Hey folks, good evening. Happy Friday. I apologize for the time drift. I apologize because there's a machine running in the background. It's supposed to be running for another 4 minutes, but it will be done by the time we get rolling. So yes, it's almost 15 minutes after start time. It's been a minute. Thank you guys for being here. Happy Friday. Hope you guys had a wonderful week. Everyone cozy up. We've got a lot. We got a lot to get through. And a whole lot of opinions on a whole lot of stuff that happened in court this week in the Karen Read trial. Hopefully I'm getting reports of staticky mic already. No, don't do that. Well, hopefully it resolves itself. We're just going to trust that it will at some point in time. Oh no, the static you're hearing isn't from the mic. I just checked the volume levels. It's not from the mic. What you're hearing is the 3D printer that's running in the background. That is what you're hearing. So hopefully that will be done within the next minute or two. And if it's not, if it's only when I talk, then I'm going to do this. No more static. We're going to eliminate the static because we're just going to keep fighting mic issues till the end of time. We're just never going to be done with it. And we're going to try that. See if that does anything and work. Now I'm very quiet. Everyone says I'm very quiet. Here we go. Better. How about now? We are going to figure this out, folks. I promise you. I'm going to yell into the microphone if I have to. Let's try that. Hopefully that boosts that volume a little bit. You know what? We're going to tweak it. We're going to tweak it along the way. We're going to figure it out. Promise you. We will figure this out. And we will absolutely get it figured out. Okay. Either way, how was your week? How's it going? How is everything? How is everyone doing? Are we on the verge of panic? Are we managing ourselves appropriately? Are we drinking enough water? Are we eating food on the regular time? Are we going to bed at a regular hour? Are we waking up at regular hours? Am I doing any of the things that I am telling you guys to do? No, I'm not. Because why would I? Because why would I absolutely do that? It has been a wild week, absolutely wild week. We are still in the middle of an office move. Well, we're moved, but now it's assembling all of the things and putting all the things into the place they need to be to have an effective and efficient law office. And one of the challenges in doing that is that lawyers, by and far, are not the most handy of individuals. Just the average number of them I've come to find in my experience. So when things need to get done around the office that involve fixing, repairing, installing, building, deconstructing, generally speaking, there's one person in the office that can do it. Kind of me. I've been doing a whole lot of stuff. A whole lot of stuff indeed. And been very busy in doing that. With the exception of my office. So tomorrow is going to be a day in the office. It will absolutely be a day working. And I'll be able to catch up on, I don't know what I'll catch up on. Probably nothing. We'll find out. It's going to be fun. So hopefully the microphone is slowly resolving itself. And working its way out. You know, I will say there was one bit of news development, and that'll be our first story. We're not going to go straight into Karen Read, guys. We're not going to go straight to Karen Read because we had one little bit of, I call it justice. Not really justice. That's kind of odd. One bit of news from the great state of South Carolina, which I think is where we're going to begin our discussion. As you guys know, we've covered a case in the past, the Alex Murdaugh case or Alec Murdaugh case. We covered it rather extensively, and we covered the aftermath of it, including the appeals, including certain conduct by a duly elected county clerk courts who authored a book, who may have used their office for personal gain, who threw parties for everyone in the office on taxpayer dollars, who authored a book. What was the title of that stupid book? Gosh. Behind the Walls of Justice? God, the mugshot is phenomenal. Behind the Doors of Justice, the Murdaugh Murders. Oddly enough, on Amazon, 3.5 stars. So those who have read it, some have had some mixed reviews. Having read a few pages of it myself, I think whoever was voting that thing 3.5 stars is, well, needs some different literature options provided to them. Because we've got news. And Courthouse Becky Hill, the Colleton County elected court clerk, has been arrested, charged, detained. We had wondered when that was going to happen, and it happened. So we don't have too many details yet because a lot of it just doesn't seem to be accessible. But we can go over what we have. And you know what? Heck, we might, as a little bit of fun, we might go back and watch some of her testimony when she was called to testify. Would that be fun? I think that would be fun. That'd be a good little sidetrack adventure, shall we say. Because, oh, baby, she was something else. So I've got the arrest warrants. Let's see. I don't want to subscribe. No, I don't want your ads. Go away, ads. I don't like you, ads. I've got the warrants. I've got some articles. Pull it up and go through it. Let's go ahead and see if we can't find a little bit of the footage of her testifying, because that's going to be kind of fun to watch. Becky Hill testimony. Oh God. You know, if you ever wonder if your devices are listening to you, pull up YouTube. Granted, I'm on YouTube, but I pull up YouTube, and without even searching for anything, without even having looked for it at all, what's the first recommended? Would you like to see information about Becky Hill charges? Why, YouTube, thank you. I would love to see that, but I'd like to actually go back and see the raw materials of the testimony at trial, or testimony at that motions hearing. So we'll go into that, and then we're going to get caught up on the Karen Reed matter, because the Karen Reed case was, we had some interesting back and forth. While the testimony might be a little bit less exciting this week, because, hey, experts are experts. I do love the fact that experts are there. We are now in week 3 of the Commonwealth's case. We're at the conclusion of week 3 of the Commonwealth's case. And I believe the Commonwealth gave us the estimate that they would be done 3 to 4 weeks. So in theory, they should be wrapping things up by now. However, I think that there's been some expansion of the scope, because I honestly don't think Hank Brennan thought he was going to be calling 1 or 2 of those witnesses, at least at the jump. I don't think he thought originally he was going to need to get into, or try to get into, any of the Ruba stuff. And I think he's there now because of how the trial has developed, and because largely the cross-examination of Yuri Buchanan. You know what? To be fair to Hank Brennan on this one, I don't think Hank Brennan expected Alan Jackson to cross-examine Yuri Buchanan for a day and a half, or what amounted to 2 days total. So it's been been pretty wild. Oh no, it's week 4. Interesting. All right, so we are now at the end of the 4th week and going into the 5th. So there's one day of court where there's nothing that happened, where the court was canceled. Judge Bev loves her half days too, so can't take those away. Then there was the jury review, and then there was jury review connect on cross-examination for a prolonged period of time. And then there was voir dire day. So I'm not going to hold that too much against Commonwealth, because when I do the math, I think I'm coming up to about 3 days of lost time. So we're good. Today was being a half day. So oh my gosh, I think I just caught myself almost saying the half, like Judge Bev, half day. This trial is wild, but I think everyone's going to develop an accent after watching it. I don't know what accent we're going to develop, but it's going to be something. It can't be nothing. So what are you guys doing? Where are you tuning in from? Please, if you are on your way in, please hit the like button. Let's see if we can get this video. I don't know what the most recent videos have been doing as far as like counts are concerned. Let's take a look and see what goal we can set for like counts. I don't know why people don't do it. Hit the like button, guys. It's not hard. You're on your way in. Just tap it. Tap it. Pretty easy. Some content is light mode, and some content is dark mode. It just blinds you. Let's see. Last Friday we were up to 3,000. So let's set a goal. We're going to set a goal. We're going to go and we're going to hit 4,000 likes tonight. That's what we're going to do. 4,000 likes tonight. Please hit the like button and please consider subscribing if you wouldn't mind. Park the car at Harvard Yard. Yeah, we all did jokes. We always did. And had a little bit of fun. Damn. So the hair is a funny story today, because I woke up with the understanding that, and oddly enough, Fairfax Courthouse, the entire county courthouse has been closed the past 2 days, physically closed. No courthouse business being done. Apparently there's an issue. There have been issues with their electronic data entry system, key card access to get in and out of the building, and the building access systems. So they have closed the entire courthouse. So I was supposed to have court today, and I figured maybe I'll be able to get a haircut. So I left the hair unkempt, no product, no nothing, just left it the way it was, in the hopes that, of course, I'm going to have 25 to 30 free minutes to get my hair cut. Absolutely, that's going to happen. It did not happen. So you guys get this. You get the tuft of really long hair that is more gray than I ever wanted it to be. But thank you for the compliment. Very much appreciated. Grim Fated, currently taking my last final of law school with you in the background. I graduate tomorrow. If that law school exam is time tested, then stop watching me immediately. If it's not time tested and you get all the time you want, take your time, hang out. Ask us one of the questions. Maybe we can, nope, I'm not going to help you cheat. But glad to have you here. Vez. Hey, Vez. Hey, Rob, I just got a promotion. Congratulations. I am now a full tenured professor. That is so cool. I am so excited. That's awesome. Now you can do anything. You can yell at students. You can scream at them and give them poor grades for no reason whatsoever. Kick them out of your classroom, and they can't do anything to you because you have tenure. Is that how that works? I don't know if that's how it works. I'm sure you would never do any of those things, but congratulations. Also had a lovely time in Washington last week. I'm very glad you did. I'm sorry we weren't able to connect. It has been chaos. Doesn't even begin to describe it. Tisha Sinba, lurking at my niece and nephew's high school graduation. You guys, watch the graduation, take the test. Watch the graduation, take the test. This will be here for Replay Crew. Replay Crew, we love you. Good to see you. Creed, so you got out of writing briefs to play with Legos. The moving look is universal. Did you see the new book, Behind the Bars of Justice? I didn't see them. I saw the cover page. I saw the cover page, Behind the Bars of Justice. We're going to review that a little bit. Shy Gal, thanks for being a member. Becoming a member. DSN, thanks for gifting a membership. Shell C, thank you for gifting 10 memberships. Very much appreciated. Just Because, thank you for gifting memberships as well. 20 gifted memberships. Reggie Edwards, thank you very much. It's very kind of you. Aaron Blackman, do you think that the appellate courts are already eyeing this case and paying attention, or is it too early? The appellate courts are too busy. I don't think the appellate courts, because they don't want to get ahead of the one. The appellate courts don't have anything unless they're presented to it. Two, the appellate courts already have a backlog of cases they're dealing with. Three, at this point in time, they'd be speculating. There's really nothing to do that. I believe there's probably a fair number of jurists that are curious in this trial, watched some of it, who have tuned in a little bit and been like, what the hell is going on here? I know a number of lawyers who have chimed in and just gone, so you watch that Karen Reed case at all? Yeah, I've been watching it. Pretty crazy, isn't it? Yeah, it's a little bit nuts. It's a little bit wild indeed. Brennan's faux indignation. Take lie to the judge with a straight face is getting old. He contradicts himself within a couple of sentences, and Auntie Bev just smiles and nods. We are going to go in to all of that argument, the judge's ruling, and we're going to breathe heavily. Just deep breaths, drink water, and hydrate. Because that there's two aspects of the past 2 days that became very frustrating to me. That whole decision making process was rather frustrating to watch. And what was worse is knowing, as the argument's being made, just getting that feeling in your gut. No, it's not that. That's totally not going to happen. And then two, the different rules that are at play when it comes to direct and cross-examination. And a curious part of me wondering whether those rules are going to continue and carry on as the defense moves into their case in chief, which for some, imagining perhaps not. We shall see. We shall see. Tracy Sires, thank you for gifting memberships. Baby Steps, thank you for gifting memberships. CSTers, did you get my email with Ghost Danny found? I have not looked at my email at least in 5 or 6 days, which is very sad, but I have not. I really have not. And I will take a look at that. What I usually do is actually, you guys remind me, I put it up during the live stream. I have it up afterwards so that as I'm decompressing after the stream, I am able to read some of this stuff. Oh, never mind. I just pulled it up. Take a look at it. Very, very interesting. Joy W. CA. Wondering if any lawyers think KR is guilty at this point. I'm sure there's some. I'm very much sure there's some prosecutors who think that she's guilty. There's people that will just have that judgment no matter what. What I've learned about this case is that you walk into it with a certain position. The way the lawyers litigate the case, the way the judge sides the case, has been ruling on the case, and the way that the commentariat, the individuals that are out there opining on the case have conveyed information, it doesn't do very much to sway you. It either stiffens your resolve, or it gets you back up and gets you pissed off and you get defensive of your position. But if you sit there and you kind of view it with an open mind, I don't know how you can apply the standard of beyond reasonable doubt and not see that. Now, I will say this. Hank Brennan made a lot of lofty promises in his opening statement about science and data, science and data, science and data. And we are now finally getting to some of that science and data. I know I don't like the way he presented this case so far. Because if you're going to say science and data, science and data, science and data, I think the cell phone data, your desire to use that data in conjunction with the accident reconstructionists, you would want those individuals testifying near in time, where the information is fresh on the mind of the jury from one expert to the next. Now, the gap in time we can speculate on. Actually, I hadn't even thought about that. We'll get to that when we get to that. Someone remind me to talk about the trial strategy and the gap in time between Ian Whiffen and the accident reconstructionist when we get to argument on this motion. So someone remind me of that, because I do want to bring that up. Brennan's faux indignation. As a prosecutor myself, I am deeply offended by the state and the court's conduct in this case. You are not alone. I'm not even a prosecutor. And I've been very, very honest with you guys about where my biases lie, my natural predispositions. I am generally always going to lean a little bit more defense. I don't know. I've tried to analyze that, and I've tried to figure out why I lean that way more and more and more. That is just my general predisposition. So I try to give you guys information with that context given to you, so that you know, as I come at this case, generally speaking, when the prosecution is presenting their case, I am looking at poking holes in it. That is what my brain is just intent on doing. So I'm listening to the information and digesting it, not towards the mind of it, those things being true building blocks of a structure that I want to exist at the end of the trial, but looking at those building blocks and really kind of testing the soundness of each one of those blocks as it's being built. I think that helps me at least analyze cases, but I don't know that a lot of people look at the cases that way. I know that some people lean heavy towards prosecution at the beginning. Oh, bad person sitting in the bad chair. Why are they in the bad chair? Because they did a bad thing. So it varies. For my purposes, I just want to be honest with you and tell you where my gut lies and where I see things going, and let you guys make the decision for yourselves. Best gun losing detective. It's been a long and fun road with you, Rob. Thanks for being a member. 33 months. Thank you. Very kind of you. It's been a long road indeed and a lot of fun. Lindsay, hi from Seattle, drinking another Red Bull. You don't want to know how many I've had today. Guessing more than 2. Probably, by that comment, maybe more than 6. To get me through assembling dressers. Oh my. Leftover pasta and not leftover wine, waiting as a reward for me when I'm done. What I have found about assembling dressers is that you can assemble those dressers with the assistance of wine, provided there's not too many steps involved and you aren't losing or using glue that has a working time of like 5 minutes. You can do it. Don't ask me how I know. Amy Fava, thanks for becoming a member. Much appreciated. All right, guys. So what do you think? Do we want to start talking? Joseph Krauske. Kraus thinks she's guilty. He was Colin Albert's attorney. Like I said, I know that. Runkle, by the way, before people start asking the chat, Runkle has an obligation early in the evening. He said he was going to try to get here later. We will be fine without him. I'm sure that when he arrives, he arrives. He has the keys to enter whenever he wishes to do, and I will end up surprised by his presence and playing buffer to his angry takes when he comes in there. So let's do this. Without further ado, let's go ahead and get to one of our first topic, our not Karen Reed topic, shall we? Let's talk about Becky. So, Becky Hill, the Colleton County elected clerk of the court. Who is Becky Hill? Becky Hill wrote a book. Let's see if we can't pull the book up, shall we? Behind the Doors of Justice. Behind the Doors of Justice. Oh no, it actually still has a Facebook. Oh my gosh, terrible. Awful. Should we start with the Amazon? Take a look at it. Yeah, let's do that. Why not? Let's share the tab. Behind the Doors of Justice, Murdoch Murders by Rebecca Becky Hill. Look at, because it's no longer being published. So look at the price tag for the hardcover. That's great. Yes, you guys are right that it was pulled, but apparently there it's now you can get it as a collectible. Um, I guess you can get it as a collectible. So, quote, from beginning to end, here is the true story of Alex Murdaugh double murder trial from a courthouse insider who witnessed it all and more. Nancy Grace, legal commentator and television journalist. Oh, that's oh my gosh. Another quote, this book is not only historically significant, it is well written and a treat. Pull up a comfortable chair and be prepared to stay there until the last page is read. Rhonda Rich, God, let the jokes flow. Well, she's going to have plenty of time to read it again and again and again and again. Quote, the inside view really gives the reader insight into what went into this trial of the century. What a brilliantly written publication, The Walker Family. Oh no, these are so awful. Oh no, how do you want to be? What if you were remembered as giving a quote or giving a little blurb or a review on this? God, it's gonna be great. Becky Hill has been. Oh, wait, what is this? No way. Oh no. Oh no, this goes on. I didn't know this was here. This is a treat. This is on the Amazon review. No way. This ends up being so much better than I thought it was going to be. Okay, so we have the little reviews, right? Then this is part of the what's put in here for the sales of the book. Becky Hill. Oh God, this is phenomenal. Becky Hill has been villainized by Alex Murdaugh's attorneys in the press, and they've made serious allegations of jury tampering against Ms. Hill. Thousands of words in Behind the Doors of Justice are dedicated to the 18 men and women who served on the jury or who were alternates. Read what Becky said that's caused such a stir. Just remember, just because a lawyer says it's so doesn't mean it is. A once prestigious lawyer on trial, raised in the low county country of South Carolina, Hampton County. A look at the Murdaugh murders trial through the eyes of Rebecca Becky Hill, the clerk of court, with 40 plus exclusive photos. Oh, crap. Exclusive photos. Oh. She explained her extensive role. Yeah, that's an understatement. That has caused such controversy with amazing visitors and courtroom personnel she met along the way. Rebecca Becky Hill had known the Murdaugh family for decades. Family members of Becky's were involved in the moonshine conspiracy together in the 1950s, where Buster Murdaugh was later indicted and then acquitted. For years, Becky had known about the rumors of corruption and crime surrounding the Murdaugh family. These accusations came and went, nothing sticking long enough to bring clarity or a clear conviction. Oh my God. I can't read this with a straight face. Becky had also known of good deeds done by the Murdaughs. She was there when Randolph Murdaugh received the Order of the Palmetto, the highest honor bestowed on a civilian by the governor of South Carolina. What she didn't know was that Richard Alexander Alex Murdaugh was capable of murdering his own wife and son. Serving as the clerk of court at the time of the trial, Becky Hill was present in the courtroom in the case of the state of South Carolina versus Richard Alexander Murdaugh trial and beyond. Join her on her journey, which is still continuing, as she visits the crime scene. Oh, God. Shares heartfelt details about the judge and people involved, navigates the massive media frenzy unsuccessfully, delves into her own family's history with the Murdaughs, and ultimately reads the guilty verdicts on live television. The verdicts that would put Alex Murdaugh away for 2 life sentences with no possibility of parole. Oh, this is so bad. It is so much worse. It is so much worse when you read this. So, we're caught up with a little bit here. Let's go ahead. Oh, there's the back. Oh, that's a lovely photograph. What a lovely photograph of Becky Hill. Let's see. Look at that. Wonderful. Lovely, lovely photograph. So let's go back through some of her testimony here. So we have direct. We're gonna get into. We're not gonna do all of it. Let's just watch a little bit. Creighton Waters. Oh no.
And could you tell the court what that was, please?
I was a South Carolina official court reporter for about 14 years.
All right. And were you, in being an official court reporter, you had served in the courtroom, which is Ms. Harris is here today, is that correct?
That's
what
correct.
Was your, all right. And was that primarily in the 14th Circuit?
It was primarily in the 14th Circuit. However, I did travel throughout the state.
All right. Did you?
Hold up. The bail hearing was televised? Oh, we're going there. We're going to watch a little bit of this one first.
Have any other experience in professional experience prior to becoming a court reporter or clerk of court?
I was a court reporter freelance for 2 years before that.
Okay. And then any other professional pursuits you've had over the course of your career?
I was able to be a middle school teacher, and I worked for the Board of Disabilities for a few years as well.
Let me go ahead and just kind of get straight to it. In your capacity as clerk of court and in your previous experience being a court reporter, were you familiar with the rules that apply to court staff as it comes to interactions with jurors during the course of a criminal trial or a civil trial for that matter?
Yes.
All right. And could you tell the court generally what those rules are as far as what contact is permissible and what contact is not permissible, just very quickly?
The judge gives the law and gives the instructions for a jury, and the attorneys will state their opening argument, their opening statements, their closing arguments, and basically the clerk of court and anyone else, court reporter, we're there to, my understanding would be to make sure that everyone's taken care of. Do you need some Kleenex? Do you need some water? Different things like that, just to make sure that they're taken care of.
Is it common for clerks of court to have interaction with jurors during the course of a trial to see to those various logistical needs that you just described?
Yes.
Oh, Creighton. I miss Creighton Waters. Oh, where is he these days? What's he doing? I miss Creighton. Oh, God. Oh, it's phenomenal. This is a trip down memory lane. This is phenomenal. This is great. God, I love this.
And did that happen in the Murdoch case?
It did.
And can you give us an example of some of the logistical things that you or other things that you would see to deal with any needs that the jurors may have? I mean, did you provide them food, coffee, make sure they were comfortable, things like that?
Yes, all of that.
All right. Provide blankets for them if they were cold?
Our courtroom was very cold in Colleton County, yes.
Did you provide them with aspirin or Tylenol if they needed, make sure coffee and snacks were available?
Yes.
Did you take lunch orders for them so that they were fed each day?
Yes.
Let's fast forward a little bit.
During the time that you were on the property, traveling there, traveling back, did you have any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
No, no.
How compound was that fucking question? Sorry. Whoa. All right. Maybe I don't miss Creighton as much as I thought I did. That was worse than a lolly question.
Jury view.
I was.
All right. And was Judge Newman there as well?
He was.
During the time that you were on the property, traveling there, traveling back, did you have any...
All right, so there's three parts of the question. On the property, traveling there, traveling back. So there's three elements of a compound question.
Any conversation with the jurors where you made any comment about the substance of any testimony or any comment about the merits or the strength of the case?
Conversations with jurors. Now we have two different parts of where you made a comment about the merits or you made a comment about the other communications.
No.
Did you have a quick comment to the forelady about how the property was beautiful and there were tea olive trees there?
He's trying so hard. He's trying so hard to make it not look bad.
that bloom and smell good, or words to that effect?
I did.
All right. And was there any other conversation related that you had where you made any comment about the case or the merits or anything like that?
Oh, no, no.
All right, Creighton, let's see what Poot does on cross.
Breaks, correct?
Correct.
So we have no animosity towards each other. You didn't do something to me, and I didn't do something to you during that trial, right?
Absolutely.
Okay. Now, given that, I'm going to ask you some questions today that may indicate to you that I have some antagonism towards you. Let me disabuse you of that. I'm here.
Let me translate for Dick Harpootlian. For those of you who have not met Dick Harpootlian or had the pleasure of watching him do examinations, he's much like, I don't know how I would describe Poot. Fine whiskey that you've had way too many of. It means that, starts off, pretty good. But then you've had so many of them that you can't see straight. You don't know what you're saying anymore. You're lost. And it just tastes like you're drinking some same old shit you've been drinking the whole time.
Doing a job representing my client. And you've been around the court system for decades, correct?
Yes, sir.
So you understand what we're doing here today.
Yes.
Now, let me understand a couple of things. I think, and I've read your book, some editions of your book. There's several. We got a bunch of emails in which you have drafts that you forwarded to your co-author, correct?
Correct.
Objection. I would object to relevance. I believe any draft she sent to her co-author with the book is beyond the scope of this inquiry here today.
Overruled. You may proceed.
Thank you, Your Honor. And in those drafts, you say certain things about the trial, about the process, which you later did not include in the final version. It's called editing, is that correct?
I would agree with that.
Okay.
Would you accept that parlance? Ms. Hill, would you accept that parlance editing if I were to give you that? Are we on the same page as far as that parlance? This is putting me in such a better mood. Such a better mood.
Now, let's talk about this book for just a second. When did you first decide you were going to write a book?
I think a thought was there, a very fleeting thought, before the trial.
Did you take any steps before the trial or at the initiation of the trial to begin writing this book or working with somebody on this book?
Oh, no, sir.
When did you and your co-author get together?
It was several weeks after the trial.
Okay. Did you talk to anybody about the fact you were going to write a book before the trial?
There were several anchors and several journalists that I did speak with about the possibility of writing a book.
How's that for a random? It's the word
So
salad.
disorganized, I apologize. Did you seek assistance in this trial from other clerks of court?
Yes, sir, I did.
And who were they?
Rhonda McElveen, who is the Barnwell County Clerk of Court, and Renee Elvis from the Horry County Clerk of Court.
And were they there with you the entire 6 weeks?
No.
I mean, how long were they there? Or how often were they there?
Rhonda McElveen was there as often as she could be, probably several times a week. Renee Elvis helped me during the jury selection.
Now, wait. I want to get to the
The
compensation
one,
part.
can they hear what's going on in the other one?
No.
Adamantly, I think was the word you used, that he was guilty, that he had killed his wife and son. Is that what you put in the book?
I can't remember if I put that in the book, but if you say I did, then I will
Did
agree
that
with
happen?
you. We did have a conversation about what each of us thought,
And all four agreed that he was guilty, correct?
and none of us were jurors.
No, trust me, I know that. But you had an abiding conviction, at least by the time of the Moselle visit, that he was guilty. And the other people in the car with you were bailiffs, were they not?
No.
Who were they?
Some were not bailiffs. One was a court reporter, one was our security officer, head security, and another was a deputy sheriff.
Okay. But the four of y'all rode out there, and based on what, and I mean, I can, you want me to read to you how chilled you were and how you felt that poor Paul and Maggie had been executed by him on that scene, that visiting the scene convinced you that he was a horrible, horrible murderer? You want me to read that to you, or you will concede that's what you wrote?
I will concede that's what I wrote, but if I may, I would say that a lot of that is poetic license in writing a book and in making it sound like that.
Okay, so some of it's poetic license, and some of it you just stole. You purloined it from that BBC writer, right?
Your Honor, again, I object to not only the relevance, but the scope of cross. I would object also under Rule 608. I don't believe that's appropriate cross-examination.
Overruled. You may continue, Mr. Harpootlian.
Did you steal part of the book?
I did plagiarize,
Okay,
Mr.
so
Hartfield.
that's stealing, isn't it?
And it is, and for
Okay.
that I'm very sorry, and I have apologized.
Okay. And that makes it okay?
What I did, and I apologized for that.
Okay. And part of the book is, you say, literary license, exaggeration?
I wouldn't call it exaggeration.
Okay.
Wait,
Now, let me ask you
wait,
this.
Wait, I would call it poetic God, pause game on point tonight. I wouldn't call it poetic license. I wouldn't call it exaggeration. Are we really gonna parse those words?
Switzerland, and this is, you're saying this is happening while you're supposed to be Switzerland. You decided the defendant's guilty, and if Ms. McElmeen says that it's going to make you more money if he's found guilty, don't you think it's reasonable to assume that you may have crossed the line from time to time?
Your Honor, I object to the form of the question, assuming facts not in evidence.
Overruled.
Can you repeat that question one more time,
I'm
Mr.
not going to repeat
Hartfield?
it. Let me just move on to something else.
He doesn't remember the question.
Let me ask you, you had interactions with some jurors, and I believe in a conference in the judges' chambers, you indicated that you had seen a post on, is it Walterboro Word of Mouth?
Your Honor, again, I object. I think he's delving now into the Facebook inquiry. We believe, again, that that's irrelevant to the inquiry before Your Honor.
I will allow a limited, he's, as I understand it, trying to impeach our testimony and explore her credibility. And I think I've already told Mr. Harpootlian that I don't want a whole trial about the business of Facebook and the egg juror, but I will allow limited examination on this point. You may proceed.
My God, we need another trial in the South. Oh, we need another trial in the South. Is it just me, or are these accents at least they're more tolerable to me? And look, if you're from Massachusetts, I have no problem with you at all. I am just so not used to that accent that it especially when Hank Brennan is doing, I have trouble with it. But the jurors.
Mr. Harpootlian.
Am I oversimplifying that? I mean, it's in your book. You
Say it or no.
saw something on Walterboro Word of Mouth, which appeared to you to be from the ex-husband of one of your jurors. Is that correct? Am I oversimplifying that?
Let's do this.
I
I think we
You
get
just said you.
because the substance of the arrest was more dealing with other stuff. So let's just fast forward a little bit because I think this is
And You just get to where you kind of see things happen as they progress, and it's a guess, it's a gut feeling, and that's all that I meant by that.
Well, why are you telling this young man who wanted passes for the next day in an email, it won't be happening tomorrow? That was or did you say, you didn't say, I don't think, you just said, you better come today if you're coming. Remember doing that?
I don't remember that. But, if he wanted to come, I knew that the trial would be ending shortly as far as testimony. So if he wanted to come, he needed to come.
Why wouldn't the jury have been out a week on a 6-week trial?
They could have.
But
They could have.
you apparently were telling the press.
Oh, I got another good pause on it. Harpootlian. I'm sorry, what is the screen name? Ouch, Rob, but even I agree. I hold no harm against anyone from Massachusetts. I'm just not used to that accent. So to me, it throws me off. And then you hear that accent, and then you hear like the Brennan version of that accent, and you hear it a lot, and you just, Like I can do Judge Bev's like, we're doing a half day. I can do that. That I'm fine with. But the ACCA witnesses, which is different. And that's okay. That's fine.
Yes, and others that would be a quick verdict. Were you not?
That was just a gut feeling that I had,
Okay.
and that was my opinion.
Okay. Your opinion, you were right. Jury was out 3 hours on a 6-week trial, correct?
That's true.
How much money did you make off that book?
There was not a whole lot of money made off of it.
Oh no. How much money did you make off of that book? Now we're getting to some of the money stuff.
The book, after paying different things and paying for some expenses that went along with that, but I want to say roughly around $100,000.
Okay. That's not a lot of money.
No, especially when you publish your own book
But that was $100,000 you made.
with my co-author.
Okay. In what period of time? 6 months?
I would say 6 months, yes.
When was the book published?
August 1st.
Okay. The trial was over. That's 6 months after the trial's over, you've published a book, correct?
Correct.
And then I believe you've recently stopped selling the book because of the plagiarism you've admitted to, correct?
Correct.
And so there's no more money?
Correct.
Now, you also indicate in the book that the Murdaughs had a reputation of criminality, I think, is kindly what you put. Did you not?
Well, Mr. Harpootlian and my grandfather and Old Man Buster were very close.
Well, were they criminals?
I wouldn't know.
You wouldn't know. But you believed and you published that the Murdaugh family had run that part of the state and they'd participated in criminal conduct, correct?
Your Honor, again, I would object to general testimony about the alleged criminality of this family. I'm not sure how that has any bearing on the focused inquiry before the court.
He's asking about what she said in the book. I'm going to allow it.
Yes, sir. Did you say that in the book, that they were criminals?
In the book, that was more of the literary ease that we take.
Excuse me. You do not get literary ease in a book to call someone a criminal if they are not in fact a criminal. That's not poetic license. That's a fucking lie. Oh no, this is so terrible. All of this is giving such great context. Oh my God, I'm so glad I'm doing this. Oh, I needed this so badly.
I think to make a story a little more interesting for the reader.
By calling people criminals. I guess what I'm saying is this. Were they criminals?
Your Honor, again, I object to that particular question.
Overruled.
Were they criminals?
I wouldn't know that.
Okay, so you either made it up or you're lying about it? About the reputation of people that can't defend themselves? They're dead? You're going to call them criminals? You did that in the book so you could sell a book?
No, I didn't do that to sell a book.
What'd you do it for? Made it more readable, you said? Which sells books?
Literary ease. Yeah.
What?
Literary,
Literary what?
the literary ease.
It's just the smile. It's the smile. It's the answering these questions with a shit-eating grin pasted on her face like it's not a fucking problem. It is amazing to me. The easiest thing in the world for her to do is just to look right at Dick Harpootlian and smile, and then just blame everything on literary license, and no, I wasn't making money, and no, money wasn't the issue or the goal.
That you can take when writing a book.
Literary ease you can take with writing a book? You can make stuff up? You can lie? You can lie about people?
Not with that. I think the public perception was one that it was very interesting during this time.
So you're
And
feeding the monster out there that wants to believe bad things about the Murdaughs, and you'll make stuff up to do it. Let me give you another example. I read your book, and I found this somewhat humorous. My co-counsel did not. In describing myself and Mr. Griffin, in the book you say that I neutered him. We've both been very interested in what you meant by that. What do you mean by neutering Jim Griffin?
Mr. Harpootlian, it was a book.
Did you make it up? I know it was a book. The
Right.
Bible's a book.
Right.
Just because it's a book doesn't mean you can lie in it.
It's just a word that was used.
Nature of that exchange.
Don't argue with the witness, but the witness, Ms. Hill, you're instructed to answer his questions. You may proceed, Mr. Harpootlian.
So let me get this straight. The book, and I'll see if I can cut to the chase on this. I could read you chapter after chapter, verse after verse, which is not true. Okay? Not true based on my experience of being in a courtroom, and not true based on knowing some of the people you described. You say that is...
Mr. Harpootlian.
I object. The counsel's just testifying right now as to his observations about the book.
Question, Mr. Harpootlian, please.
You have conceded there are things in the books that you don't know to be true, correct?
Correct.
Okay. You would concede then that you have lied in the book.
It's only because I wasn't there at the time. I can't interview my dead grandfather. I can't interview Mr. Buster. There's just things that we can't interview them on. We can go by what was written in a newspaper and get facts from that.
And take the inference that one of the Murdaughs was a pedophile. You could have printed that, and they're not here to contradict it. You could have printed anything you wanted and made it up to sell books. That's what this whole scheme was about, selling books. As you told Rhonda McElveen, if him being found guilty would sell more books.
Your Honor,
Isn't that true?
I'd object to the argumentative nature of the question, the compound question, and assuming facts not
It is a
evidence.
compound question. If what you're asking is what she told...
Creighton finally hit the right fucking objection. Of all the ones he could have gone with, every question Harpootlian has asked has been remarkably compound. Like, there's been like 7 questions in each question. And he wins on the compound question. God, you just keep trying.
Ms. McElveen, go on and ask that, but don't precede it with
Yes, Your Honor.
testimony.
Beg the court's indulgence for just a moment.
Indulge away, Dick Harpootlian. Indulge away. Let's see. When it gets to Judge Toll's, I think her ruling, let's see, 70. So, Justice Toll. I think Justice Toll then begins asking questions.
The judge brought up another thing right after sentencing that I want to explore with you briefly. One of the big responsibilities of the clerk of court is to take control of the exhibits that are presented in court. Isn't that correct?
Yes, ma'am.
And there were sealed exhibits.
Yes, Justice Toll used to be the Chief Justice of the Supreme Court of South Carolina, from my recollection. I think the first woman serving that position. She was no bullshit. I would love to be in front of her. I just loved it. I would love to.
Presented in this case that were photographs of the two decedents at Moselle when the law enforcement authorities first investigated the murders. You recall that?
Yes, ma'am.
And those photographs were sealed by the judge, were they not?
Correct.
And when the testimony about them was completed, they were under your control as the clerk of court, were they not?
That's correct.
How was it that those photographs came into public view?
Are you talking about after the...
I'm talking about...
Now, this testimony is directly relevant. So everyone pay very close attention to what Justice Toll has just picked up on. Really glad that I caught this little bit of questioning here. And it wasn't Dick. It wasn't Harpootlian. Listen to the questions. What did she pick up on?
Came into public view.
Are you talking about after...
Several sealed photographs. So sealed exhibits. Exhibits go into the possession of the court clerk. You've seen this happen in the Karen Reed case. The clerk is the one that marks it. Clerk takes possession of it. Clerk is responsible for maintaining that exhibit and making sure it makes it into the damn court file. Certain exhibits are sealed, which means that no one can access or see those exhibits. Once they are sealed, they are deemed closed off, verboten, unless and until a judge orders that you are allowed to see them directly or lifts the seal. Several exhibits in this particular trial, because of their very graphic nature, were sealed. Photographs that were displayed in open court but sealed. Actually, they actually angled the photos towards the jury box, from my recollection, so that the gallery or a majority of the gallery couldn't see them. Oddly enough, there were photographs of those exhibits that somehow ended up out in the public view. How the hell did that happen? And one of the charges that Becky Hill faces is directly related to this. So I believe Becky Hill had an attorney at this point in time. There might have been several settings in this particular trial or this particular hearing where learned counsel or a wiser clerk would have advised, or the wiser clerk would have invoked their Fifth Amendment privilege against, providing any testimony or statements that might be incriminating in nature.
I'm talking about the fact he alluded to it on sentencing and said that he was frustrated about it and was going to try to look into it. Those photographs that were sealed court exhibits under your control found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from a screen that had some of the pictures on it, if I'm remembering correctly.
That was about as good as the deepest Judge Bev sigh I think we could have ever seen. Oh my God. Oh, I would have paid good money, to be in front of this judge. Oh, that was so worth the price of admission.
Did you?
Hang on, let's do this again.
Found their way into the public media, did they not?
I believe they did. And I think what happened, it was someone from the gallery took a picture from
Ready?
a screen
Look at the
that
screen.
had some of the pictures on it, if I'm remembering correctly.
Did you ever allow anyone?
Oh, she is. If you ever want to know what the face of someone who's not buying your bullshit is. Oh, that was fucking phenomenal. That made me so happy. I'll take that over a Judge Bev sigh any fucking day.
From the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
How did you handle exhibits? Because you did have the press have great access to the exhibits. And you say several times in your book that you had to stay after to be sure that you interacted with the press about these exhibits. That's true, is it not?
That is true. We had Mr. J. Bender, and then we had the pool photographers and someone from maybe the state, I believe, or the Post and Courier, along with the court reporters, someone from court administration, and then someone from the clerk's office every night that would go over the exhibits to make sure everything was correct and within our domain.
Were any press people ever allowed to view the exhibits, even the sealed exhibits that you had on file?
No, ma'am. No, ma'am.
Bullshit.
What was the methodology for allowing them to examine the exhibits? How'd you handle that?
I wasn't there a whole lot when we did this every night, but it's my understanding that the people that were involved with the exhibits, and especially the court reporters, and there was a certain time frame that they were allowed to take their pictures, and everything was, all of the pictures were looked at by the court reporters that were there, and the lady from court administration, along with someone from my office and Mr. J. Bender, to make sure that everything was done correctly.
What I'm asking is how you handled having them, the press, view these exhibits.
If I remember correctly,
You don't, Becky, you don't remember correctly. You don't. And that's the problem. You've started 3 sentences with, if I remember correctly.
press, we had certain designated photographers, and then someone, I think, from the state or the Post and Courier, and they were responsible for putting it out on a stream for the rest of the media to
And would they
access.
do that by photographing the exhibits as they were in your possession after court was over that day?
That is correct.
All right. And how did you handle the sealed exhibits in terms of their availability when these press people are there photographing exhibits?
They stayed sealed.
That's a really cool word.
And so you think that you're aware of the fact that some of these on the scene photographs of.
I love that she says they stayed sealed. Do you guys really think that there's a big old seal that says sealed that we put on top of the photographs? Is that how we think that that's covered? Like that we just put a big old seal on top of it? Especially if it's a larger photograph.
The two decedents found their way into the public press. You're aware of that, are you not?
Yes, ma'am, I am, yes.
And you contend that they photographed them in the courtroom?
That is what I heard.
How'd they get a straight shot of the exhibit?
All right?
God, that was almost better than the first one. Wait, hang on. That was almost better than the first one. Hang on.
That is what I heard.
They photographed him in the courtroom?
That is what I heard.
1, 2, 3, 4, 5, 6.
All right? Finally, you have indicated about your book that some things that you put in there were, you called it literary license, not literally true, correct?
Correct.
Did you ever, by any kind of email communication or in any way, shape, or form, indicate or state that you wanted a guilty verdict because it would increase the sales of the book? Did you ever say that in an email or verbally or in any other way?
No, ma'am, I did not. It didn't matter to me if it was guilty, not guilty, or a mistrial.
Oh, yes. Right there. There's the screen grab. That's the photo, everyone. That has to be the photo. That has to be it, right? This just pairs so well. Like, just the photo, just the pursed lips and the slight tilt of the head. I'm going to leave that screenshot exactly where it is, right where it is. That's exactly where we're going to leave it, because we're going to go to this. For those of you, it's going to get a little bit bright because it's going to get a little bright. Okay. Warning ahead of time. So reporting by the AP, Associated Press. Oh, look at that photo. He's even better. Oh my gosh. The AP beat me to it. No, you know what? What's better? I think the screen grab. I don't know. I like the screen grab. But that one's good too. The whole I'm swearing under oath. Columbia, South Carolina. Shall I read this in the Southern Virginian accent? The Virginian, the former court clerk in South Carolina, who helped with the trial of attorney Alex Murdaugh, powerful, wealthy lawyer, convicted of killing his wife and son, showed sealed court exhibits to a reporter and then lied about it. Authorities said on Wednesday. In all, former Colleton County Clerk of Court Becky Hill was arrested on 4 charges. She faces obstruction of justice and perjury for showing a reporter photographs that were sealed court exhibits and then lying about it, according to court documents. Sealed exhibits are only for viewing by the jury, lawyers in the case and court workers. She also faces 2 counts of misconduct in office for taking bonuses and promoting through her public office a book she wrote on the trial. Hill, 57, was released on bail after court appearances in Colleton County and Richland County. The lawyers did not immediately respond to a message seeking comment. She lives here. She turned herself in. We found out about these charges last night, Hill's attorney Will Lewis said during her appearance in Colleton County Court, according to a live stream of the hearing by WCIV TV. Hill was charged. No, hang on. Back up. Y'all are killing me. Hill was in charge of taking care of the jury, overseeing exhibits, and helping the judge during Murdaugh's 6-week trial in 2023 when he was convicted of killing his wife and younger son. Murdaugh's appealing his conviction. Is this going to do anything for the appeal? No. This is all after the fact conduct. Let's see. Initial appeal was denied. Judge Dean Toll said that she wasn't sure if Hill told the truth. Yeah, right. Attracted by the siren call of celebrity. And then we went straight to the commentary. Did you allow anyone from the press to view the sealed exhibits? Okay. One of the charges, this was the other one that we knew that SLED was investigating at the time. Misconduct in office involves money that investigators said Hill took for herself. They said that included nearly 10,000 meant for bonuses from federal money meant to improve child support collection. Wow. Let me reread that. Said that included nearly $10,000 meant for bonuses from federal money meant to improve child support collection, and about $2,000 in money from the clerk of the court's office. Let's take a look at the warrants. Shall we? Let's do it. Here are the warrants. South Carolina State Law Enforcement Division, SLED. 2 counts of misconduct in office, charged with perjury, obstructing justice, and 2 counts of misconduct in office. Details can be found in the attached warrants. So let's see the warrant details, shall we? Description of the offense. Let's zoom in on this one. Let's see, zoom. Mary Rebecca Hill. All right. So this is the perjury charge. That in Richland County, South Carolina, on or about January 29, 2024, Mary Rebecca Hill, being the elected clerk of court for the Colleton County, did willfully and unlawfully give false, misleading, or incomplete testimony while under oath in a court of record. That would be intentionally so they're charging with perjury in front of Judge Toll. January 29, 2024. Yeah, oddly enough, but January 28th was the 29th, because it would have been 29th, right? In Karen Reed case, 29th, 12:38 a.m., something like that, or later, who knows? Life lesson, don't do things on January 29th, especially testifying in court, apparently. So this is related to, this is literally the question. Did you allow anyone from the press to view the sealed exhibits? And Hill responded, no, ma'am. This statement was inconsistent with the events of February 28, 2023, when former Clerk Hill did release or make available, quote, sealed evidence, end quote, photographs to a third party or parties. Ooh. Geez. She would have been well advised not to respond to that question and to invoke her privilege, because perjury is one of the charges. Awesome. Well played. Obstructing justice. That in Colleton County, South Carolina, on or about February 28, 2023, Mary Rebecca Hill, being the elected clerk of court of Colleton County, did unlawfully commit an act which prevented, obstructed, impeded, hindered, or potentially impeded or hindered the administration of justice, to wit, while preserving evidence during the course of the General Sessions murder trial of Alexander Murdaugh, did release or make available, quote, sealed evidence photographs to a third party or parties, such act occurring in violation of a written court order issued to protect the sealed evidence photographs, in violation of the law of the state of South Carolina. And then the last one, misconduct in office. That in Colleton County, South Carolina, on or about June 7, 2023, Mary Rebecca Hill, being the elected clerk of court, did willfully, dishonestly, and unlawfully breach her duty and accountability to the public as imposed by law by failing to properly and faithfully discharge said duty, to wit. Hill did promote a book in which she was an author, Behind the Doors of Justice, The Murdaugh Murders, while using her public office to promote the aforesaid book on social media, such act being for her own financial gain and in violation of her duties, in violation of the laws of the state of South Carolina. And then finally, the fourth charge, misconduct in office. That in Colleton County, on or about September 1st of 2021 through March 5th of 2024, Mary Rebecca Hill, being the elected clerk of court, did willfully, dishonestly, and unlawfully breach her duty of accountability to the public as imposed by law by failing to properly and faithfully discharge said duty, to wit. Hill requested and then received $9,880.10 in financial bonuses for herself that were paid from the Title IX-D incentive funds. So she paid herself the bonus that was to be directed to those individuals who had successfully been collecting child support. Lovely. Such funds were obtained by Hill and utilized for her own financial gain. Furthermore, on March 5th, 2024, Hill received a financial gift and or bonus in the amount of $2,000 paid by a check from the Colleton County Clerk of the Court's office funds and utilized for her own financial gain in violation of her duties and further in violation of the laws of the state of South Carolina. Oh, that is a golden update. Very few cases where I will be leaning for the prosecution. This might be one of them because of how egregious the conduct was. And because of the fact that it was documented in her own email, which if you're a public official, your emails are public. You can get them. The public can get them. Allowed to see them. Maybe don't put your criming in your emails. Don't do it. Also, the clerk's office performs clerical tasks. One of those clerical tasks, generally speaking, is pretty damn good bookkeeping. One of the jobs. So maybe don't ask the clerk of the court to cut you a check for $9,880.10 as a bonus when you were not eligible for that money. Just hypothetically, maybe we don't do that. God, that was so. Oh, sorry for the distraction. Actually, I don't apologize for that one. Everyone needs that. We all needed that contact. You know what? We all needed that. Every one of us needed that. I'm going to screenshot this. I have to. I have to also. Hang on. Can't screenshot. Okay, so we screenshotted that one. Becky. Then let's go ahead and see if we can't find the mugshot. There is a. Oh no. I just typed in Becky mugshot like that was going to magically give me this mugshot. And let's see. So we went from. Why did that not do that properly? No, I needed this. We went from this to this. This to this. That's what we did. Why do you want to go to that big giant boat? I hate that. Bond hearings are pretty boring. I can't imagine we're gonna. Let me just take a. I'm gonna take a look at it and see if it's even worth pulling out because I don't want to waste too much time. God only knows. We have a lot to cover. It's detention center. It's a Zoom hearing. ABC News has it. She bonds out. So, not the most exciting. Let's get through some of the chats and we can get caught up on some of the new case. Well, not new case. But, oh, and just as I finished Courthouse Becky, Ian appears.
1 second.
I'll pull you down. Down. And pull himself back on.
There we go. I didn't pull me down. You pulled me down, but you pulled me in the first place.
Pulled you down. I pulled you down. Pulled you down. Please tell me you were watching some of that. Please tell me you were.
I just got here. Which one are you looking at there?
I'm looking at the testimony provided by this lovely individual.
Oh. You might have to play that again.
Justice Toll asking the question.
Mm-hmm.
Yeah, you guys, I hear it. I hear the volume. My volume, when Ian jumped in, my volume reset to like a set volume and not.
Did I break everything?
Nah, you're fine. My mic's just being my mic, just not behaving nicely to. Which, you know, is par for the course. Par for the course, right? We're used to this. Oh. So, actually, I think I have. So one of the charges that she faced, or one of the charges she's facing, rather, is.
I'm too loud, I'm seeing.
No, I think it's fine. I adjusted myself.
Okay. Hopefully we're good.
One of the charges she's facing is in direct relation to these questions. And I've got spinning wheel. Let's see.
Just to horrify Rob.
No, ma'am.
Oh, it's this one. This one.
Someone from the gallery took a picture from a screen that had.
This is about the sharing of the photos, the sealed photographs. That's one of the charges.
Ah.
Some of the pictures on it, if I'm remembering correctly.
Did you ever allow anyone from the press to view these sealed exhibits?
No, ma'am.
Did you allow Netflix to ever examine the exhibits for trial?
No, ma'am.
How did you handle exhibits? Because you did have the press have great access to the exhibits, and you say several times in your book that you had to stay after to be sure that you interacted with the press about these exhibits. That's true, is it not?
That is true. We had Mr. Jay Bender, and then we had the pool photographers and someone from maybe the.
Yeah, it's the. All right. So that's the charge. Charge is related
Also,
to.
Can I just say how awesome it is that Justice Toll is like, because the lawyers ask, a bunch of questions, and then Justice Toll is like, no, I have questions. And then after she's done, it's like Justice Toll's questions that lead ultimately, I think, to the perjury charge.
They are directly quoted in the arrest warrant. It is. Did you give access to the press for these sealed photographs? No, ma'am. That is directly quoted in the arrest warrant.
Wow. So, yeah, Justice Toll basically hunted her for sport.
And that was the question, by the way, that she asked, where Justice Toll just pauses and just long pause. All right. It was phenomenal. But wow. I got to catch up on some of the chats so we can get to some of the Karen Reed stuff, because I know that you're probably hot and mad about some of that.
Oh, yes.
Yeah.
Sean, I have opinions.
I have some too. Usually I'm more quiet about my opinions.
Sean, this is true, but this is also not true. The problem is that you can't write for shit.
It's true. We before you jumped on, we started this adventure by actually reading the foreword and all the above to the book on Amazon. It was quite the adventure. I very much needed this break from the Karen Reed cover. Like the Karen Reed stuff, which is depressing me and frustrating me and making me angry, both in the way questions were being asked and everything else. I needed this little distraction.
Well, how about this? Let's play a little game. I'm wondering if you can identify this quote. Mr. Runkle, turn on your, or Mr. Runkle, turn on your camera.
Identify that quote.
Yeah. Who said that?
Mr. Runkle, turn on your camera. When was this? Was this in the case that you dropped in on in what's her name?
This was earlier today.
Oh. Were you at appearance observing another hearing?
I was.
What hearing were you observing?
I was observing Janet.
Oh my.
And,
please tell me about this. Hang on. Can we pause? Because I know there's gonna be questions flying. I want to catch up. Let me get the Becky Hill super chats out of the way.
Sounds good. And the chat
Splashdown
called
CA. Splashdown CA doubt direct from the bench, hidden from the jurors. I don't know if that was Karen Reeder or if that was this. Paralegal Liz, I'll be covering her case as I did on January 24th. Good. I can't wait. When you cover that, you had to let me know, because this is it's going to plead out. There's no way that she lets this go to trial. There's no way.
Going to trial.
Do you really think so? Just with the obstruction charges and what the obstruction carries?
I think they're going to say, like, if you want to plead this out, you've got to eat a whole pile of crap on it. And I think she's going to, want to
fight it.
To fight it.
This is good. Becky, best of luck. Best of luck to you. Best of luck. Ashley, I'm going to save this for later. Can you talk about how you become a hostile witness? I will talk about that at a later point when it becomes relevant in the context of Karen Reed. Catlin Shute, long week of paperwork to register 17 athletes for Special Olympics Summer Games. First year as head coach, stressed, nervous, excited, time to enjoy FNF. Good luck to you. I mean it. I love the Special Olympics registration. And it is so cool what you're doing. My apologies. I didn't mean to cut you off.
Oh, no worries. It's just, that's a group that is incredibly badass. So
that's really cool. Lynn Britton, just a reminder, Rob, on civil loans, the book. I know he's read various passages of it. Jurors, Justice Toll. She also gave herself a bonus with county funds. Yep, that's in there. KLB, purloined from the generosity of chat. Hunk, Brennan's fave forensic homeopath, Kim G. Member for 10 months. Sit down, Creighton. Get her, Poot. Everyone in the chat was going, why am I rooting for Poot right now? It was the chance, change of pace from Karen Reed. It was a needed change of pace from Karen Reed.
Karen Reed is anger inducing. So we'll look at some stuff that isn't Karen Reed. But yeah.
I started this because I've seen this question a million times. Is Murdoch getting any trial depending on if she's found guilty of obstruction of justice? No. This is all after the fact stuff. On all these charges that are related to. Now, here's the thing. If the investigation, no, I don't even think so, because they had an opportunity to kind of do their own inquiry of her. This is not going to impact his. I don't think so.
It should.
Now, the original, here's the thing. The original argument being made that should have been thrown out based on influence of the jury, that has been appealed up. That case, that appeal could change. But this disposition, this conviction for these charges, maybe the investigation uncovers more, but I don't think so.
We'll have to see. I am just, I'm just like, this is so wild that this went from, she is the court clerk to she is the accused. Like, when does that ever happen?
Better shoes did not fit. Geraldine Friedrich, why can the judge ask a question? Bench trial. In bench trials, the judge is allowed to ask questions because the judge is the finder of fact. The judge can jump in and ask whatever damn question they want. I had a trial the other day where the judge, various judges will be hot benches, and it gets kind of frustrating sometimes. Sometimes the judge does you favors. Sometimes the judge does not do you favors.
That's different from where I am, because where I am, just because it's a bench trial doesn't mean that the judge necessarily, they can ask some questions, but they're very limited in terms of like what and how they can ask.
The rule is they're allowed to ask clarifying questions. That is kind of the scope that they're bound by here. Like if they don't understand an answer, if they need additional clarity, or if they want to hear you clear up a question they think the lawyer asked.
Here, both sides kind of agreed to let Justice Toll let her play. And
let me tell you,
she went to town.
do you think you're going to have the balls to stand up and tell Justice Toll to stop?
Well, the thing is, I don't think either side actually wanted her to stop.
No, they didn't.
Because from the prosecution side, they're really just sitting there kind of going, well, we want to actually see where this goes, right? We want to actually know what went down. And from the defense side, they're like, because the prosecution basically never argued that she didn't, that she wasn't like messing with things. They just said he still would have gotten convicted. It's so I don't think anybody ever argued that she was like an innocent in this, except for her. Except
for her, she didn't do that very effectively. Cindy Collins, pregnant, emotional, but happy to be here. Glad you're here. Take care of that baby. Hopefully a new warm smile in the near future. Analytical Barney, thank you for gifting memberships. Kristen M96, Poot is writing a book about Pee Wee Gaskins. He was a prosecutor at the time. Pee Wee was a serial killer in South Carolina between the 50s and 80s. Very different to simply write a book about what you did than to take your public office and your office and go out and market yourself as like during the trial to get the book written.
As like, hey, I'm a specially available source. And if you scratch my back, I'll scratch your back. That's kind of where things go really
while the trial is going on.
Yeah.
Restore justice. Pay Alex's commissary for life. God. Hoping all Sparkle Farts in St. Louis, Missouri are safe. I hope so too. It's been crazy weather here in the States. Light Queen, thanks for gifting memberships. Minnie Busy, thanks for becoming a member. Creed, Becky went from sweet lady to retired FBI agent coffin diver real quick. Hello, Ian. Motion to name your Becky Hill video Behind the Bars of Justice. The memes that are coming out of this are unquestionably phenomenal.
Oh, top shelf. Like,
because they write themselves.
Yep.
Troublemaker Baker, thanks for becoming a member. Carolyn Knight, so happy to see you too. Happy Friday to you. Best way to end a week, Robin Ian on one screen. Thank you very much, Jet J. Holly's Hobbies, how's the back, Runkle? How is the back, sir?
Pretty awful, but you know, we just it's one of those things where it's just like, well, you just got to do what you got to do, because if I start worrying too much about how much my back sucks, I will never get anything done. So
I know
you're the other sad thing about weather is that there are fire bans everywhere. And me and Mrs. Runkle are going out to the
property.
And it would be nice to have like a campfire and roast some weenies and so forth. And it's like, nope. Government just doesn't want forest fires.
Hank Brennan will be on screen shortly. You can roast weenies there.
I mean, that is a fair description of him.
AG, happy Friday, hard week. 16-year-old kitty diagnosed with aggressive liver cancer. Oh, no, I'm sorry.
Oh.
Follow up next week. Please check out the case I sent you at some point in time soon. I'd really make my week while I'm struggling through this. I will, AG. Thank you. And I hope you're doing okay. I hope that next week is not the most struggling week. Hopefully, kitty recovers. Mark Breenan's fave forensic homeopath. Worst judge y'all have ever practiced in front of.
I'm not naming any names.
Not naming any names.
Sure. Actually, maybe I could, because the worst judge I've ever practiced in front of is he got removed from being a judge. I won't name names, but after a certain age, you as a judge, they have to renew your appointment. And usually the renewal of the appointment is fairly straightforward. In this guy's case, it was they're like, nope. And it's like,
hard pass.
What do you mean no? And he's like, nope, we're not doing that. So yeah, he is not a judge no more.
Yeah,
And
the one that I'm thinking of is no longer sitting either. I'm still not going to walk that plank. It's just
yeah,
there's really no good outcome at the end of that one. Not naming them.
yeah, no, that's a good way to get in some difficulties.
Stories de-identified. Said judge imposed costs. Oh, this is good. When a spouse is incarcerated during the time of a divorce case and while the divorce is pending, let's say that the spouse goes away to jail or to prison for 20 plus years, something like that, right? And you want to get divorced. In order to get divorced, the spouse is considered to be an unavailable party. So a comité is appointed. It's like a guardian ad litem. And the comité
He's just making up words, people.
But the comité is actually paid for, generally speaking, by the party who requests the appointment, unless there are incidents where the incarceration is because of an act that they did against the person that requests it. So the spouse, like if the husband commits an act of abuse and that's what put him away, the state pays the cost of having the lawyer for the husband in the divorce case.
Reasonable,
right? So
yeah, I got no beef with that. That seems like it makes makes some practical sense to me.
My client was asking for a divorce from a person who was incarcerated, and the person was incarcerated based on consolidated charges. There were 4 different charges: threatening to bomb and burn a building, the building that she was occupying, assault and battery, attempted arson,
Against her.
Against the building that she was in, again, because she threatened to bomb and burn the building of a workplace and then the house. Those are the charges. I feel
like those two things are like kind of affect her in a practical matter.
Just wait. Those are the charges that she was convicted of. So we go through the entire case, and at the end, I'm asking that the state be made responsible for the charges by the guardian ad litem / comité. The GAL in this point in time is now a sitting judge. I love this judge and the GAL at the time. He was very reasonable. And he actually asked and joined in my request that the state be made to pay his fees. Well, guess what charge he had pled to in the consolidated plea agreement? Which charge did he plead to?
All of the ones that don't affect your client directly.
It was threatening to bomb and burn the building of the workplace. And
then it's
that was what he accepted the plea to, and therefore this judge imposed costs on my client because the sentence he was serving was not related to a crime that was committed against her. Notwithstanding that it was I was in a full courtroom, a full courtroom of lawyers when this was being said, a full courtroom, and
Big
the number, the murmurs, the number of people in the back of the courtroom that were like, how the hell is threatening to bomb and burn the building that this person is in? Not wow. So what did the GAL do? He waived all his fees. He said, I was like, yeah. That's my story.
I think that person is awesome, honestly. So, yeah. Props to that person.
Aaron Blackman. There's a whole playlist on my channel of me following the Maya series. I did recaps of the entire trial.
He was a machine.
If so, is it common for lawyers to have a falling out like that? After a big case, it is not common. And actually, if you go and look at Peter, lawyer, he and I do an episode where we talk about some of that out. I don't really like going through it a whole lot because it's just unfortunate for Maya Kowalski to be in that situation, but that's weird.
Yeah, that is a sad case.
I'm going to save... Oh, wait. Feral Dragon. Becky's alleged sins include perjury, liberating child support payments made to the court, wiretapping. Who knew South Carolina and Massachusetts had so much in common? I feel like that's something there. I'm going to save the rest of these. Wait, what? I just read the private chat, Sandy. Are you kidding me? I'm going to save the rest of these. Please, please, please. Tell us about how that Janet proceeding went. I need to hear it in great detail.
So the proceeding itself is kind of minor. The issue that they were
I'm still
talking
here, just
about,
keep on.
yeah, I figure you're still here, just like changing or something. Um, now chat is gonna get spicy. The issue is fairly minor. Basically, she discharged one lawyer and she hired a different lawyer. And that lawyer is like, I want money, I want fees. And she's like, yeah, you had a time limit to ask for that. And that is, that was like within 3 months and it's now 5 months. So y'all can get effed. And the thing is if she's correct, then kind of Team Janet on that one. Lawyer should have gotten off his ass if that's correct. But anyway, and I know that's not really a thing that I said I would say a whole lot, but yeah. But anyway, that the judge is just like, okay, you can brief that would be good. But at the beginning of the hearing, like I log in and I don't have my camera on because like I just logged in. And Janet is like, Mr. Runkle, turn your camera on. And the judge is like, court is not in session.
Wait,
like,
Janet was the one saying it?
Janet was the one saying it.
Are you fucking kidding me? As if she was running the court?
Well, and it gets even funnier. So after the hearing ends, I wasn't sure if there was going to be something else, but they're like, okay, we're out of open court. So I turned my camera off and I had earbuds in. And I went and walked into another room to go do something because I was like, okay. And what I didn't realize is that the judge was going to be like, if you need to leave, right? Everybody needs to get out of the Zoom court. And so I was like literally outside when the judge said that. So I'm like, oh, and I come walking back towards the thing. And Janet goes, because, earbuds, Janet goes, I'm just waiting so I can get the time that Mr. Runkle leaves. And the judge is like, you don't run this court.
Wow.
So I get back and I hear the judge saying, I'm just noting for the record that I'm going to remove both. And I'm like, leave.
Yeah,
I'm like, I'm trying to follow what the judge is telling me to do. But I was just like, okay. All right. That's how we're doing this, I guess. So,
okay.
Yeah, she's got some big mad.
She's really not a fan.
No, she's got some thoughts, and apparently I am like very much rent free in her head. Oh wow, Snow Maven. Hey everyone, currently in labor and delivery, waiting for baby boy to make his grand entrance.
That was you've got more important things to focus on.
Yeah,
like the labor and delivery part. You abbreviated the thing that's the most important that you should be focusing on.
Those seem important to me.
Mm-hmm. That was what I was like, oh my God, Sandy. Yeah, because no, Snow Maven. Focus on the labor and delivery. And we will celebrate the baby new boy and all of the things when the baby boy is born. But focus on the labor and delivery.
Yeah, those are the important bits.
Yes, please do that. Okay. Yeah. All right. Let's do this. We're gonna swoop and we're gonna go to we're gonna go to Karen Reed. Where would you like to start? And I ask this sincerely because there's a lot
Let me explain. No, there's too much. Let me sum up.
Because in terms of testimony, we did not have the most exciting. I know you covered. So Dr. Scortibello, who I personally love Dr. Scortibello. I thought she's credible. I think she's solid. I think she and Alessi were there was a lovely gamesmanship going on there where they're kind of going back and forth on language. Alessi basically saying, I know the language, so don't try to fuck with me. And Scorty Bella going, I know the language too. I'm not gonna just agree with you. I mean, it was good. And I honestly,
a fun little back and forth.
It was. And I think at the end of the day, the Commonwealth's case was, they got the hypothermia stuff. I think that was the most important part, because the rest of it really wasn't the most significant. But I think that ended up being a win for the defense more than anything else, because of the beginning of the testimony, where you had the back and forth exchange between Alessi and Dr. Scortibello of, you would agree that a neurologist is not capable of doing an autopsy, or you would agree that they're not the proper person to do an autopsy. I was fine. It was good. I thought Alessi got a little hung up in some of the cross. I think he came back and cleaned it up a little bit.
Overall, I don't think it was really a massive point swing for anybody.
No, I call it net even. Prosecution got something, defense got something. So I'm good there. I was confused with some of the stuff about the picture, who was there during the autopsy. Is that Michael Proctor? And then today's stipulation that was read out that it was not in fact Michael Proctor. It was Walker, name we have not heard yet.
Some other person. So I'm guessing the Commonwealth just was able to prove, like, to defense's satisfaction that it was not Proctor. And then it was like, okay.
I mean, I will say that what Scortibello really did for me, though, was very much solidify a feeling that I have been developing about Hank Brennan. A nauseating feeling, uncomfortable feeling, a feeling like, what the fuck is going on? And it's his redirects that I have now grown to disdain because they are so improper. Well, let's do this. Let me give an example. I know you covered this last night, but it's going to be very brief.
Brennan really gives the feeling as if you're bobbing for apples, and then like midway through, a condom floats by.
I don't know if it's that feeling. I think it might be worse. I don't know how it'd be worse than that, but it might be. Hello. It's the redirect that has been driving me insane in all of these witnesses by Hank Brennan. Share screen. Let's see. So actually, this is great because we'll get to the redirect of Scortibello, and I think we'll get to the argument made on this motion, which will then get us to the ruling on it today, which was, I mean, it was something. Let's see, are we at redirect yet?
Miss McCabe.
Okay. So, bringing you guys up to speed on why I'm focusing on this point. Alessi, in cross-examination. So, cross-examination versus direct examination. Cross-examination, you are allowed to lead. You are supposed to lead. You have to lead. You are required to lead. Generally speaking, the judge, not required to. Generally,
but the judge may, like, give you some shit if you're not, because they're like, hey, are we going to be done this year?
Yeah. If you are asking open-ended questions in cross-examination, save for one or two where you really want to make the point by asking an open-ended question because the witness is an idiot and you just want to let him talk, you are leading. You are asking very pointed questions. With expert witnesses, there's a very specific rule that you're allowed to pose hypotheticals to the expert because you're allowed to challenge the facts in the case as you wish them to be or as you see them. Not simply the facts that have been adduced at trial. You are allowed to go further. You're allowed to take that expert and you're allowed to try to make that expert yours or make a point through that expert. You're allowed to pose hypotheticals to poke holes in that expert's conclusions, their findings, their logic. They are an expert. They're to assist the jury. They are not a fact witness. They are an expert witness. Scortibello is both. She is a fact witness and an expert witness. So you are allowed to challenge her medical opinions. And you're allowed to challenge the medical opinions by posing hypotheticals to her that are speculative in nature, that don't have to be well-founded in facts already presented at trial. You're allowed to say, would your opinion have changed or would your opinion be different if, and then list different facts. list things that you
Would your
intend
opinion
to
be
adduce at
different
trial.
if, John O'Keefe was a unicorn, or
Yeah. You're
maybe not
allowed to
that
do
far?
this. Now, what frustrated me about this, and I started to get the gist that, and I was watching a little bit of Andrea while she was covering this, is that Massachusetts' rule on experts is rather specific. That the expert testimony is not, the general rule is when you're an expert, you're allowed to testify to things that are hearsay. You're not testifying to the truth of those things, but you're testifying in the sense that
I base my opinion on this.
Yes, your conclusions are
even
based
though
on
it might not be super or it might not be admissible, otherwise. But I mean, and for the chat, this makes sense.
Yeah.
Right. The expert isn't going on the police investigation, but they can say, I based my opinion on it's like, why did you conclude this guy was shot? Well, he had a hole in him, but also I, heard from the officer that this guy was witnessed, shooting this guy by 30 people. That was relevant to me.
Yes. You're allowed to go further than simply things that would be admissible in court. Now, apparently Massachusetts' rule is a little bit more narrow, and they place an additional burden where the expert, technically speaking, isn't supposed to testify to things that are hearsay or have an absence of foundation or for which there's another evidentiary objection that you cannot get admitted, which puts you in a very, very odd situation where the expert is somehow allowed to give their opinion, but then not allowed to testify to the foundation of that opinion if the foundation of that opinion is based on hearsay or something that's kept out of court.
We have that as well, but it's for if it's like actually inadmissible. So let's say that, the expert bases their opinion on the fact that the guy confessed.
I was just about to say confession getting thrown out.
After like 12 hours of being beaten with a hose. It's like, yes, the guy confessed, but at the end of the day, we have some reasons for that. And, maybe that confession isn't super valuable. The expert wouldn't be able to testify as the hose beating, the hose beating confession. They'd be like, nope.
And when you think about how the rule is founded in allowing the expert to go beyond the evidence and to go to hearsay and go to that kind of stuff, it actually makes sense. And it puts the lawyers in a position where the lawyers are allowed to challenge the expert. And you really are relying on the adversarial process in getting the proper result. A good lawyer facing an expert that's properly prepped, that's going to be relying on hearsay, is allowed to ask a hypothetical that challenges that hearsay's conclusion and tries to get the expert to reach a different outcome, a different opinion. So in allowing the expert that leeway to testify to hearsay or to rely on hearsay and to repeat that hearsay on which they relied as a foundation of their opinion allows for both the jury to hear it, and if the jury discredits it, the jury can also discredit the opinion. So that's the bonus. If the jury hears that the expert relied on hearsay and the jury doesn't believe what was said by Jen McCabe, then that's fine. You want the jury to hear that. But it also puts the opposing counsel in a position where they can give their own hypothetical to the expert and say, so let's say that Jen McCabe didn't say this. Would you have reached the same conclusion? You get to have that play out to the jury. So you actually get a better result, a result that's kind of more founded in fact, and it's more informative to the jury. Now, let's say you place a gag on that and you don't allow for even that level of inquiry, or you don't allow for the witness to testify what level of weight they gave that bit of information they had. Well, then how do you trust the veracity of the opinion? How is the jury supposed to know that this opinion should be given a lot of weight or a little bit of weight? Because you can't challenge it. So I think this rule is fundamentally flawed. And that is without getting into how that rule gets applied. During cross-examination by Mr. Alessi, that rule was rather strictly applied. Alessi was foreclosed in asking any number of hypotheticals about Trooper Proctor, the source of information that Scorty Bella relied on, hearsay statements that might have helped assist or sway her in one direction or the other. This is a very big contrast to how Scorty Bella was handled in the first trial. In the first trial...
This feels like watching a soccer match where one side, their goal is the full soccer goal. And the other side, their goal is they've taken a basketball hoop and they've put it on its side. And so you got to kick it through the little basketball hoop. And I'm going, you know, she's the judge seems to have her finger on the scale.
It was this examination really bothered me because you had Alessi asking what I perceived to be completely proper hypotheticals, and I could not see a basis for that objection. Let's put it this way. If I had opposing counsel asking those questions in my case, I wouldn't have even bothered to stand up.
No,
because
well, and I
proper.
actually would have expected that if I did stand up, that the judge would have yelled at me.
Yeah. And it was one of those things where Alessi was stopped in asking all of these questions. And a lot of it seemed to be that Judge Cannoni was relying on, there was no foundation because the witness said, no, I was not aware of that, or I did not know. And therefore asking the next hypothetical was improper. But that itself is ridiculous. You have to be able to challenge the veracity of the opinion by the expert. Would it have changed your opinion if XYZ? So it frustrated me. But at that point in time, I'm going, all right, well, if you can't get it in and the conclusion is what it is, I don't really have a problem with the conclusion. Go with that. Enter Hank Brennan. And I was going, wait, I thought the rule was there was a rule. We were following the rule and I understood the rule. At least I thought I did. But now the rule is just not the rule anymore.
The rule only works for one side. The other side, one side has to follow the rules. The other side gets to play Calvin ball.
And here's the thing. To anyone that is very much on the Karen is guilty camp, if you can articulate to me, please, I'm asking you sincerely, if you can articulate to me the rule on which, or how that rule being applied was applied evenly to both parties with the sets of questions being asked, I'd beg for you to do that. Please play the questions side by side and tell me how that applies evenly and equally to both sides and how the judge evenly applied it. It drove me insane. So that brings us here. Hank Brennan's redirect.
Do you remember Attorney Alessi read you that part of your statement?
Yes.
Do you remember that you had
it was
more
this
to that
part.
statement that was left off when he could?
And this is the other part. Hank Brennan does not know how not to lead witnesses.
Well, and
Yeah.
this is basically, isn't it true that your testimony at a previous proceeding was way better
different.
for me? So I want to impeach my own witness with a prior consistent statement.
You can't do that.
No. Well, you can if you're Judge Cannoni's favorite.
Yeah. Debbie J, thank you for the generous tribute. I will bring this up when we get to that. I really will. Okay. Please hang on. Thank you for the very generous. I want to bring it up in context. But this is something that judges get wrong all the damn time. All the time. And lawyers do too. So you go direct examination, non-leading questions. Cross-examination, leading questions. Redirect. The prosecutor's role does not change simply because they are redirecting after you have asked questions. Prosecutors still can't lead and redirect. The number of judges that I see get this wrong, by the way, is pretty shocking. Where the judge will look at me and say, well, Mr. Morton, it's redirect. Judge, look at the rules.
Redirect has the same rules.
It's the same rules. Look at the rules. Oh, I'm gonna let him lead. Why? No, you're not allowed to. You are not allowed to ask leading questions.
It's like, okay, Judge, if you really like appeals.
Confronted you with it.
I'm sure there's more to this.
To complete your statement, you said, but in the whole context,
This was
I
so
believe
stupid.
that those are signs of
So
hypothermia
stupid.
and not caused. Do you remember that completion to your statement?
Sustained, you can show her the statement.
Okay.
No, we can't show her the
I can
statement.
Yeah. You don't get to rehab a witness and assist them with their own self-corroborating or self-assisting. I mean, imagine if you had the defendant up there and Karen Reed testified in open court and says, well, I might have sideswiped it. I don't get to walk up to Karen Reed as her own attorney and then walk up to her and say, so Karen, do you remember giving testimony under oath where you said, and then have her read where she said, like, I did not hit him. I don't get to do that. You can't do that. It's improper. Yeah.
Ask you to take a look at part of your grand jury testimony. Do you remember Attorney Alisi reading part of your answer back?
Objection, Your Honor.
So I'll strike that. Have the witness look at it and go from there.
She doesn't actually understand the issue is the problem here.
Yeah. This ends up being a problem with a lot of his witnesses. And I'm going to play the DNA witness today. Oh, it was great. Lolly steps in it with a question. And I think a lot of people missed it.
The thing is like, this is so insane that they're getting away with this. And you can hear Alessi losing his mind.
Yeah, because Brennan is trying to get in a full out-of-court statement for the truth of that statement when it's self-serving. It's not a statement against interest. There's no exception to the hearsay rule that allows this in. This is evidentiary no. It's trial no. This is not allowed. You can't do this in redirect. And for people that are like criticizing, well, the defense does, the rules are different. And they're different. They are different when the defense is offering their case in chief. They are different when you are the one that's offering the evidence than when you're the one that's combating the evidence. You have to treat it differently.
Mechanical cooling.
Sustained.
Oh, this one,
Where there was
mechanical.
cooling. Mechanical cooling.
Sustained. Move on, Mr. Brennan.
You were shown a photograph, a chalk that had spots on them. Do you know where that photograph came from?
I do not.
Do you know who that was from, what person that was from?
No, I do not know the context of that picture.
Do you have any information on the circumstances which led to that condition?
I do not.
Do you have any information about what caused the condition that you saw on that chalk?
I have seen similar pictures in textbooks depicting gastric hemorrhages or Wisniewski spots.
You were asked about your role as a medical examiner, and there were a number of questions about your assessment from a legal perspective.
Yes.
You mentioned that you had information from a police report. How many police reports were you given?
There was a preliminary police report, I believe, the day of the autopsy, and communications with law enforcement in the days and weeks following.
Yeah.
All right. Now, here's the point where, based on the court's ruling during my cross-examination, if I'm Alessi, based on the court's ruling during my cross, I am scooting forward in my chair because I feel like he's allowed to get rid of that. He's allowed to ask that question, but I know where he's going. So I'm scooting forward in my chair and I'm going, I'm going to do the same thing that he did during my cross.
And it won't matter.
And I'll be able to stop the line of questioning.
So you think that, but
Showing you a document. Do you recognize that document?
This is a police report on this particular case.
Is that a police report from your file?
Yes.
And that police report, is that the police report that you considered?
Amongst other information, yes.
How many lines is that police report?
Lines.
11.
What's the date and time of that police report?
This was initiated on January 29th. It says at 1941.
I have this marked for identification, all right?
Okay.
Oh, sorry, I may have that down. Thank you. May I approach her on?
Yes.
Second document, was that another document in your file?
Yes,
And is that another report that you considered?
yes,
How many lines is that report?
5.
I'd move to have this marked for identification, please.
Okay.
Thank you.
Exhibit RR for identification.
May I approach again?
Yes.
I'm going to go back to the questions I asked you about logging in and refreshing your memory. I'm going to hand you a document. I'm not going to ask you to read it aloud. I'm just going to ask you to look at it.
This is proper. This is being good lawyer. This is good. This is you refresh your memory. Did you rely on this? Yes, I relied on this. Informing your opinion. This is fine. No problem here.
Who attended the autopsy?
Yes.
And who were they?
I believe one person was Mr. Keefe and the other one was Mr. Corner.
That was weird. I didn't know Mr. Corner.
Are you part of the criminal investigation team?
No, I am not.
Did you go to the scene and evaluate any evidence?
No, I did not.
Did you do any of your own detective work or investigation in this case?
No, I did not.
So when you were asked questions about your role as the medical examiner in your medical evaluation of Mr. O'Keefe's body, you were also asked whether you considered any part of the legal aspect. Do you remember those questions?
Here we go.
Yes.
You were never, oh, let me ask you.
Yeah, he was about to
You
lead, and then he's like, wait a
submitted
minute.
the death certificate on April 14th.
Correct.
I want to talk about some of the things that you may or may not have known about or considered.
Okay. So right off the bat, may not have known about. You cannot challenge your own expert. So this is a distinction between when you are offering an expert and when the other side is offering an expert. When I am offering an expert, I cannot challenge that expert with giving them magical hypotheticals that they didn't rely on. I can't, that's impeaching them. I cannot impeach my own expert. I cannot go after my expert and say, did you know this? Did you know this? Did you know this? Did you know this? I can't do that.
Unless you're in Judge Cannone's court and you are Brennan.
It's improper impeachment. This is your witness. This is your damn expert. You don't get to cross him. Then there's this things that you did not know. Well, if she didn't know, it didn't form the basis of her opinion. And the question is inherently improper because it's suggesting something outside of her opinion.
At the time you wrote your death certificate or filed your death certificate. Were you?
Oh, here's something I will agree with. Yes, he's a defense attorney by trade, very different role. And when he gets, the other thing is when he gets objections sustained against him for leading, he needs to adjust. And these objections should be coming and they should be more free. And I cannot imagine a world where the judge has not said, Mr. Brennan, you cannot lead these witnesses. But when you're saying to me, Brady Goat, that I'm saying I would do the same, if a judge let me get away with leading a witness and I couldn't lead the witness, if a judge let me get away with it, I would absolutely do it because it gives an advantage to my client. And that's my damn job. So,
But you're not the prosecution. And that's
I'm
an
not.
important distinction here because the prosecution has no client.
It's true.
The prosecution is supposed to be representing, justice, not going for a win. So, and this is a fundamentally important thing that they teach prosecutors is like,
Lead.
you can't you don't have a side. You know, you are the prosecutor, but you're not like, you know, you're not here to score wins. You're here to, you know, or I mean, the other way to put it, one friend of mine who's a prosecutor, you know, I was like, I asked him, did you win today? He says, you know, I'm just here to do like justice. We win every day. He's like, when I get a ruling against me, it's still a win because I'm not here to get convictions. I'm here to get fair trials.
Right result.
Yeah, just, you know, I'm here for fair trials. And so long as we got a fair trial, it's a win.
People ask me what your win record is as a family law attorney, and I'm like, there's no such thing as we're losing.
Yeah.
No such thing. But it's the same thing. And going back to one of the questions about the prosecutor being different, the prosecutor's role is different in the idea that I did see comments about you guys are understanding that he's just not he's a defense lawyer by trade. I see this with civil litigators that try to practice in family law, and they come in and they ask, they don't know how to do it. They just don't know how to do it. They will ask like an open-ended question of a witness that's a family member, and all of a sudden an hour later and they're like, okay, and they forget where they left off because they don't know how to examine families. You have to hold the individual accountable to the standard that they are expected to rise to. I can't change the rules because this person happens to have been a defense lawyer. I can't change the rule because they happen to have been a civil litigator when I'm in family court. You can't hold them to a different standard when the expectation is that they will act and comport themselves in accordance with the standard of a prosecutor or of a different litigator. Yeah.
I mean, Canada actually, you know, we apply this in some criminal trials and so forth. Let's say you are charged with being careless with, I don't know, explosives. You were playing with explosives and they went off, and you're like, and your defense is, I didn't know what I was doing. Like, I'm not a bomb guy. I just, you know, happened to find some explosives and thought they'd be fun. That's not a defense, because the court will be like, yeah, if you want to play with bombs, you have to actually know what the hell you're doing. You can't just go, I was an idiot, and that's fine. You have to actually, like, if you're going to do that, you got to actually be good at it. So, same thing with this. If you're going to step into the role of prosecutor, and if you can't turn off the defense lawyer brain, then you need to not do that thing, right?
Or
you need
at
to,
the very least, the judge needs to sustain
well, and the judge
objections.
needs to be reining him in.
Yes, that's the judge's job. The judge is to rein in the damn lawyers. Judges to make sure that the theater of the courtroom doesn't become too theatrical and actually maintains courtroom decorum. Their job.
Yep.
But so back to this, which is the cross-examination.
You informed, or were you aware that before you filed your death certificate, there was information in the investigation that police spoke to a first responder by the name of Timothy Nuttall, who reported that the defendant...
I'm going to allow it.
Exactly contradictory to how every one of those questions was ruled on by Alessi. 100% in direct conflict to how that ruling went when Mr. Alessi was asking the question.
Well, it's because it should be being ruled on based on principle.
If the rule is that you cannot get into inadmissible hearsay or things that were said out of court, and you can't go into parts of the investigation for which there is no foundation, you cannot do that. And here's the other problem. If Judge Cannoni is applying because this is my other thought, maybe Judge Cannoni is applying the rule of, well, Flametti or his statements are already in evidence. So it's not technically relying on hearsay because the jury has already heard his testimony. And if that's the way the judge is ruling with an expert, you got to be out of your fucking mind. No way. No way. You mean to say that I can only impeach that expert based on information that's already in evidence? No. That is a fundamental misunderstanding of how experts are used in court.
I feel like fundamental misunderstanding is her nickname.
I think it should be on the fucking placard on the top of the bench. It is asinine. And it's not just this one. It's not just this question.
That the defendant said, I hit him, I hit him, I hit him. Were you aware of that
I became aware of it at some point.
during your 90-day window?
I believe so.
Were you aware that there was another first responder by the name of McLaughlin who provided information that the defendant said, I hit him, I hit him, I hit him, I hit him?
Yes.
Were you aware of statements made by the defendant, to Miss McCabe, that she said, may have I hit him? Did I?
He is relying on the argument that's in evidence already. That's what he's staking his claim to. Because he rephrased that question. He didn't say, were you aware the defendant made the statements? He actually went back to say, were you aware that McCabe? Okay.
I hit him?
Judge, may we approach, please, briefly?
Okay. Thank you.
And this is, it's...
Objection, Your Honor. Are you high?
It is, if it's in evidence, well, it's not, you can't do that with an expert. Experts testify to things that are not yet in evidence. I mean, this is...
So, jurors, I want to let you know that, like other evidence that was let in previously, this is not coming in for the truth of what's in the statements. It's coming in so...
And this part is even worse, because where was the admonishment and where was Alessi allowed to ask those fucking questions during his cross? Right?
Yeah.
And yes, Ian, you and I and every other lawyer in the whole world knows the whole, you are not supposed to consider this for the truth of the matter asserted, but instead for the impression it leaves on the listener or some other, or the investigation. We all know. Can't unring a bell.
Yeah, I mean, the thing is they're just reading this over and over and over in front of the jury. That's the whole point.
But this was astounding to me. It was and Alessi had asked to approach during his cross and was denied the opportunity to approach. Move along from this. And someone in the chat asked, does that leave an impression on the jury? Yes, it does. When the jury has seen that every time that you have an objection or an issue that you want to discuss, and the jury is allowing one of the parties to approach and discuss their issues at will, and the other one has to clear a certain fucking hurdle before going there.
Oh, I mean, the jury can pick up that the judge likes one side over the other. Like 100% the jury can pick that up.
Debbie J, are her rulings normal? Seems to me not.
Nothing in this is normal.
Nothing is normal. So, for example, a judge is not supposed to say, I will allow that. Let me tell you why. The judge is supposed to say overruled or sustained. The reason why the judge is supposed to say those two words, overruled or sustained, is because it doesn't give an opinion or offer a way that information should be interpreted. You hear overruled or sustained, you don't hear anything else. You are not supposed to view that more favorably, less favorably, with skepticism, without skepticism. You're supposed to either ignore it or listen to it, right? When a judge says, I'm going to allow that, what that conveys to the jury is it conveys to the jury that the judge has viewed this information with skepticism. And after the skeptical view of it, they said, no, perhaps it just passes muster.
Yeah.
This is a big problem. And it's been consistent, and it really frustrates me. And there's really no way that you can tell the judge, don't do this. You can make an argument, you can try to make the argument, but the judge is going to keep doing what they're going to do. I'll allow it.
Yeah.
Or can you answer the question? The can you answer the question is less offensive to me.
Sometimes she'll be like, well, the thing is the can you answer the question sometimes is like actively putting her hands on the scale in the sense that she should just say, this is the question. Because can you answer the question is giving the witness an explicit out. And you're not supposed to give the witness like, hey, here's an out. If the witness can't remember, it's up to the witness to say. If the witness doesn't know, it's up to the witness to say. It's not up to the judge to give the, can you answer that? And then they can just go, no. And then she goes, move along.
That's what I was going to say. Let's put this in a context that everyone can understand really easily. Let's say that you're cross-examining one of your children and you have them in a bind and they have given you that face where it's like, oh shit, I'm caught. I don't know what to do. And you have them and there's the open-ended question that they have not yet answered. And you're sitting there looking at them and their sweat beating down their face. And all of a sudden the other parent comes in and says, well, did you really do that? And it's like, I don't remember.
Then,
or it says, did you remember doing that? That's what it is. It gives them the out and it teaches. It is a leading question almost inherently because it offers the off ramp. Just like Ian said, it offers the excuse. And I'm going to be very clear. I would be just as pissed off at this type of behavior if it was a defense witness versus prosecution witness. And when she does this to defense witnesses, I will call it out too. It is not fair.
The problem is she doesn't do it evenly, like at all. I mean, well, the problem is that it's not proper, but if you've got a judge who's just making a bad ruling, but is consistent about it, then it's like, okay, the judge is misapplying the law. When you've got a judge who's making a bad ruling and is unable to be consistent about it, and it's not even like that. Sometimes you get a judge where their rulings are basically like rando whatever, right? You never know what they're going to say, right? They'll, it's like, okay, I don't know what this, you object and you don't know if the judge is going to grant it or not because it has nothing to do with whether it's a good objection. It's just, what did the judge have for breakfast? But it's a very different scenario when you've got this situation where it's like, you never know what the judge is going to do because you do know what the judge is going to do. It's, that the judge is going to rule based on what side you're on.
Well,
and that's a problem.
I know. And let me go back to the whole, I'll allow it. Let me put it this way. There is a fundamental difference between I'll allow it and I'm going to allow this. And if you're telling me that you're too much of an idiot to understand how those two things are different, if an objection is made and if the judge shoots back, I'm going to allow this. That immediately leaves in the mind of the jury that the objection was made, it was argued, it's without merit at this point in time, and the judge wants us to hear these things. That's how it feels. That's how it sounds. That is how everyone would take that.
And the judge is supposed to get as, like, in front of a jury, the judge is supposed to convey as little of that as possible. If the judge really thinks that one side is screwing up, you're still not supposed to tell the jury that, right? That because ultimately the jury's the one who gets to decide what evidence they believe. Not the judge. Never the judge, right? It's the jury who decides what. And I mean, the jury can decide that they believe something that is like, they could decide that they think, Karen Reed did it by like hiring, by like turning into a space alien. And, like jury can do all sorts of weird things. I'm being, of course, overly, ridiculous here, but the jury doesn't have to accept the theory of the defense or the Commonwealth. The jury can, in fact, come up with their own theory and say, we think that's what happened.
Yeah. So when Judge Bev does this, this is probably, I think, some of the most egregious behavior. And the thing is, we've become so used to it because that's how she's ruled consistently in this case. And because we've become so used to it, we're not talking about it as much as we should be. This type of behavior, this type of demeanor, this type of conduct when you are ruling on objections is entirely improper. It is absolutely improper. Especially in a bench trial, I would understand it. In a bench trial, she's the one making the decision. She's the finder of fact. When she says, I'll allow it, and with that skepticism, it doesn't matter because she's the one she's trying to convince.
Yeah.
In front of a jury that is not privy to the back and forth of what's going on, that has no understanding of the basis of the objection, has just heard the question. And
she says, she says, you can't even say objection like hearsay.
Leading.
Speculative. She says that's too much for the jury to hear.
Foundation.
But then she's like, I'll allow it. And do we, this better, like, what was the comment about, like, this better be the last sidebar or something? I was like,
oh my God.
Are you fucking kidding me?
No, it's not just the last sidebar. That part pissed me off so much because before this trial started, what did I say? If she starts being really with the objections, what would I start doing? I would start asking for a sidebar every time to put my fucking objection on the record. You do not get to tell me.
And it's what they literally said, Judge, we are going to have to do this. Like, if you don't let us, just say objection, like, objection stupid. That isn't a valid objection, by the by, but, it would be funny. Then we're going to have sidebars all the time. It's going to slow things down. They warned her specifically that was going to be an issue. And now she's like, oh, well, things aren't going fast enough because there's too many sidebars. Fuck you. That's your problem.
So let me articulate in one or two words what my objection is. If you do that, then I will ask for far fewer sidebars because I won't need to explain the fucking objection anymore.
Yeah.
Like this is, unless you start doing that, unless you start allowing me to articulate my objection and state it on the record with specificity that would suffice for the Court of Appeals, then you don't get to tell me that I don't get to approach. You sit there on your chair and you allow me to make my fucking record. And I'm sorry, but you have to. And when Yannetti did it, that was one time when Yannetti, who drives me nuts with how many times he picks issues or points with, he makes everything into a fight. But when Yannetti forced the sidebar, I was like, good for you. Good for you. Absolutely.
For the people in the chat who don't practice, if you don't put your objections on record, they can be waived.
It never existed.
Or appeal.
Yeah,
they just,
it's poof.
And I mean, I have had appeal cases where you get it, and the lawyer who ran it, because wasn't me, gives up on an objection. And because they gave up on the objection, I can't argue it at the appeal.
Oh,
it was waived.
Here's a good one. This is one of my favorites, and we'll move on for this in a second. This is one of my favorites. I'm training new associates right now, right? So I'm training new associates, and one of my associates asked me a question. Can they what? Yes,
can they sit?
They can sit. They can stand. One of them is actually very, very eager to be in court. One's very eager to be in court, and I'm having to do like the little gentle tug on the reins, like be like, you're. I know you want to start handling motions. I'm going to let you handle motions, but I'm going to tug you back a little bit because you're still making a couple rookie mistakes that I need to teach you how to not make. One of those mistakes is this, and it's very common for young practitioners, even for skilled practitioners. Objection. And the judge sustains the objection, right? Let's say that the lawyer goes back and asks, let's say the judge, after a long back and forth, overrules the objection, okay? And then the witness says, I'm sorry, can you repeat the question? And the lawyer repeats the question. If you do not object again, even though we all heard in the court, we all heard it. If you do not object again, you have waived that objection.
And the thing is I object when the witness asks, can you repeat the question? It's just objection. And the judge will be like, no, the lawyer cannot repeat the question. It's a new question.
Yeah. You
get on that. Get on that
waive
early.
objections. So when you talk about how easy it is to waive objections, when you talk about waiving objections, it is that easy. Where
other
the
one that
same
happens-
question is asked, and it's not. You don't re-object. You have to re-object. And
The other one that happens all the time is people are too polite. And so it'll be like, something like, objection. And then the judge is like, the judge says, sustained. And you're like, can we approach? You go up and you approach and you're like, why was this sustained? The judge says, it's hearsay. And you have to be careful not to say something along the lines of, okay, I agree, or something like that. You can't ever agree with the judge when they're sustaining an objection against you.
Yeah,
you
you
can
can't do
say,
that.
you can say something like, I understand the court's ruling and we'll move on.
Now,
But you got to preserve your objection.
circling back to this one, here's why this is so dangerous. Why this type of behavior is so dangerous, where you're not allowing the objection to be articulated with specificity as to what you're objecting to. Let's say that you have a remarkably objectionable statement or evidence introduced, and you objected, but you weren't allowed to articulate the basis for it, and the judge says overruled. And now you're writing your appellate brief, and you are trying to argue to the Court of Appeals that your objection was made on this ground, right?
And the
And
Court of
of
Appeals is like, prove it.
Prove it. The Court of Appeals is going, prove to me that you objected on this ground, that you preserved this specific objection. And you say, I can't.
Sometimes this can be like super obvious. The prosecutor in open court calls your client a slur. And you're like, objection. And the judge is like, overruled. And you're like, what do you mean overruled? And then later, when you go to appeal it, it'll be like, how do we know that was the objection, that it wasn't objection hearsay?
Yeah. And that's the part where it's the judge and the Court of Appeals at that point in time. Let's say the Court of Appeals agrees with you or doesn't know what the objection was and applies all of them. Well, the Court of Appeals has the equal authority to say they can apply all the exceptions to all the other rules. Like they don't know what to do. So this rule is stupid. It fundamentally alters how trials are to take place. And I understand that a lot of judges have this rule, but when you impose this rule,
the problem is that there's several appellate cases, because I went and looked at some of them, where they do exactly the opposite. You pick the best objection, and the appeals court is like, but we picked the dumbest one.
And in Virginia, in particular, there was a recent Court of Appeals case this year where the objection was not stated with specificity. And in failing to state it with specificity, you did not preserve the objection because you didn't articulate the basis to the extent that it allowed the Court of Appeals to review the trial court's determination. Because the Court of Appeals doesn't know how much discretion to afford the trial judge if the Court of Appeals doesn't know on what basis the trial judge is viewing your objection. So this becomes, and here's the issue. Well, not, I've said here's the issue so many times, it's like a verbal tick for me, but one of the things that is a big problem, it's a trade-off, right? If you're a judge that's not going to allow the speaking objection or allow the articulated base of the objection, fine. You have to be the same type of judge that allows every single sidebar, every single one of them. You can't criticize, you can't comment, you can't do anything. You have to allow every sidebar. Conversely, if you don't want a lot of sidebars, you have to allow all of the speaking objections. You cannot have it one way or the other. You can't say magically convey to me through telepathy what the basis of your objection is, and I'll hope that the court reporter got it right. It is wild. Now,
well, and the other thing that's been happening, I see somebody pointing this out in the chat, is that they're like, objection may be heard. She's like, later. It's like, what do you mean later? The objection is now. Like, I need to be heard on this now.
And that's the other thing is the objections are waived unless they are contemporaneously made.
And never, like, later never arrives. She's just like, later.
Yeah.
Like,
Debbie J, very generous of you.
contact-
Thank you. Do not contact the bar. Don't.
or the bench. Like, don't,
Because those
don't
get
touch the poop.
no, those get thrown away faster than you could ever imagine. It actually does the opposite. It actually gives
As a third party, if they get a bunch of rando complaints, they will disregard, like, they'll just assume that there's no merit to any of them.
correct.
And, like, let's say that after this, Alessi and Jackson and Yannetti decide to jointly file a complaint against Judge Cannone. Their complaint is so much better if it's not lined up with thousands of rando complaints.
Yeah.
Because they will put them all into a pile. They will look at the dumbest complaints in that pile. And if those dumbest complaints are dumb, then they'll just take the entire pile and put it into the trash. And yeah, don't do it. Do not. Jackson, Yannetti, and
Let them do the
Alessi,
lawyering.
they're very good at what they do.
But to the substance of the question of what you can do, to the substance of the question of what you can do, you're doing it. You're watching, you're learning, you're educating yourself. There are many jurisdictions where judges are elected. There's many jurisdictions where judges are appointed from the lawyers that are in that jurisdiction.
A friend
There
of
are
mine
many
was just appointed to the bench.
Yeah, see, there's many jurisdictions where judges are nominated to the state senate in Virginia, and they're confirmed by the Senate. So they're nominated by the governor to the Senate for confirmation. They get confirmed. Educating yourself on the process for how judges are put in place in your jurisdiction is how you do it, and then
Also,
knowing whom to contact to make sure that the right people are being vetted as judges is another thing. Also,
I have an
be
important
familiar with the
question.
court system. Go.
Rhubarb, apple, blackberry, or mango lime?
Blackberry.
All right.
But become familiar with the courts and don't be intimidated by the fact that this is the judiciary and that you don't feel like you shouldn't be involved or know what happens or anything else.
Just Joe was asking, I'm guessing Just Joe might be in my area because they were asking if the judge was from Chivers, which is Chivers, Sparks, and formerly Teskey. Teskey was already put on the bench and is an excellent justice. What is it? From Legal Aid. Karen McGowan is her name. She is basically the youth court wizard. So she's been appointed to the bench. So yeah.
So learn how you're doing it. Learn how, and if it means that you have to get in touch with your congressman for the next time that a judge gets appointed, you get in touch with your fucking congressman. They listen to you. At least some of them do. Lazy L, this building the record for appeal pisses me off the most. That assumes that Karen Reed will be convicted and sit in prison for months because of this dirty judge. I'm so hoping all of this extra crap goes over the jury's heads. You guys really need to embrace the possibility of Karen Reed getting convicted. You really need to see that not just as a possibility. It is, I'm telling you right now.
Let me tell you that if I am Karen Reed's lawyers,
I'm telling
I have told her to have a signed power of attorney ready, to appoint, say, her dad as power of attorney in case she's got to sell houses and stuff like that because she's going into custody. Be ready. I tell people, we're going to a trial. It's a serious trial. You could get 3 years or something, whatever it is. You need to be ready to go into custody and not come out for years. Have you planned for that? Do you have somebody? Because, you don't want your house sitting there with nobody paying attention to it for 3 years. And she's looking at 20. You want somebody to sell your house and put the money into your account. Or put the money into a an interest-bearing account, and then, transfer it over in portions, right?
Let me tell you that the Commonwealth's case.
Yeah, and I see people noting she's got no money left, but you still have stuff to worry about. Most people, like, even just stuff like what happens to your dog if you've got a dog, right? And she may have already covered all of that, and that's the thing is that this is what you do, right? Yes, I know they've taken everything. She's still,
I know.
There's still going to be something to worry. You always need to plan for there's something.
I am going to say something that's going to piss a lot of people off, and I'm sad. I'm saying it right now because there's 5,000 people here. So there's 5,000 people here, and here I am addressing an issue.
And there'll be less.
Addressing an issue that a lot of people are going to be pissed off about. For the 5,000 of you that are here, before I say the things that's going to piss you off, can you hit the like button? Just because you can't unlike it. Like before I say it, can you just hit the like button, please? And then I'll say it, and I promise you can unlike it then. Okay, here's the thing. Beyond a reasonable doubt has been so watered down in our perception as a society that we don't understand what that standard actually means anymore. We don't apply it properly. And I say we because I mean people in general don't apply it properly. I don't know if you want to call it social media, the hyperbole that you see in public, the decorum. I don't know if it's because people watch crime TV or people listen to murder podcasts. I don't know what it is, but it's been so watered down.
Podcasts.
It's so watered down that people don't understand the burden to which the Commonwealth or the prosecution is held. Correct?
Oh, I mean, it predates all of that. It goes down to you see it from, TV in the 60s. All of that just sort of assumes that everybody who's charged with something is guilty. And basically they stay guilty until that person proves they haven't done it, which is, of course, exactly the opposite of what it should be.
Yeah. What's funny about it is we are a common law system, English common law. In old English common law, the burden was different. You didn't walk into court with the presumption of innocence.
That's terrifying.
Yeah. Just it is very easy. Let's say that also the information that we have been hearing in court, we have the opportunity to digest it, go back, rewind, look at it again, hear arguments about it, recap it with friends, remind ourselves of it. This is a jury who's just sitting here.
Various other people.
Exactly. This is a jury that's sitting here listening to information provided to them piecemeal, not in a direct linear fashion. That's kind of all over the place, and they're trusting their own memory of what the evidence was when they're going back to deliberate. The closing argument is just argument. It's supposed to be a consolidation of that evidence into some streamlined understanding. But let's say that the closing argument, and the other thing is jurors are not, they're not going through this stuff at the level of fine-tooth comb. They might, but by and large, they're not. With a level of fine-tooth comb where they're putting everything, every single minute detail in the proper context, in the proper place of where it should exist. It's not how they act. If a juror is offered in closing argument a timeline, and if the timeline is off by 35 seconds, it is well within that juror's prerogative and probably commonplace where the juror is like 30 seconds. So what? It's more likely than not she was the one that was driving. She had the vehicle. She drove off. He didn't drive off.
More likely than not is the standard they often apply, and it's exactly the wrong standard. More likely than not is completely improper.
Yeah. So why does it appear that I get more pissed off when the prosecution does things and when the defense does things? It's with that understanding in mind that the deck is stacked against the defendant in every single fucking case. It is always stacked against the defendant. And I hope for the 5,000 of you that are watching right now that you will very much appreciate the words that I'm telling you about how jurors act the next time that you are called for jury duty. And
that's
that
great numbers, by the by.
You are, thank you. Thanks to you guys for being here. But the people that are here, the next time that you're called for jury duty or know someone called for jury duty, well, after they've talked about it, or after they've resolved the case, that you take from this the understanding that there is no standard that is more important in our justice system than beyond a reasonable doubt, and having a proper understanding of what that burden means, and taking the evidence not just as a summary of information, you puppers, as a summary of information that you have to somehow put into a box and either say guilty or not guilty, and you kind of going, well, it's more likely than not. Even if it's the box of, well, I don't see any way else it could have happened. You have to try to see another way that could have happened. You actually have to explore every possibility of a reasonable doubt.
Well, and the other thing is reasonable doubt can also be, I don't know what happened.
Yeah.
But, and it can be, I don't know what happened. The prosecution puts on a pretty convincing theory, but it's only pretty convincing, and it might not have happened that way. It could have happened some other way, including ways I don't know.
And the prosecution's narrative is far simpler. It is far simpler than Karen Reed's narrative. And it is far easier. If you don't get into the minute details, it is far easier to understand than Karen Reed's narrative. So I don't, and I'm saying this not for all of you guys to jump down my throat and yell at me like I'm an asshole or a prick.
Well,
I am saying
you actually
this.
have more people watching now than when you started this.
Yeah, that's probably true. I'm saying this because you guys need to have this understanding in mind that this is not just a possibility, and it's not a remote possibility.
There's a genuine chance that she gets convicted.
Genuine chance. I'm actually here's the thing. At this stage, with what the prosecution has been able to put on and what the defense has been able to bring out and cross without the defense's experts, I don't know, average jury thinking maybe 70% chance of conviction at this stage. Because you have to be.
I don't think a jury should be looking at conviction at this stage,
I don't
but
think
you
it
got to
should be.
realize that they could,
And they
right?
often
And
do.
that they, yep. Like all of this stuff is how juries think and how they act. So
yeah. So for every time that I start yelling about a prosecutor that steps outside the bounds, or a judge that might give an impression to the jury as to how information is being received, I am doing that with this understanding in mind. That we are dealing with something that has to be given the greatest weight that we possibly can. And we have downplayed that and minimized that and bastardized that and done everything we can to that standard, except for faithfully and dutifully do that job and do that analysis and make the Commonwealth or the state or the prosecution reach that burden. And it's our job to do that.
And folks, if you're ever on a jury, I hope you'll remember some of these trials that you've watched and just be like, you don't have to, I'm not saying go acquit people. It's just, you need to be mindful of the fact that the evidence that you hear at the beginning might not be how it is, when it shakes out. You need to be mindful of the fact that police witnesses may not always be honest or accurate. You need to be mindful of the fact that experts may be inexpert, or that they may be, motivated, or any of these things, right? And the only thing the system can really ask you to do is to go over all of this and to be very careful and very thoughtful about how you do it.
And Matthew, this comment, I hear you. I think we don't have the experience you do. We just find it hard to deal with the anger we feel towards the government system, and should be aware it extends beyond just Karen's case. 1,000,000%.
Yep.
Yes. So when you guys ask about what you can do, a lot of you are doing it right now. You're watching the case. You are listening. You're learning. You're wanting to engage. You're wanting to understand how these cases get tried, what's wrong with it, what's right with it. You're trying to learn more. And you are absolutely allowed to be angry and feel angry. Fuck, I'm angry.
I'm
at this
angry.
stuff.
Like, oh.
And
Yeah.
you are also right that this happens all over the place. All over the place.
And remember that there are cases you have never heard of that are just as bad.
Yep.
And there are cases that you think were fine.
Oh.
That are just as bad.
What was the dingo ate my baby?
Yep. Oh, everybody thought she was like the worst ever until they're like, oh, right. We totally found.
Until they found the bones in the dingo den.
Yeah. It's like, oh, right.
Just person spent years in prison. Just
and was
wild.
vilified and still is vilified.
Lazy L, Rob, would you really be leaning towards the prosecution after the ME said no injuries consistent with a vehicle strike? I don't have to agree with the ME. And not me. The jury doesn't have to agree with the ME. For me, for my purposes, for my sense, the prosecution has not demonstrated to me how Mr. O'Keefe's body could possibly look the way it did, being hit by a vehicle going 24 miles an hour in reverse, even if it's clipped. That is where I am. And then the timeline for the vehicle leaving Canton or leaving Meadows,
the car with teeth.
Yeah, the cuts on the arm and the timeline for getting back to the house. Those are the things that I can't figure out. Now, prosecution might have an explanation for the timeline. I don't think that. Well, you know what? Let's do this. Let's get to that. Let's do that.
The time. I mean, they've got an explanation. It's just the timeline can keep changing every week.
That's what I want to get to. We should swoop. We're going to swoop to timeline. Swoop to timeline. So at the conclusion of the hearing yesterday, I thought we were done. And I was like, oh, cool, we're done. We were not done. There was an argument to be made.
The topic I would like to raise with Your Honor is the timing and nature and significance of the information that the defense has received from the firm Aperture. And Your Honor may recall there are two individuals on the witness list that we understand are to testify in this matter. First is Dr. Judson Welcher, and the second is Shannon Burgess.
And are they testifying in reverse order, though, than what you said?
My understanding is, Your Honor, yes.
Okay.
My understanding, Mr. Brennan has the best information, is that it's proposed that Mr. Burgess testifies first and Dr. Welcher testifies thereafter.
Okay.
So the Commonwealth has established in reports right up until not established, they have stated in the reports of Aperture, particularly the slide presentation of Dr. Welcher, a trigger called 1162-2 that they have associated in the report of Dr. Welcher with a specific time. And that specific time that they have associated with that trigger is 12/31/38 to 12/31/43. And we have been assuming that information, and this is from best memory, but I believe it's slide 137 or so, where the statement is in the slide. And so we have proceeded with our defense. We have proceeded with the work that has been assigned to ARCA based upon that time period. On May 8th, not too long ago, Your Honor, we received an amended report of Shannon Burgess that pushes that time period. I'm just going to give it. So, although it was dated May 8th, we received it actually on May 11th. And in that report, Mr. Burgess states that he is making an amendment, and he is now stating that that infotainment trigger of 1162-2 is further back in time and it is past 12:31:43.
Do you have the time?
I'm going to get the exact time, Your Honor. It is 12:32:16.
12:31:38. 12:32:16.
And basically, it's the Commonwealth's expert heard what we were going to use to impeach them, and decided that he needed to fix his evidence to, like, this is what it looks like.
And this is one where right now I am doing my very, 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 very best to apply neutral hat. How could this possibly look a certain way? And in a certain way that is different than what my gut tells me it feels. So I'm just writing down 12, 1, 2.
Okay, you're going to wear the neutral hat. I'm going to go get a different hat.
You go get the different hat. 12:31:38. And then hang on, what was the other one again? I want to repeat that. 12:31.
12:32:16. And Your Honor may recall that the second.
Okay. 12:31:38 to 12:32:16. Why is this significant? Because John's phone data shows his last physical interaction with the phone. And this is why I'm really uncomfortable at the timing of this one. And I'm trying like hell not to think that this is intentional. But there was substantial cross-examination by Mr. Alessi in this trial and the other one. Substantial cross-examination on what it would take to register that last interaction with the phone, 12:32. And it was hammering down on Ian Whiffen and saying it had to be some type of physical interaction with the phone, right? He had to have physically interacted with it in order for it to register that thing at 12:32:16 or 12:32, whatever time it was. And Ian Whiffen had to admit, yes, he had to have physically interacted with it. Well, based on the theory that was offered at opening statement, and the theory that's been advanced by the Commonwealth at every other stage of this trial. Every other stage. It was 12:31.
Fuck this shit, we ride.
12:31:38. Ian got his cowboy. 12:31:38 is when the vehicle is said to be going 24 miles an hour in reverse. I think that was it. 1162, right? That trigger, that vehicle trigger. And the fact of the matter is, if at 12:31:38 the vehicle is going 24 miles an hour in reverse, and yet John interacts with the phone 12:32:16, 30 seconds after that, then it would be impossible for John to do that. Based on the injuries that are suggested. Unless somehow that timeline aligns. Now, I think the Commonwealth still has a problem, and I think here's the problem. 12:32:16 shaves 30 seconds off the Commonwealth's time for Karen Reed to get her ass home and connect to the Wi-Fi at John's house. So are we going to see more time shifting with the Wi-Fi? Does the Wi-Fi connect in a different way? Does the Wi-Fi record time a different way? I don't know. I don't know how that is supposed to work. But that is the argument being advanced. Now, here's my issue with it. This is like submitting your answers to a quiz, and then the teacher issues the answer sheet, and then you submit amended answers to your quiz.
Yeah. Well, the other thing is that they let the defense commit to a timeline.
That part.
And they let them cross-examine based on that and tell the jury, because of course the jury picks up on what they're doing, tell the jury what they're, where they're thinking and what they're going with and so forth. And then it's like, nope, And then, so they get to make the defense look stupid based on that. I'm going to take the hat off because I'm going to end up mecking.
This comment. Mary, I get you're a little bit behind. I can't believe all this BS tonight. Is that how you go to court and feel about your people that you're defending, that you tell them that they're going to jail? I tell them realistically, I tell them the odds. I
tell people realistically, sometimes it doesn't matter if you're innocent. It matters what happens in court.
Yeah. Do you want me to blow rainbows up your ass and make it feel like you're going to walk out of there because it's, fair? And my job is to advance the best position I can for my client and to tell them the truth at every stage of the way so that they can make informed decisions along the way. So that's my apology. I got distracted by that comment.
And it would actively harm the client to fail to warn them that they might have, if the client's looking at a decade in prison, you don't want to be like, oh yeah, you shouldn't prepare for this because,
or it's also what allows, this is also why a lot of people take plea deals. It's not great, but it's their life. It's not mine. They get to decide. If I'm telling a client that they have an 80% chance of being convicted based on the evidence that's going to be provided at trial, but a 20% chance of going free if I win all the arguments I'm going to win. And then I say, but the offer on the table is that you do 6 months and you plea out to this. Doesn't the client have the right to decide based on all the information?
I mean, ethically speaking, I am in shit if I don't, transmit that offer to the client. Even if I think the client is 100% innocent, and even if I think the client is 100% going to be acquitted, I still got to present an offer to them when I have an offer. Like if the prosecutor says, hey, I'm offering 6 months, because it's the client's decision, not mine. But I also saw somebody saying, Runkle, if you're in front of your maker, is Karen Reed innocent? Here's the thing, and I've been consistent on this.
Not guilty.
I don't know. I don't they said, are they factually innocent? And I'm like, I don't know, but that isn't the issue here because I don't know if anybody is factually innocent. Factually innocent is a whole different thing than what we're looking at here because at the end of the day, what we look at is, can they prove it? Did they prove it? And if I'm at the point of, I don't know what is going on here. I don't know if that's an absolute not guilty, right?
And I'm sorry, Ian and I have been practicing law for way too long to actually give you an up or down vote on whether the person did or did not do the thing. That's not my job. I add nothing to you. I add nothing to your interpretation of what's going on in court by giving you my impression of what actually happened. Because I don't know.
Ultimately, the aspect of all of this is that people say, how can you defend guilty people? I don't know. It's the judge's decision. I'm not the one who actually makes the call.
All right. Sorry. This is badass. This is awesome. So we went from bad topic to celebration here. Margot Rana, Robin Runkle, I graduated law school last Friday.
Oh, congratulations.
Wanted to pop in and say thanks for the inspiration and content over the years. Hoping for a career in appeals. That is fucking phenomenal. Now on to the bar and a Fed clerkship.
That is amazing.
You got a Fed clerkship lined up? Way to go.
That is also super badass.
Way to go. That's awesome. So cool. I will take a small little piece of credit in you being where you are when you get.
I will take no credit, but I will also be super proud because that is.
Take a little bit. Just take a little bit.
I can't.
I know. Okay, so but back to where we are here. So now we're wanting to change the timeline from 12/31/38 to 12/32/16, which coincidentally lines up with John O'Keefe's last phone movement. And we are.
And the defense has put a lot
They put everything they have into it.
Yeah, they put a lot on, like, hey, this doesn't line up. And now they're going to be like, oh, yeah, it totally does, because we just changed our everything. It's...
Okay, so let's rest the argument by Mr. Lessie.
Seconds, literally seconds matter in the analysis of many factors. I won't go into them other than to say I went through and developed testimony with regard to the cross-examination of Mr. Whiffen. He had a timeline. He talked about much human volitional conduct. Suffice it to say that that information is literally by seconds determinative in some ways of various analyses. So we basically commissioned, if you will, ARCA to be looking at matters based upon the infotainment trigger 1162.2 of 1231.
Hey, Mike.
38 to 1231.
Oh, hey.
It says of May 11th, we received information that has changed that. Now, Your Honor, that is a rule.
Mike, it's been too long. If you're bored, you can text me and I'll let you on.
It has been way too long.
But that's only if wait, what time is it now? We're probably heading out to the bars or coming back from the bars.
Also,
just
Mike, text
me.
Did you see my video that I think you would be amused by? Oh crap! I just tore it.
Not your video.
The letter I got that is.
Oh yeah, he would love that one.
I bet Mike would love that one.
Sorry for the distraction. That's my ADHD. Go on, Mr. Lessie.
14 violation, among other issues, but I wanted to start there. It's a Rule 14 violation. It's obviously, as I stated, an amendment of a report of a significant matter. And also, with regard to the defense's ability to provide a defense, we have to be able to evaluate that information in terms of our entire defense. And it's just not limited to ARCA, it's our entire defense. The other data point I want to get to, so the effect it's had, we still haven't even been able to evaluate entirely that. And I believe, Your Honor, based upon the information that I have, that this may have been a calculated matter by the Commonwealth, but even assuming it's not calculated, the effect is pronounced. So what I want to do, Your Honor, is to look at what the reason Mr. Burgess has given, which leads me to be very concerned about a calculation and a strategy calculation here. Mr. Burgess states in his own words that the reason why he is changed, that time is being changed, is to, quote, align the trigger with Mr. Whiffen's analysis.
And this part really, it's not that this part bothered me. I want to see the report so badly. Because if, let's say the report says, and this analysis aligns with Mr. Whiffen's analysis, that is very different than to say that I did this to align with. Those are very different things. First one, coincidence, right? Because even Ian Whiffen's report indicates that the last movement on O'Keefe's phone is 12:32.
That guy's got to rename himself.
Whiffen?
No, Ian Whiffen.
Oh, well,
he's lost his Ian privileges.
Oh. Okay. Oh, I was laughing at something else. Just God. But yeah, okay, go, Mr. Lessie. I'm going to figure this out on my end.
And Mr. Whiffen's analysis is based upon the extraction data from Mr. O'Keefe's phone. And I believe it's undisputed that the extraction from Mr. O'Keefe's phone occurred years ago. And the data from that has been extant, it's been available years ago. So to me, Your Honor, that basis can't be a proper basis at particularly this stage where we are approaching the end of the trial, just literally days before the testimony of Aperture. And we are in a very, very almost impossible, challenging situation. So, Your Honor, there are obviously, Your Honor knows the situation here.
I don't know
Our
that she
first
obviously
request is that the May 8th report that we received on May 11th be not allowed, that it be not considered at all. As Your Honor knows, I don't like to use hyperbolic words, but the word has been used for us, against us, ambush, ambush, ambush. If there's ever an example of an ambush, this is it. And so, Your Honor, our request is that Your Honor find a Rule 14 violation, that Your Honor have the remedy.
I didn't even see that. Debbie J. That is remarkably generous of you.
because I wasn't there. That's the thing. I don't believe she's guilty. I don't have evidence to convince me that she's guilty, but I wasn't there, and I can entertain the theoretical possibility.
Debbie, I'm going to say this. I'll bring this back up again because I'm sure it's going to come up again. I will save this. I'll bring this back up. You do not need to super chat that. That's very generous of you. But I will bring that up.
Be that the violation remedy be that this is not allowed, and that the Commonwealth proceed with its the information of Aperture that has been extant before the May 8th date of the report. Thank you.
All right. Do you have another option if that's not something that we do, right? Because the Commonwealth moved to exclude ACA or have them go by their old.
You know what? I need someone to make me not feel so angry right now. Mike, make me feel not so angry right now. Just
He's like, I didn't sign up for this. This is
how you doing, Mike?
Good. How are you guys doing?
Oh, doing all right. It's been a while.
Well, it has. I watch you guys sometimes, but then I'm always like in the middle of stuff. But tonight, Rob knows.
Yeah. Are you gonna say it?
I'm in the middle of some G-rated adventures over here. I'm done.
G-rated.
I was doing dad duties.
Is this the last? Is this the last dad duty? Is this the?
No, I've got more.
Oh, okay. Okay.
But anyway, I'm sober as a deacon, and I got a couple minutes. But yeah, it's nice to see you guys. I did a couple days of this trial. I can't figure shit out. I really can't. Everyone's like, oh, the defense is so good, and I thought the defense attorney started strong, but I think it's fading.
Which ones? Which attorney has been your favorite so far?
Well,
you want me to put them on the screen?
I saw so little of this. I saw one of the cops that they did. They were beating up the cop. He was like Eastern European guy.
Oh, Buchanan. So you saw Alan Jackson. Yeah. Yeah.
And everyone's like, oh, he's so full of shit. I'm like, he's making sense to me.
See, this is important. This is so people, and I've tried to tell people this, people who have lived with the case, people who live with the case, people who know the details, people understand a lot more having watched this stuff outside of court than someone who's just walking into it for the first time.
Well, yeah,
I think he was like super Weasley.
Well, I don't have enough context. I'm just watching him, and I'm like, he doesn't seem bad to me. But I didn't watch the first trial.
See, and that's the other thing.
And the thing is neither did the jury.
Neither did the jury.
And the main defense attorney, he comes on. I mean, there's a pile of sketchy shit going on with this investigation for sure.
Oh yeah,
but that doesn't mean she's innocent. The selling of the house and the redoing the basement is just flaming red flag. I mean, it's just suspicious as hell.
The dog being rehomed.
The dog being rehomed.
All of it.
Let me put it to where I'm at. I don't see a conviction still as of yet, and I'm just dabbling, and you guys are like closer to it. But from what little I saw, I don't see a conviction there. But if you ask me in my heart of hearts, did she do it? I don't know.
And we just had somebody who was very upset because I was like, I don't know if she did or didn't. And the thing is it's the Commonwealth's job to prove it.
Yep.
Yeah.
And like, I have been to literally hundreds of trials because, criminal defense work. Usually I've got a pretty good sense, like real early on. There's like, and usually my argument is something like, are you sure you got a really good look?
Yeah.
Could it have been somebody else?
You're playing at the edges. You're trying to basically create any doubt in the world. It's not reasonable doubt, but you're trying to poke holes.
This one is one where I'm just like, wow.
My fresh, clueless perspective on this too is the other thing that really gives me serious reasonable doubt is the injuries don't freaking match.
They
don't match the defense's story of the dog bite either, but that's whatever. But the defense doesn't have to prove it.
That's
the thing. Hell don't match getting whacked by a car. There's no effing bruising.
It's this magic car that's got teeth.
And I deal with injuries all day. And if you get hit by a car, there's going to be bruising. A lot of it. Always, like a little thing. Like a pedestrian in a crosswalk at 5 miles an hour. Bruising.
Yeah.
Even a glancing, 5 miles an hour. 5 miles, and that's the thing, 5 miles an hour. Glancing blow, there's still bruising.
Yeah.
There's bruising and there's broken ribs, there's broken bones, and not broken ribs from chest compressions. There's broken ribs, like all the ribs. You were just saying, then the defense says, oh, none of this stuff matches up. And I'm like, no, I hate your theory. The stuff you're saying doesn't match up, does match up. You have better just sort of like reasonable doubt defenses. Why are you selling your soul for it's like you have to fit this narrative or you lose all credibility. And I just think they made a mistake there. I think they did. Here's my impression from the first trial. First trial, they went way too hard in the paint on that. I thought they really pushed that issue and they put a burden on themselves that they didn't have.
And they've dialed it back this trial.
Yes,
this trial,
great way to put it.
They've done better at it. But this trial also, the prosecutor's taken a different tactic as well. So you get to see some legal chess play out. And I want to see the experts. I'm waiting for them. Because the fact witnesses, I don't believe any of them. I don't. They're going to say,
anybody.
I don't believe anybody. Just show me the fucking math.
The defense has thrown up theories that I think also suck, but that's fine. They don't need to prove them.
I had a trial where my client insisted on testifying, and at the end of it, and I told him not to because I was like, everybody that has testified so far, except for like a cop who was like, I showed up after things and I don't actually know shit other than this is the guy I arrested and these are the people. Like the cop's testimony was honest, but the cop doesn't know shit, so it doesn't matter if he's honest or not. But like everybody was clearly a lying sack of shit.
Yes.
And so my client is like, I want to testify. I'm like, we don't have to prove anything. So client insists on testifying. I'm sitting there with I advise you not to testify letter in my file, but like, okay. And my client gets up and tells the story that is like the least plausible story ever. And the judge is like, the Crown is just like, I should just submit these people are believable. And, I'm like, so I get up and the judge is just like, so, Mr. Runkle, what do I make of this case? And I said, Your Honor, I'm going to suggest that there's not a single credible witness in this room. You have not heard a single credible piece of evidence other than from the officer whose evidence is not helpful.
Yeah.
And the judge is just like,
you have to acquit.
okay. And I'm like, and the natural result of that, Your Honor, is that's an acquittal.
Yeah.
I'm going to suggest that none of us knows what happened here because nobody was like, everybody was either, I don't want to say that my client was dishonest, but I'm like, everybody here was either lying or stupid. You know, and
that's with the fact-based witnesses, that's what drives me fucking crazy. You're telling me that someone is on your front lawn, dying or dead, and there are ambulances, police cars, and you're giving me the excuse of, well, they didn't have sirens on, therefore that's why I didn't come out of the home or I didn't wake up.
Yeah, no.
You have got to be out of your fucking mind.
That makes no sense.
That makes no sense, especially when you yourself are a trained law enforcement first responder. Like,
oh, I mean, I would have been out there like
no way. I don't care if you're hammered. I don't care what. You're out on that lawn.
Well, the other thing, what does she actually try? I mean, is it like a manslaughter kind of thing? It's not like
murder.
Lawn.
It's murder. They are saying that she intended to hit him with her fucking vehicle.
Pre-existing plan, the whole deal.
Yeah, she intended to hit him with her car.
Effing way.
Not pre-existing plan.
Not ever.
But you
tell me she was like sloppy. Like you tell me that
it's not premeditated. What it is they're saying that she intended the act that resulted in the death. So she intended to slam on the vehicle in reverse, knowing that the natural consequence of that was that he was going to die. Yeah, the eye roll is appropriate.
I don't think you can sell that.
No, but their notion on this,
like she didn't.
That's the problem. They're going to split the baby. That's my concern with the jury. The jury's going to go, not murder, but manslaughter, and no problem.
I think the murder is purely there because they're like, we have a thin argument for it, and we know that ultimately the jury might split the baby on it. But their argument is essentially they had this fight in Aruba, and she thinks he's sleeping with other women, so she gets mad and intentionally hits him with the car because she's angry because they've been fighting and she's drunk and she just decides, that she's going to smoke him by throwing this car into full on reverse.
Oh, and the next day when she sees him laying there on the snow and screams out, I hit him, that's an admission and not a statement of exclamation.
That's the best part of the prosecution's case is her statement and her running her mouth on TV about it.
It's her running her mouth on TV about it.
The problem is
that's the best part of the prosecution. The best part of the prosecution's case is not the statement itself, because I can explain the statement itself. Mm-hmm. Like the exasperated statement, the exclamation, the fact that she's in shock that she sees this. It's the repeated statements in interviews, the public, that bothers the hell out of me, the lawyer, who's like, stop talking.
The thing is that she needs funding. She needs like people to see this, and and so the Commonwealth has infinite money, and they can just like hire experts because they want experts. They can all of this stuff. Whereas her team's got to scrape and scrimp and, fundraise. And so they're put into a difficult spot where in order to do that, she's had to make all of these appearances and so forth. And that ultimately...
So she's getting money out of these appearances to help with her defense?
Mm-hmm.
I don't think she gets... did she get paid for the appearances, or is it more just...
They've got to be paid. There's no way they're not paid.
There's always a way to monetize. I don't know specifically.
Well, and that's the thing is she's got fundraisers, and so the more people are paying attention to it, the more people might go and donate $100.
Okay, now I feel guilty because I feel like I drug you guys down. Just like you guys know the case, and now you got some guy.
You didn't. No. Here, because here's the thing. The key. There's key cycle data. There's vehicle data. The vehicle data shows that she. So. At the first trial, and I can't wait for the person who's going to break down the fucking black box in this car, because at the first trial, the expert basically said she threw the vehicle in reverse in this key cycle, and the vehicle got to 24 miles an hour in reverse. I went to an empty parking lot in my truck, and I floored it in reverse, trying to get to 24 miles an hour without shitting a brick, and
Spoiler alert: he shot a brick.
Oh my god! Did you do the broken bed video redo?
No, I didn't record it, but I just
you really
tried.
Should have.
It was scary as hell, dude. I'm not doing that again.
That was the bomb video right there.
I've got a watermelon in the other room because there's a particularly distinctive mark on John O'Keefe's head that I'm going to try to replicate by pistol whipping a watermelon.
I was wondering how we got to watermelon.
That's terrible. I was so concerned for so long. Right, I was so worried where he was going with that.
How did the snowplow driver come off? Did he testify in the first trial?
He did.
Snowplow
and he
driver
actually
testified
comes
in the
off
first
as
trial.
very, very straightforward. Like he doesn't
like believable.
Jury dismissed him. The first jury dismissed him. The first jury thought he wasn't credible. That's the problem. We don't know. Nobody knows. Nobody knows. But so the 24 miles in reverse.
Afterwards, they tell you the craziest crap. You're sitting there obsessed for like 6 weeks putting a trial together, and they're like, "Oh, I didn't like the color of his shirt." You're like, "Oh my god, I'm gonna lose my mind."
Yeah. So there are key cycles in the car. The car does all kinds of shit. The car is supposedly spinning wheels 24 miles an hour, but also they didn't account for the fact that tires might be just spinning in the snow.
Yes.
To get to that 24 miles an hour. There's any number of things that have taken place where there's behavior by Karen Reed I don't like. There's questions that I have on timeline, but I cannot get to the prosecution proving what happened the way that happened. I just can't get there. And to me, that's reasonable doubt. I'm not saying that Karen Reed didn't drive the car drunk. I'm not saying she didn't drive it recklessly. I'm not saying she didn't drive it back up like crazy, a person, or I'm not saying any of that. I'm saying that they have not proven to me that she hit John O'Keefe with a fucking vehicle and that killed him. They have not proven that to me.
I'm going to tell you right now, a guy who's only seen 1% of one of the two trials, I have the answer for you. This is a hung jury because some people, there are jurors sitting there who are saying the B said it. I'm saying she's guilty.
Oh yeah.
And there are people on there. There are people on that same jury saying there's no way the prosecution's met their burden, and I am not doing it. And that's a hung jury is what you got.
And that would make the second one if that's the case.
And then you got to let it go.
No, the prosecution will not let this go. They'll run it a third time. They'll run it a fourth time. Because the thing is every time they're emotionally invested, and every time they make her run it, she's got less and less money to do it. And so eventually she just runs out of experts. Because the experts aren't going to show up for nothing.
I don't know. It seems like a weak case. Like even though she may have done it, I don't know. But it seems like a bad case in terms of the evidence that you have. And even the fact that they brought it again makes me feel like they're covering something. It really does.
They're obsessed with it. They
because if they walk on it, then it's like, okay, hey,
I know.
You got,
if they walk on it, then every person's political career who's involved in the DA's office is done.
Yeah, it's wild.
The lead investigator has been fired from being a police officer over his conduct in this case. And they're like, we're bringing this charge again. I'm going, why? Why? Like this, that screams to me that this is over. This should be done.
Does anybody have a good theory as to the scratches? I don't think it's a dog.
I think it looks to me like a dog.
I don't think it's from a car. I don't think it's from a broken freaking taillight either. I mean, I don't have answers. I'm just saying, does anybody have a good theory?
It looks to me like dog.
I don't know. The defense has an expert, not just Dr. Russell, but did the defense get the dog trainer, the Marine, or the guy who's
I believe so, yeah.
K9. The defense has an expert lined up who's a police K9 trainer who says that this is exactly what a dog bite looks like when the dog has a weak bite. Melanie Little interviewed him. I actually watched that interview a while back, and it was really interesting. So
which I guess is what you'd expect from a regular house dog too.
Well, this dog was a failed police dog.
So basically they're saying this is a dog that sort of sucks at biting, and
right.
But then we're back to where I am at the very beginning. why do we have to have that discussion if I have this in my mind as being a reasonable alternative? Like this is I don't have to decide that that's the case or not. I don't have to say that looks more like a dog bite. I just have to say that doesn't look like a fucking car hit him in the arm.
It doesn't look like it. If a car hits you hard enough that you crack the taillight and it creates those scratches, that's theoretically possible. You got bruises.
You
got bruises from the hit.
Mike,
you got bruises
you have more than bruises. You have more than bruises. If you crack the polycarbonate.
I woke up this morning with bruises from sleeping.
Well, that's just because we're dinosaurs, Ian.
You're saying you hit this guy with an entire car and
I know they're trying to now change it. So the Commonwealth, the first iteration was that it hit him, right? The car struck and flew him, and he pirouetted through the air and he did all this stuff, right? The second iteration is, oh no, there's no bruises because it glanced him. Like, do you understand what 6,000 pounds going at that speed does? I don't give a shit if it grazed him. I don't give a shit if it touched
gives him a stern look, he's gonna get bruises.
Even if it just makes an abrasion to his arm, it's abrasing. Like, there's no way.
If we have the notion that this tail light scratched him, then how come the tail light pieces and housing and so forth aren't full of DNA? Because there's not.
There's no DNA on the light pieces?
No, there's DNA on the exterior of the light, but it's on the vehicle. They didn't test the shards. The DNA dude testified.
They don't have DNA on the shards.
But even DNA on the car doesn't mean shit because it's like
it's his
car
that they're around. So
or no, it's her car, but he's always in the car.
Right. So that's like getting DNA from somebody's house where they live. Well, no kidding.
Yeah. We found his toothbrush had his DNA on it. It's like, well, no shit.
Oh, that's wild.
So
I mean, the thing is a lot of this comes down to, if we're entertaining like possibilities, it's possible she did it. And if they had done a competent investigation, it might be that I'd be sitting here going, 100%. Like, they could have gone and like, they said, oh, we didn't want to have a look around in the house where his body was found on the front lawn because we couldn't get a warrant. And I'm like, anyone else on the planet, you wouldn't have asked for a warrant. You would have asked for a consent search and people would grant it, right? And had they done the consent search, it could have eliminated the whole issue of, did he get killed in the house and dragged out?
Also,
these things.
Important testimony, Mike, is there's a split eye. Like there's bruising on his eyes, and one is more predominantly bruised than the other. And there's blood on the shirt in various places where there's no underlying injury on the body. Like there's blood on the exterior of the shirt.
No way.
There's blood on the exterior of the shirt.
This should be not guilty. It'll be hung, but it should be a not guilty.
Shirt.
Oh, and they do DNA testing.
Got his first statement.
They do DNA testing of a whole bunch of different spots on him, and they conclude that the DNA comes from John O'Keefe and an unidentified other person for like a whole bunch and like multiple other people. And I'm like, so you guys, it's a dead police officer, and you never actually put in the effort to like figure out who DNA'd all over his shirt. Like
this is and the thing is this is the thing for me. The prosecution can close any number of these circles, right? So if the prosecution's evidence closes any number of these circles, great. There's still one or two of them left open.
Yes.
And you've got to close all of them to get me to a guilty. That's where I am. Like you can square all of these arguments. Like, and that's the thing. When I start arguing with people about this case and they're like, but what about this? I'm like, all right, cool. Let's give your hypothetical a chance. Let me go ahead and say, you have closed that loop. You have proven that fact to me beyond a reasonable doubt. Congratulations. You have not proven every other thing here.
I use the metaphor of a boat. Like the prosecution starts with like a bunch of boards and they have to build a little boat out of it. And that boat has to hold water and the thing has to, and the defense only needs to sit there and like leave a hole in the boat.
Yep.
That's it. At the end of the day, like the defense gets to interfere with what they're building in the boat. And if there's a hole in it at the end of the day, the defense wins. The prosecution's got to build the whole boat. Now, what they're building is not a boat. It is.
It's leaky as hell. Because you're right. Like they can kind of patch up this hole, but if there's 3 other holes, it's sinking, man. It's not working.
They're building a pile of firewood, and they're telling us it's a boat.
If the standard was a preponderance, which is what I deal with in civil law all day, I'd say this is close. You could go either way just based on her statement. But if it's beyond a reasonable doubt, it's not even effing close.
Yeah.
From what I know, but I don't. But there's so much I don't know. I could be wrong. But from what I've seen,
there's a lot to it. Yeah, it's
and that's
this trial's a shit show. It's a complete shit show.
You might have a different take on it, but this is not a civil trial. It's got to be proof beyond a reasonable doubt. I actually started covering this because I thought it was going to be stupid. Literally, I was not going to cover this, and then I was watching Emily covering it, and it starts off like the first trial starts off with Yannetti going up to the mic and going, Karen Reed was framed, and I went, holy shit, the defense has just
what are we doing?
Something that they cannot possibly deliver, and they're gonna get slaughtered. And so I started covering it on the basis, and you watch my initial coverage, I'm like, there is no way the defense delivers on this, and the jury will punish them for it. I was like, this is gonna be be ridiculous. This is gonna be awful. And then I'm at the end of the first week, and I'm going, why is this not ridiculous yet? Why is this holding on as a theory? Why has this not been blown out of the water? And as it goes on, I'm like, holy shit, this wasn't just them talking. There's actually a basis for it. How?
That's why.
And Summer, no, this is not how I talk in court. This is how I talk at 12:20 in the morning when I'm breaking down a case after I've been in court.
How much longer is this thing going to go?
Another 5 weeks or so. It's never going to end.
It's never going to end.
And that's only for this trial. After they get another hung jury, it'll be
see.
All right, I've got a travel day tomorrow. I have to get out. It was awesome seeing you guys. I seriously feel bad. I just drug you guys right down to the mud.
No, it's fine, Mike.
If I get another
3 months ago,
if I get another of these letters,
yes, Mike, that is signed. Look at his face.
What is this?
You know what this is when it's signed with the big thumbprint, red ink thumbprint.
Sovereign citizen.
I got a sovereign citizen type who.
Okay, that's what I was thinking, but I'm like, I don't know. Is this some Canadian stuff? Maybe it's legit up there.
It is someone who signed a letter to Ian in blood in their thumbprint.
One of his demands is proof/evidence that the 3 jurisdictions, which he spells wrong, of law, land, air, water being the land of the sea, do not exist as you so elegantly demean me over. And I was like, well, first of all, I'm not your monkey, and second of all, this is ridiculous. I might as well
fire.
So, I sent a response to this letter.
Oh no!
And the response was, "Dear sir, I wish to treat your letter with the seriousness that it deserves. Accordingly, please find attached a picture of a monkey." And then I attached a picture of a monkey, and I sent it. And,
I love it.
And I haven't heard back, so I assume the guy has been
probably,
that he's probably realized that it's okay, maybe. So we'll see. But he's like, I demand you stop talking bad about me, and it's like, no, that's going to continue so long as you.
So you're covering one of those cases.
I covered, he had a reported decision. I covered it. It was hilarious. I mocked it. And then, what do you call it? And then he sent me this letter going, please stop making fun of me. And I was like,
no,
I was done making fun of you until I got this letter.
Don't give me more material. Absolutely not. Yeah. All right. You guys are the best.
Thanks, Mike.
I'm out.
Cheers.
I'll be back.
Yep.
Awesome. Yeah.
God,
I miss him. We got to hang out more
so
often.
needed. Okay, more argument.
Report, right?
Right, and Your Honor, I'm going to answer your question, but with just a quick point that this is really much different than ARCA because two reasons. We are the defense, and ARCA is a rebuttal to the prosecution's case. That is much different than a prosecution changing its theory of the case at this time.
I understand that. I'm just asking if you
Right,
have
so-
another
so-
option.
It's not what I am saying that I am proffering. I think the only remedy here is exclusion and a Rule 14 violation.
And you're not waiving that?
I'm not waiving that.
No, I'm not asking you to.
Your Honor.
Okay, a continuance for how long?
I could have a better answer perhaps to that question tomorrow. I haven't, given what's been going on, I haven't even had a
Right.
chance to talk to ARCA.
All right, so tomorrow morning, let me know that. All right,
In Your Honor,
You know how much I
will do
hate that?
of course. And I will also say, without getting into an elaboration of it, we have to look at all the witnesses that we called. I'll give you an example. Mr. Whiffen. I had my whole cross-examination, not whole, but a significant part of my cross-examination of Mr. Whiffen based upon going through human volitional conduct off that phone that was after that 1162 trigger. And a lot of our defense in theory is based upon that's been in existence now for several months. And again, I go to the bottom line that the proffered reason in Mr. Burgess's report is to align with the data on Mr. O'Keefe's phone, and then that's been around for a long time. So that's my answer to Your Honor's question.
all right, thank you. Mr. Brennan.
Your Honor, this disclosure is not a Rule 14 violation. The Commonwealth, just like the defense, is entitled, continues to work on their case and study their case as time goes on. This issue,
pause.
the relevance of this issue.
Yeah, fuck off. I know.
It is
You
so
may-
insane that they're like, the Commonwealth is entitled to still
To
be trying to
continue
figure this fuck out.
investigating.
It's like, we're trying to figure out what the fuck. We're midway through trial. We don't
This
know
is-
what's going on. Like,
this
if you
is
don't
what-
know what's happening, then
You know
you should not
who's
bring
supposed to
this.
be. You know who's supposed to be rock solid on their presentation and who's allowed to be fluid. The prosecution is supposed to be rock solid. They're not supposed to be able to change. You know who's allowed to change under the rules? The defense. All the time.
yeah,
I can poke any hole I want. Like this is a, I know that people have opinions on ARCA being comparative.
and the thing is, at this stage of the game,
You're out of your fucking mind. Like
at this stage of the game, the Commonwealth should be sure of what happened. And anything the defense says should fall into one of two categories. Category 1, I don't care, that's bullshit. Or category 2, oh shit, our case is is broken and we need to fix this. And we need to fix it by making the case go away. It
You
should not be
cannot-
that they're still figuring out what's happening.
Yeah.
And
you cannot adjust your data and presentation on the basis of the fact that holes are being poked in that.
The other thing is that they should absolutely, at minimum, be having a voir dire as to how this guy determined what Ian Whiffen testified about.
Mind you, we've already had a full trial. We should not be having this discussion. It was bad enough. That's the argument. We'll listen to the argument. I have to start pulling up super chats. I hate doing this. I have to
No,
start
you
pulling
don't.
up some of these. No. I hate doing it like when I'm backlogged like this. I have to start pulling them up, the ones that are non-questions, because I will not physically be able to read all the ones that are backlogged that are non-questions.
Fair.
So I'm going to allow the argument to continue to play. And I will keep questions, and I will try to highlight whatever I can. I promise you. I'm usually very good about reading every single thing that I can. It's just that with how much activity has been going on in the chat tonight, it's very difficult for me to do all of that and still get to all the argument. Plus, we had the added bonus / distraction of Mike, which is a bonus and distraction at the same time. I like to say it's more of a bonus than a distraction. But so we're going to continue to let Mr.
are also bonuses, says the guy with like nearly terminal attention deficit.
Talking to the guy with nearly terminal attention deficit. Like, yeah, there's not a place where we can have conducive linear thought process. Okay, Mr. Brennan, you may continue.
This issue has been clear throughout the case, including my opening statement. And the issue is that clocks are different. There is a clock in a Lexus that runs on a different time than that of an iPhone.
I heard a very different thing the first time he said that. I heard a very different thing, and I apologize. My brain.
And if you recall, in my opening statement, I talked about the fact that there are variances between those clocks. So instead of a moment that coincides happening at the precise second, sometimes there's a variance of time between the two. So the Lexus clock could be at a variance with an iPhone, but the event still could happen at the same time, given the clocks have different times. The defense provided a report by a person by the name of Mr. DeSorga, a noted expert witness who they've listed as a witness they may potentially call. Mr. DeSorga wrote a report, and in the report he suggested, based on his analysis, that Mr. O'Keefe's phone always ran late. That means if the text screen data, the black box data from the car, has an event at 12:32:38, 12:31:38, and Mr. O'Keefe's last movements were 12:32:16, last user interaction 12:32:09, there is a variance between those times. We asked our expert to review their expert's report.
But when? But
I cannot fall asleep listening to Brennan, or I will have the world's worst nightmares.
Like, when did you ask your expert to listen to this? Because this was known for a long time.
I'm just kind of amused. They're like, his iPhone is running late. I'm like, what? Why is it running late?
The iPhone's name is Rob. That's why it's running late. Yeah.
No, but this one was only running seconds late, not like
okay.
minutes.
Okay.
See if he was accurate that the variance means that these times would never align. And that's what he did. He studied the data, he studied the waves, he studied the Lexus black box relative to the time. Doesn't change anything, doesn't change the data whatsoever, just adds to the time. What he learned, from his opinion, is that Mr. DeSorga was wrong. He used information from different phones, not recognizing the items that these timelines came from, and that his time estimates are wrong. So then he looked at the time of the event.
Not realizing the time estimates are wrong. So
of the ignition on and off, and he compared that to the Waze data. And when he did, he found that he could identify what the actual differential was. Instead of guessing that it was within the 30-second window, it was somewhere around 21 to 25 seconds. And that 7 minutes before the collision, Mr. O'Keefe's phone was 21 to 29 seconds ahead, which means you subtract that time, which puts it in the same variance that we've been arguing from the beginning, that the collision occurred at the same moment when Mr. O'Keefe last had user interaction, and that reconciles with the data. It does not change the text screen data or the black box information on the car whatsoever. It does not change ARCA's analysis whatsoever. We received this report on May 8th. I was surprised to receive it. I welcomed it.
If I'm a judge and you're in the middle of trial and I hear you utter the words, I was surprised to receive a report from my expert witness, but I still want to use it. You don't have to say anything else. Like, that's it. You don't have to tell me anything else. Because I'm going to say no. No, you are not going to spring this.
I'd be like, Brennan, then we're both surprised today, Mr. Brennan, because I'm surprised you're making this argument. And
yeah, right? There's no way. And let me tell you, there's a difference between ARCA and this. Well, there's several differences. I have an issue with how. Let me get to that later. Someone remind me to get to that. I will.
Turned it over on May 8th. There was no delay. It's been a week now. The defense has had this information. And so this is not an attempt to align anything. Reconcile or identify.
The chat below was a typo.
It doesn't change any data.
They said ARCA was sitting on the scale. They missed an H.
And so this is not a Rule 14 violation. The effort was in response to disclosures that we believe were wrong by the defense expert, and it is clarified and it is favorable for us, and so we should be able to use it.
Did you intend to use it in your case in chief or only if this witness disorder? I don't remember reading that name, so I don't know how to pronounce it.
My case in chief, because we now have this available data. As I said, this wasn't ambushed, isn't something that we sat on. It was in response. Fortunately, we received their expert report.
I want to use something in my case in chief that I found and discovered and disclosed to the defense after the commencement of the trial.
This should have been an easy thing.
No.
This should have been like Judge Canone going, well, obviously not. This should have been the judge standing up or just Alessi gets up and, to respond, and she's like, I don't need anything further.
This was scary to me because at this juncture, one, the questions themselves kind of tell you where she's leaning. She's not going to throw it out with Alessi's comment to Alessi. She might give additional time. That additional time, she might not have to give it depending on how the trial aligns. She wants to know if it's being brought up in rebuttal because that might sway her opinion on how much time to give or if she needs to give time or if she doesn't need to give time. And then she's also looking at the calendar. So she's wondering how she can deny the motion, let it in without being too prejudicial to the defense, which I don't. This is where my thought process is, trying to think from her perspective. I just don't see how that aligns with any experience I have in courtrooms.
Mm-hmm. Which caused us to focus more closely. And now that we've identified that variance, rather than having an open variance of 30 seconds, we should not be precluded from favorable information that has been provoked by a report by the defense.
Okay.
No. You don't. No.
No. Okay.
We should not be precluded from information that's been or favorable information that's been provoked by a report from the defense. When did you receive the report from the defense that provoked the information you seek to elicit?
Yeah. Oh, that was years ago? Well, then the answer to that is
everything that you are offering is in response to a report from defense. I get that. I get it. And you know what? If this was in relation to information provided by ARCA in this subsequent thing, like if ARCA had given you information on May 7th and you were like, shit, I need time to respond to this. I'm like, all right, okay, you got it May 7th? Fine. But this report that you're talking about, this time slip, you had a lot of time. You don't get the benefit of the doubt. There's too much at stake for you to get the benefit of the doubt. And to be honest, people that are going to jump down my throat on siding this way versus ARCA, you know who does get the benefit of the doubt? Who does get the benefit of every doubt to make their case? Who faces the possibility of conviction? The defendant gets the benefit of the doubt. You, the weight of the state, the resource of the state, you don't get that benefit. Unless you're in this courtroom.
Yes.
I'll do it quickly.
Okay.
Attorney Brennan has provided a lot of information, and he has accurately provided information, but he's got the time completely wrong and the significance respectfully completely wrong. I'm going to hit his 4 categories quickly. He said he referenced
Brady Goat is
Mr.
big
DeSorbo,
mad.
who is a defense witness. Two points about Mr. DeSorbo. First, Mr. DeSorbo provided his expert report within the reciprocal discovery deadline.
Okay.
And he provided that report months ago.
Okay.
So if, as I heard Attorney Brennan, he's saying the reason why we're getting something on May.
And you can hear her being like super
I know.
dismissive of
I'm
this.
so mad at that. Kudos to any lawyer who stands up to that and keeps on arguing, because it is really hard. It is really hard.
And there's been point where you're just like
side note, I have known lawyers. I've known at least one lawyer, probably the only one I know with the level of courage to do so, and I do it in a very I do it in a passive aggressive way. I stop speaking until the judge looks up at me. But I have known a lawyer who has basically said, Your Honor, I just want to make sure that you're hearing what I'm saying because I see you writing notes or I see you looking down your page. And it's a dangerous game, but it's one of those where I don't know. Sometimes you got to fight it.
I had an instance where a judge said to me, "Mr. Runkle, I'm not going to rule in your favor. So can we move on?" And I said, "No, we can't, Your Honor, because I'm not talking to you. I'm talking to the Court of Appeal right now via the transcript." And the judge acquitted my client. And I'm pretty sure it's because he didn't like what I had to say to the Court of Appeal.
There are cases where I have stopped a judge who has told me to move on, and I've said, "Judge, I need to put my objection. I need to put the whole objection on." And I said, I know that you have made your ruling, but it does not necessarily mean that I don't need to have a clarifying reason on the record for seeking review elsewhere. That it doesn't with different judges it plays differently. The mature judges understand. The ones that are still feeling themselves out and have the ego trip, they get very, very, very snippy at you.
Feeling themselves, you say?
Just high and mighty on their high horse.
A8 is because Mr. Burgess supposedly is responding to that. That was months ago. Okay. The more apt point is, or
she's
even
so
more apt point is,
dismissive here.
Mr. DeSorbo was responding to the information of Aperture. It wasn't like Mr. DeSorbo was coming up. He was rebutting as defendants do. So, and it's Mr. DeSogra, D-I-S-O-G-R-A. Again, D-I-S-O-G-R-A. So that's an important point with regard to Mr. DeSogra. Now I want to go to Attorney Brennan's comment about clocks are different. I agree with Attorney Brennan on that. The shortcoming for Attorney Brennan's argument, however, is that the clocks are different concept has been in existence in this case for over 6 months. I can give you by memory Mr. Whiffin's report of December of 2024, where his report went into the different clocks and what their significance was. So that is almost 6 months ago, at least 5 months ago, the issue of different clocks has been in existence in this case. So therefore, the issue of different clocks dates back to then. But even more fatal for the Commonwealth's argument is that Mr. Burgess himself issued his report and talked about the difference in clocks. He already knew it. He already had it.
Did he testify to that last time? Did he testify?
Aperture was not part of the first.
Why are you asking that question, Judge? Because every fucking time that comes up, the trial last time, do you know what she says? This is a new trial. Every time.
All right, I thought Burgess was, no?
No, neither. Okay. No one from Aperture was.
I knew Aperture was, and I thought he may have been something. The name just sounded.
Neither Burgess nor Welcher were part of the first trial, but they were retained. Aperture was retained, I believe, in October of 2024. Okay. And at best for the Commonwealth, Aperture had, and Mr. Burgess and Dr. Welcher had Mr. Whiffin's report that talked about the clock differences. So the clock differences cannot be, as the Commonwealth is proffering, some sort of new information that caused Aperture to provide a new report. This variance that Attorney Brennan talked about, it's called the clock drift. A more layperson's term is a variance of time.
I like how he's like, the more layperson's version is a variance of time.
There's a whole section on clock drift. That's not a new concept for him. He's just changing the drift.
Okay, so what I'd like to do, because I want to address the other issue and I don't want to keep people here too long, can you wrap it up, Mr. Alessi, or is that?
You don't want to keep people here.
I know.
Like, you've got somewhere better to be than the murder trial? Like,
I had a judge hold us until 8 o'clock at night for his ruling. And though I don't want to keep people here, bullshit this is really recognize the position you're in. All I'm going to say. We ask a lot of litigators. We ask a lot of lawyers. We ask a lot of court staff. We ask a lot of judges. We ask a lot of court personnel. We ask a lot of the bailiffs that are there. We ask a lot of them because they have a very important job. and you don't get to do the 9 to 5. You never do. I have no doubt that she's not doing 9 to 5. She's doing more going back in chambers, but can we wrap it up?
So, Your Honor, the last point I wanted to make, and I think I heard Attorney Brennan correctly, is he said he was surprised that he got this report dated May 8th. That's what I heard. So if the Commonwealth is surprised that they got it, that should mean, to me, Your Honor, be an outstanding, fetching reason to not allow it because they're surprised to get it. And I can lastly say this, Your Honor, there's nobody that's more surprised to getting this than the defendant when we got it on May 11th.
Okay, thank you. The other issue about calling your expert on rebuttal, Mr. Brennan, based on the late disclosure of the ARCA materials. What's your argument on that?
I won't iterate the entire past, but Your Honor has found discovery violations. Your Honor has found that I want to phrase this properly.
Side note, this is where past violations can come up to bite you in the ass. So historical violations of orders or discovery rulings can actually impact how future rulings transpire because the court is allowed to consider past compliance. So people were bringing that up earlier today. We're like, how dare he make this argument that it's it's a different issue entirely. He's allowed to make arguments of compliance with court orders. Now, he's not allowed to hide behind them for his own failure to comply. And this is conflating the ultimate issue, which is ARCA is not this, and that this is not ARCA. But I don't know why he's allowed it. This is a lessee's motion, by the way. So this pisses me off.
The efforts of the defense.
Oh no, this part is the ARCA motion. This is Brennan's continuing argument on ARCA.
Work improper. And inevitably, we've now received an extraordinary amount of discovery on the most important issue in this case, well beyond the discovery deadlines, without any excuse. And the court, understandably, has overruled the government's objection and has stated that it's going to allow the defense to proffer 2 expert witnesses in a very complicated field, in an issue that is the heart of this case. We're going to allow them to testify, despite the fact that we have not had the time to review, to prepare, and to address it. The Commonwealth has the burden of proof. The Commonwealth has an obligation to prove its case beyond a reasonable doubt. And this isn't simply late disclosure of some evidence. This is a massive amount of evidence of the most critical issue. And so we provided this information.
Oh, shit. Damn it. No, I didn't mean that. No.
And essentially have almost a rebuttal to a...
Hang on.
Somehow...
If either of these ARCA witnesses testify. And so we believe we are entitled to have our expert.
Sorry.
4 opinions that they gave at the beginning. There are.
What I was going to say is how many of these things are new? And you haven't pointed to any of those. You just say that you're being hit with this, but you haven't actually gone out and explained to me what the opinion is that's new.
Studies, there are demonstrations, there are experiments. This requires not only review, but an analysis, testing, vetting, and then preparing testimony to address the claims made by the defense experts. Not to get into a battle of disparagement, but our expert has found extraordinary issues.
Not to get into a battle of disparagement, but here I go again.
Every time. Every
time he says, I don't mean to do
Every
something, you know that is exactly what he's doing.
I don't mean to call Mr. Brennan an asshole, but Mr. Brennan is an asshole. Every time.
And every time he denies that he's going to do something, he turns around and does exactly that thing where he's like, I don't want to deny them their ARCA experts.
Oh no, it's even better. It's even better. I don't want to deny them ARCA experts. I don't want to deny them Dr. Russell. I'm not going to call the children. I'm not going to talk about Aruba. I'm not going to do that. Every single one. Every single one. Judge, I'm not going to, I've been more than forthright in my discovery obligations. I haven't surprised them with anything. I've given them above and beyond what I'm supposed to or have to. They've received everything in a timely fashion. We've complied with all deadlines.
And I say from the chat, I'm not opposed to Mr. Betterow joining the defense, but and then he proceeds to oppose it for 2 hours or whatever. Every
single time. And I will understand. I understand. Look, on the ARCA stuff, I understand the Commonwealth's point at some point in time. Like, look, you guys knew early on that they were going to be your experts. You didn't memorialize it. We all know why you didn't memorialize it. Stop starting to parse words and stop doing that and start arguing how it's not an impact on the prosecution. Like, start shifting that argument. Stop denying that. I get that. But this with Hank Brennan, it's every fucking argument. It's not a one-off. It's not here and there. It is every single expert, every single argument, every single witness, everything he has said he is not going to do because it would be unfair. 5 minutes later, he's doing it. And Yannetti. So here's the thing. Yannetti, I'm pretty damn sure Yannetti got an instruction not to mention Michael Proctor in some of these questions. And what does he do? He asks a question. The objection gets sustained. And the next question goes, was it Michael Proctor? Yannetti jumps over that line pretty well too. He's doing it. With this judge, she doesn't care if you jump over the line, depending on who you are.
I hate this trial so much. It is.
This is not what trials are supposed to be like. This is a fucking joke. And I'm sorry that I get animated, and I know you do too. There's so much angry. It is so angry.
Material. And some of those concerns lead him to need, in his opinion, to actually conduct his own tests to demonstrate the failures of these ARPA witnesses. That's going to take time. You've heard from the ARPA witnesses themselves that the amount of data they received, they estimated they needed 5 weeks. And they were given 5 weeks despite all the discovery deadline violations. They were given 5 weeks. We did not get the report until May 7th. And so we believe we are entitled to have our expert review all the materials, do his testing, provide opinions. None of that is going to happen anytime soon because he still has not finished reviewing all the materials. There's many, many gigabytes. He is in a difficult schedule. He is away tomorrow, Saturday. We were going to try to begin to prep at the end of the weekend. There is no way he's going to be able to testify anytime
Rob,
soon
check the private
and
chat.
have all of this validation and vetting and testing.
So what is it exactly you're proposing?
So what we would like to do is have him testify about what he has prepared, that he's had adequate time to prepare. If either of these ARPA witnesses testify and they introduce new opinions, new testing, new demonstrations, he should be able to continue reviewing the materials, actively engage his own testing now, so by the time the defense case is over, he will be prepared to come back and address the new issues, not the older issues or regurgitate his testimony, but to address any new issues that were provided in violation of discovery orders, and so that he can then address the jury on those specific new issues. I see no other way of this expert fairly being provided, presented to the jury. The unfair prejudice cannot be cured in any other way. So we ask that he be able to continue his review, offer rebuttal opinions on anything that is new, and not to encroach on anything that's been previously.
That's allowed. Like, I don't know why people are shocked at that. If ARCA brings up an opinion that is not simply a rebuttal or refuting the opinion offered by the Commonwealth, but if ARCA offers an opinion of their own, independent of rebutting what Commonwealth said, that's truly a unique and new opinion, the Commonwealth is allowed to rebut that. That is the purpose of a rebuttal case. But what I think Hank Brennan's conflating here is he's not actually asking for rebuttal. He's saying that Aperture is going to say this, ARCA is going to say they were wrong and here's why. And he wants to go on and have a new rebuttal on this is why they were wrong for saying that we were wrong.
Yes.
You don't get to relitigate that issue. You have to advance it and narrow the scope at each turn. He wants to go back and have a whole new bite at the pie. And the way that Bev crafts her ruling, you would understand that maybe we are narrowing it, but I can guarantee you that's not what's happening.
Can Burgess testify after Welcher?
No, because Dr. Welcher relies on Shannon Burgess's information material. It would make no sense. I thought about it. It makes no sense to the jury, his presentation, unless Shannon Burgess has an opportunity to provide the background information.
Right. Mr. Lessie, I'll hear you on this.
Thank you, Your Honor. I think and I understand that it's very well understand the time of the day, so I'm going to do this hopefully efficiently. When we're talking about ARPA and the information of ARPA, it's very important analytically to put them in their two proper buckets. The first bucket is the information and opinions of ARCA that have been in existence since February of 2024.
Yeah, let's focus on the beyond. Let's focus on.
Okay, good, because my pithy conclusion is there should be no prejudice on that.
And I don't think the Commonwealth's even suggesting that.
So we're focusing just on the quote, new information bucket. Your Honor, it's very important to understand.
So if she enforces the ruling appropriately, where Aperture is allowed to come on and testify in rebuttal to the new opinions, then that is fair. That's fair practice.
But that's not where things are going.
That's not how I feel this ruling is, and that's not how I feel Hank Brennan is arguing it. And the funny thing is, Hank Brennan is using the right words. He's saying the right words. But if you put them in the context of what Alessi is saying, of the opinions that they had in February of 2024, you're saying the right words. But I feel like when rubber hits the road, you're going to be asking a whole lot of questions based on your conduct at this trial, a whole lot of questions that are just trying to regurgitate what you said before.
Well, and the thing is that the Commonwealth gets to go first. They shouldn't also get to go last. Like, that's kind of the trade-off, is that the defense gets to go last. And now we're seeing a situation where the Commonwealth gets to go first and last.
They do get to go last. Commonwealth gets to go first and last because they have the burden of proof. Just like in closing statements, they get a rebuttal proof or rebuttal close.
Yes,
but the defense does not.
They don't get to just call a new thing.
Oh, that's true. You don't get to keep changing your evidence. No, you don't get to do that.
This is what they seem to be getting, here is we just get to provide more case. So, yeah. Beautiful messy ball. I don't think that was. Did you see the asshole clip?
Yeah, I don't know.
I don't think that was her.
I don't know who it was. I don't care who it was. My thing is how it was handled in court after it should have been addressed. I think it might have brought about the admonishment. I don't know why. I think there's jurors that are being reported as laughing or snickering. Which is frustrating. It's very frustrating because it's very demeaning, even to the case itself. If you're on a jury, I don't care if you think the Commonwealth is a joking matter or not. There is family present in the courtroom of individuals who have died or who have their life on the line. Don't laugh at it.
To be fair, if you're the Commonwealth and you see the jury is laughing at your case,
you're in trouble.
Might be time to wrap it up. Like,
So let's see.
That what ARCA is doing is in response to the testing of Aperture. ARCA did not come up with new approaches. We, again, to state the obvious, are the defense. We get to rebut what the prosecution has put forward. And so what ARCA has done with the new information, new testing, is simply to rebut what Aperture has done. So I do not understand the length of time or the lift, if you will, that's being proffered for Aperture. Now with regard to the time period, Your Honor has already determined what the appropriate approach is for the new information from ARCA. When Dr. Rentschler was on the stand, and Dr. What you said, when can you get me the information? And they said, I think it was May 6th or May 7th, whatever, and they met the deadline. They did it.
Alessi is wrong in this point when Alessi says that Judge Bev is correct, that Judge Bev left open that for now this would be the appropriate. Judge Bev did make the ruling that this was a violation and that at the very least the report had to be provided so that there would be additional time given. It does not mean that the entire sanctions argument was foreclosed. So I think that this part, she left open the possibility of additional remedial action. Now it's remedial action. It's not something that's punitive to the defense or one side or the other. It's supposed to remedy the unfairness that was befallen the Commonwealth by the failure to give that information earlier.
We proceeded along with the trial with that information. We complied with that request to continually try to claim that there should be ongoing remedies of something that's already been decided, I do not understand.
So I did leave open. I did leave it open to address.
You did leave open the time, but Your Honor didn't leave open that you were going to continue to address this matter as if the defense is making perpetual violations. There was a determination made, and then the question was the remedy. So I'm just addressing the Commonwealth, positing that somehow there's continuing violations. My final 2 points. What Mr. Brennan is seeking is improper. What it's seeking is the most extraordinary situation, which is have Aperture come before the jury, testify to certain things, have ARCA have to come on, and then have Aperture come back and essentially have almost a rebuttal to a rebuttal as of right. I do not understand that process. I do not understand that proposal. It inverts the order of proof. It prejudices the defendant because it almost ipso facto gives a double re-rebuttal, sur-rebuttal to the defense. I believe, Your Honor,
To
the final point is,
it's a
if
prosecution.
Yep.
Your Honor is inclined to give Aperture more time, and I haven't even heard a deadline yet for Dr. Welcher. It's still open. What I would recommend, Your Honor, is that we follow the proper order of proof. We determine when Aperture can conclude its review of the ARCA work, and that there be a reflection that keeps the order, namely that the prosecution comes in with Aperture, Dr. Welcher, and Mr. Burgess, and then the defense, as part of its case in chief, puts on ARCA, and we make the determination as to what happens there. Otherwise, what we're happening is here, it's almost a self-serving matter where the Commonwealth is getting to put on certain witnesses here from our witnesses and then have an automatic rebuttal. And Your Honor, I just think that's improper and prejudicial. There's another, and importantly, it's a burden shifting to the defense.
All right, so I have a question for you, Mr. Leslie. Are you still thinking that if the defense puts on a defense, that will take roughly a week and a half for that to take place?
That is our best estimate still, Your Honor.
And not holding you to this, because obviously you have no burden. If ARCA is part of that defense, when in that week and a half time frame would that be?
We haven't made a final decision, Your Honor, but we're pretty close that it would be toward the end.
Okay. All right. I needed all this information now, so I appreciate it. All right. Thank you.
Okay. Without delaying the the back and forth, let me do this. Ruling.
So before we recess, I appreciate that council provided me with the information. Mr. Leslie, I got the 2 reports that you had that were incorporated in what the Commonwealth had given me.
Sorry, I pulled up a question and I didn't mean to. ABC's docket, they are Bubbles. Can the defense file a written objection for the record? Yes, you can. You can always file a written objection or motion reconsider. You can. It's a waste for the trial judge, but it's not a waste for the appellate court.
A few minutes before, but I appreciate that it was pointed out here. We've had full argument on this yesterday and today. My findings for the record are that the defendant has not persuaded me of undue surprise or unfair prejudice by this.
How?
What the fuck?
How?
Yeah.
And this is why I cannot tell you how badly I want to see the reports themselves, because she had the opportunity to review the reports, so she got to see the actual words on the page. If it's as simple as, hey, I had it in this paragraph but not this paragraph, that's not undue surprise. Or hey, there's a suggestion there might be time drift, and then all of a sudden it's like, oh yeah, there's time drift. But to say that the time changed from 12:31:38 to 12:32:16 after I've cross-examined 2 of the most impactful witnesses on the topic of time.
Yeah. And
you're going to try and say I'm not surprised by that?
So, for the chat, like, let's as an example here, in Canadian law, there is a thing about when they can amend the information, the charging document. And in theory, they can amend the information, like the charging document, right up until the verdict. Yeah. However, they can only do that if there's no prejudice. So as an example, let's say the charging document alleges that, like, my client, and I can't use Bob anymore. People have been giving me grief over Bob, so we're going to go with Rudiger. My client Rudiger, is alleged to have, assaulted his ex-wife on January 29th, right? Okay. So I'm able to prove that Rudiger was out of the country January 29th and that he had an alibi from like January 1st to the 30th. And then afterwards, like having heard like my entire case of arguing like couldn't have happened this day, they go, oh, by the way, it was February 1st. We just want to change it to February 1st. The court's going to be like, no. The defense ran an entire trial based on you said this day, so you don't get to change that now just because now it's inconvenient. You alleged that it was on this day, and you're stuck with it. Similarly here, the prejudice is that they let the defense run. And the thing is that sometimes the prejudice can be, I would have run a very different defense.
Now, here, let me change the facts. Let's say that it was a stipulated date. Let's say that you both agree that an incident transpired. It was just a different date. And you have both put on evidence and elicited evidence and evidence of your own that it was a specific date. At that point in time, the information can be amended because it's not prejudicial. You both have offered evidence to that effect. Right?
Yeah. Or, but even just, you can get things where the defense might have run an entirely different argument if they, if they knew, right? If that was the, so let's say I've got two arguments. One, like as the defense, I might be like, well, they've got the date wrong. The allegation should have been on February 1st. But I might have a whole argument about it wasn't my client. It's an identity issue. It might have been somebody else.
That day.
But I'm running the argument on the basis of, listen, you can't prove it was this day because it didn't happen this day, right? So that choice to forego the identity argument and instead run the argument of that this was a different day, it's, I'm prejudiced because I would have made those other arguments. And I didn't argue any of those issues, which might also be valid issues, because I can't really argue both. I can't argue, so this is the problem here. Is it's not just like, oh, there's an error and they should be able to fix it. There's an error and the defense has been, playing based on the rules that they've had.
Yeah.
And now they want to change everything. And they're like, no. So, think about it in soccer. You've got your goalposts and, you kicked the ball and you missed the goal. And so rather than going, okay, well, I guess it's, we've lost the ball because we kicked it off out of bounds. It's like, actually, ref, can we move our goal 30 feet to the left? Because then that would have been a goal. Like if we move their goal 30 feet to the left, then we scored. And that's really what he wants to do here. So, that's as far as we're going to get into sports ball.
Well, that's the feeling you get.
Information, and I don't find that there's delayed disclosure. Of course, all of this is ample game for cross-examination. Certainly as to what Mr.
You mean the
Burgess knew.
cross-examination
You've been
going to
cutting off.
interfere with, and you're going to prevent them from, I'll allow a robust cross-examination.
Well,
Brennan, I
let me tell you,
object.
and
Sustained.
this is where Alessi didn't make this point preemptively, where he should have gone in there thinking that this would be what Judge Cannoti would have done and said, there's a point where I can't cross, because once the jury is left with the impression, because let me tell you how this plays out to a jury.
The jury sees this as the defense is weaseling.
Correct. Yes, because the prosecutor puts on the expert, and the expert says, at first glance, it was 12:31:38, but I did further review and narrowed it down. And after further review and additional time in my review of the evidence, it came down to 12:32:16. The defense gets up and says, but it was originally 12:31:38. And the expert says, but that was based on past review and I had additional information. And the expert says, but hang on. Somehow Sandy got bumped on. But it was based on past information, I had additional information. And that the new opinion is the correct opinion. And you, defense counsel, are being weaselly by trying to say that new and correct opinion should be given less weight because somehow it's different by 28 seconds. Jurors are more naturally drawn to the expert's final opinion is the only one I should give a shit about.
Yeah.
Which it just means that
they want to. They're like, oh, you can explore when, whether they violated the court order. I'm like, that is absolutely the kind of thing for a voir dire. And it's like, you want the defense to go in blind and cross-examine about whether this guy violated a court order without like any background or basis, or
documentation or anything. Like I'm supposed to trust Hank Brennan. When Hank Brennan sent the report, did he send all communications between him and the other expert between when the report was produced and otherwise? I don't know that.
Oh, this is greasy.
You cannot, and quite frankly, Judge, you giving me your promise that I can explore this on cross isn't worth shit.
She doesn't keep that promise
on how you've treated me during cross. Like you have said that I can explore my Bowden defense, but every time I try to do with Dr. Scortibello, cut it off.
Yeah.
And you don't even let me come to sidebar.
I think that they are building to an argument that might, and this is always a tough argument to make. It is very difficult to argue bias.
I know where you're going with this. I don't.
If I'm them, I'm working on the bias argument for the appeal.
I'm trying to, but I'm not putting eggs in that basket. I'm going to throw it at the wall. I just.
Oh, it's not the only thing you include, but you include it.
Oh, you include it. I agree you include it. And you go ruthless with it.
And the thing is you do that because you argue all of the other violations, right? You argue, that there's dozens of different mistakes she made. And then you add, and this amounts to a pattern of bias. And, all of these things. I mean, maybe they can... Maybe they can put the judge under oath and ask her if she if she said asshole.
Good luck. My God.
They're never going to get that, but it would be a fun argument.
It's a fun thought experiment.
Yeah.
Why he looked at it, when he looked at it, why he changed his report, and violation of the sequestration order is all for cross-examination, and I will give you a lot of leeway with that, Mr. Alessi, but I'm not having a voir dire on.
I'll let you fish around in front of the jury to make it look like you're fishing. That's the problem. Is doing that in front of the jury with questions you don't know the answer to. It looks like you're trying to be shady.
Well, and it just risks getting answers that the rule is you don't ask a question you don't know the answer to. And she's like, I will let you ask any question that you don't know the answer to.
You know what?
In front of the jury. you know,
here's the other part that's ridiculous. She gave voir dires of Dr. Russell. She gave voir dires of who were the other experts? She gave voir dires preemptively.
Every voir dire that
She
like
gave
Hank asked
every
for.
one of voir dire, and the voir dires were given not because of a discovery violation. They were given just because Hank said it was unfair. He wanted a voir dire. He wanted to challenge their expertise. That is, you know what? Fine. If you're gonna do that, if you're gonna give voir dires for everybody, give it for everybody. What the fuck are you doing? You're telling me that you're gonna tell Alessi that he's got to go up and cross-examine a witness and fish on information that he doesn't know, and you've given Hank Brennan the opportunity to cross-examine every other witness under the sun for hours on end, and you can't make the damn time for a voir dire on these issues when the expert comes in and says, oh, by the way, I'm changing the time of my incident from 12:31:38 to a time that perfectly aligns with Ian Whiffen. I don't care if that's factually true or not.
She's busy. She got places to be.
That's the other part. People, if anyone wants to fight me on the whole, but what if it's factually accurate? I don't care, because the integrity of the system is more important to me than the outcome of one particular case. And if you are going to risk the integrity of the system by allowing people to gamesmanship or play games with deadlines and dates and disclosures, and if you're going to allow that to occur, and you're going to try and do it on the backbone of, well, we got this one case right this one time, then you need to find a different profession. You just do. It is infuriating.
That.
I'm just stunned.
Mr. Alessi, I can.
Yeah.
Tell you, obviously, you've got a great facility for cross-examining on the underlying information here. You've done fulsome cross-examinations. I have every confidence you can do it here again. But if after the direct, you demonstrate that you need further time, I'll certainly hear you on that. And more importantly, perhaps.
It's not that you tell me you need further time. If you demonstrate, if you prove to me that you need further time, if I think that you have laid some foundation to allow for further time.
And you know she's not going to allow it because, like, this is so bullshit. Like, just do the right thing,
Judge. If you feel that the testimony of Jen McCabe and the others that you've mentioned is critical and that you need to recall them, I'll hear you on that as well.
Let me tell you how impactful that is.
It's not recall them. It's, oh my God. Like, oh, give Jen McCabe another chance to fix her fucking testimony. Like, really?
There are certain things you can't fix.
And Jen McCabe
swing
free of all of the orders restricting her from speaking to other witnesses, from whatever else.
I don't think she was released. I don't think she was released.
I thought she was released.
I don't think she was released. She said you were free to go, but I think the sequestration orders remain in effect until there's a specific release. But
I mean, I'd want to check, because if she's been free to like watch coverage.
If Jen and that's the other part about it. If Jen McCabe comes back on the stand, and if I ask her, have you looked at any of the testimony in this trial, given her testimony in the first
I don't believe her.
Yeah,
I believe her 0%.
Zero. Like zero. If there was a percentage less than zero, it would be that. Oh, so horrible.
So regarding Dr. Welcher, as my understanding, the request yesterday was for, and it's been a request, I think, a few days. We've addressed it at sidebar, and I found that it wasn't the right time. Let's see how much Dr. Welcher could go through. I understand Dr. Welcher will testify in the Commonwealth's case in chief next week or so, Mr. Brennan.
Hopefully next week, if not
all right.
the day after the holiday.
And that will be for all of the material that was provided to the defendant initially, right, by the Commonwealth's discovery deadline?
Correct.
And what you're asking for is that after ARCA testifies the new information, you're asking for rebuttal, right?
Yes, limited to the new information.
All right, so I would allow under these circumstances a limited rebuttal, and we can define the scope after we hear the testimony of ARCA. So those are my rulings. Your objections were noted. I'll see everybody on Monday.
She's like, I know you object, and I don't care. Oh my God. The waiting of this is just
sorry. It is pretty remarkable how those rulings early on in watching this trial, I think I was very, very, very careful in drawing the line and giving her the benefit of the doubt on a lot of rulings where people attacked me for giving her the benefit. And same with Hank Brennan. I did the same thing. I gave him every benefit of the doubt. I was in his corner. I was like, new kid on the block. You got it. No problem. I'm gonna be with you. I'm gonna roll with you. I'm gonna say that this is good if this holds up. But at some point in time, this case
the shit starts to flow out of the bowl after, like, the bowl is full.
Where we are.
The shit is coming out.
That's where we are. So, recapping.
There's no more room in the bowl.
So, recapping briefly some of the testimony from today. There was where was it? This guy, the DNA expert. The DNA was taken from John's jeans. There was DNA of various individuals. The one part of this I wanted to play. Oh, and then this lady who has the coolest job in the world, where she gets to do puzzles and rebuild shit and put stuff together. That's awesome.
That is not the coolest job in the world because she doesn't get to build cannons.
I know,
to shoot
has
glasses.
a cool job. But I liked her, no problem. The DNA guy. So there were samples, and there was various contributors to the samples. I have seen other people say it's the first responders. I don't care if there's other people in the DNA. If it's a reasonable doubt, it's a reasonable doubt. Now,
yeah, and if it's the first responders, you know what you do? You get samples from them and you eliminate them.
Yeah, which
That's
they did
what
not
elimination samples are for.
Yeah, which they did not do. Now, Lolly was today's
star.
Star. Well, Lolly
star is the wrong word.
You know, I didn't mind Lolly. I thought he did.
He actually did okay. Somebody basically did brain surgery and removed what, if any, from his vocabulary. I think they just went in with an ice cream scoop and were like, all right, that's got to go. And so what, if any, was purged from his thought processes.
I had no notes. I thought he did well. Now, here's the one thing that I thought was so in 8954. That translates to 120 or what is it? 129.54. All right, redirect.
Brian Higgins or Brian Albert.
Oh no, dang it. No, it wasn't that. Where was it? No, it wasn't.
Scoop.
Jeanette. Hang on. It's Lolly's first question. Yeah, it was this. Oh, yes, it was. So the question I was asking when all the stuff was being asked about the multiple contributors and there being so much DNA on these different samples that were taken from the genes was, to me, who's viewing the importance of DNA evidence and going, seems kind of odd that there would be multiple ask multiple DNA samples or multiple people's DNA and on one sample, 2 sample, 3 sample, 4 sample, 5 sample, like all over the place. Am I supposed to feel like that's weird, or am I supposed to think that that's normal?
Just have one more question for you, Mr. Porto, and I do want to thank you for answering all my questions.
Where was it?
He does look like he is a massive geek and would probably be a lot of fun to play D&D with.
I imagine this. I have no qualms with this guy. I thought he was fine.
Like, I wish I had the ability to recruit some of these people and be like, let's play a Lawyers and Dragons game.
It'd be fun. It was Lolly's first question.
2 contributors.
I'd add Lolly to the group. I bet he'd be fun.
To his own genes, correct?
Could be anybody.
8.1.
Yes.
Was the right...
Some of the descriptions correct.
All right, and who's...
Some of the descriptions...
Brian Higgins or Brian Albert?
Sustained to that.
Experience and years of doing DNA testing.
Yes.
Mr. Porto, based on your training and experience and years of doing DNA testing at the lab, when it comes to samples from items of clothing, is it uncommon or common to have multiple contributors?
That depends. It can happen, but it's possible, yes.
Is it something that's a complete anomaly?
Okay.
It means that there's multiple people who DNA'd on the thing.
You know what Lolly was expecting as the answer? Yeah, it happens all the time. There's touch DNA, there's all this other stuff. There's multiple occasions when there's multiple bits of DNA on one. Lolly did not expect that. Is it common or uncommon for there to be multiple contributors to a single sample? And he really expected this dude to say, oh, it's quite common. And the dude was like, I mean, it's possible. I'm like, oh my God, this is a terrible answer for the prosecution. It was just so awkward.
That depends. It can happen, but.
Yo, if you are getting the answer of there's multiple samples of DNA in this one thing that we tested, and my theory is that John O'Keefe got beat up and did not get struck by a vehicle. And the DNA person who has tested the DNA is asked the question of, is it likely or not likely that there has been multiple contributors to a single DNA sample? And you are like, I mean, it's possible, I guess.
The thing is if I had multiple contributors, I would be like trying my absolute best to nail down who those multiple contributors were. Like, I've seen the theory in the chat of people going, maybe it's the first responders. Great. You call up every first responder and you're like,
eliminate them.
We need to stick a swab in your face so that and if you can get it down to, listen, there are 3 contributors. It's John O'Keefe and ambulance person 1 and ambulance person 2. You can be like, great. But if it comes down to, oh, it's ambulance driver 1 and Brian Higgins, you're like, oh, shit. And I kind of wonder if part of the reason why they don't do the elimination is because they're worried it might come up with somebody else that is awkward.
That's why. That's why. Because they would have to disclose it. That's why. And it's one of those things of, I say that you end strong, you begin strong, you end strong. If you are getting up in redirect after Yannetti has done a good job of cross-examination and saying there's multiple contributors to these samples, right? And you have a very limited window to make a point. The first question you ask is it common or uncommon for there to be multiple contributors to these samples? And this is the answer you get? I'm sorry.
Get out.
Every bit.
And I see people saying the clothes were on a hospital floor. Okay. You still try. And the better thing is can you imagine for the prosecution, you say, did you test Colin Albert against these? It's not a match for Colin Albert. Did you test Brian Higgins? Not a match for Brian Higgins. Did you test Brian Albert? Not a match for him. Okay, did you test? And just eliminate, like, even if you could never figure it out, right? It's just, we tested every single person you think of in this case. And then you can ask.
If you wanted
to. Is it possible that this could be contamination, for instance, from a hospital floor?
It's for me, it's less about the testing the rando DNA. I don't care about testing the DNA. I don't care about that. But what he just did by this answer is he made me feel, one, like it wasn't common to see multiple samples of DNA in one draw. That is the impression I'm given, which means that the doubt that I have that there's another person's DNA on there who could have been someone who involved in a fight with John O'Keefe, the doubt I have is now reasonable. That's what you've done. You have pushed me into that threshold, over that threshold of speculation to reasonable doubt. Because it could have been someone, a first responder. It could have been someone from the hospital. It could have been someone from any number of things. It could have been all of those things, but it also could have been.
It could have been someone else.
Could have been Brian Higgins. It could have been this other person. And
that's the thing is you can eliminate those possibilities. Like, now,
let's say that this expert gave the opinion of, oh no, it's very rare for there to be multiple samples. Then the prosecution's got a better case. Or no, it's very common. If the expert says it's very common, there's multiple samples.
Maybe what he was expecting the expert to say is, listen, the shirt was taken off somebody. It was, cut off. It was dropped on a floor. I'd be surprised if there weren't multiple samples.
That's if that was the answer, then there's two things. One, then why are you asking me to draw in significance to the fact that these are his DNA? Like, why are you asking me to make this conclusion something important in my mind?
Well,
if there's sample, if it's going to have everybody in it.
Well, and I was kind of surprised they even called this guy because all he testifies to is we found John O'Keefe's DNA on John O'Keefe's clothing. And I'm like, no shit, really? Like, you know what? If you check my underoos right now, they have, Runkle touch DNA, right? Like, everything, like, look, my earbuds have touch DNA.
I just took this off. This has touch DNA from me on it. Oh no.
Like,
probably
no
saliva
shit,
on the microphone that's in front of me. Yeah, oh no.
Like, why are they calling an expert to be like, John O'Keefe bled on his shirt and also was wearing his shirt? And I'm like, okay, cool. That's fantastic that John O'Keefe was wearing John O'Keefe's shirt. The shirt that he was found in when he was, yeah.
Bella Bratt, for you, he already testified, but you can't do that if there's more than 3 contributors. He said more than 4.
Yeah.
But that part.
So the reason for that is kind of complicated. They do like statistical analysis and patterning. And if there's too many people, then it basically just devolves into like a cloud of data rather than like, particular groupings, if that makes sense. I'm explaining it super badly, but and the thing is he could say that, like, he could be like, oh yeah, and on the shoes there's a whole bunch of extra DNA, and no kidding, because you walk around and you step in stuff, right? So yeah.
How are you also, Emily? I have 60 chats.
And I just I have back pain and sleep is not a thing.
I have 62 more chats to get.
And I'm interfering.
And there was a lot of yelling. Over cross-examination that's being allowed and cross-examination that's not, and how the rules just are very, very different. Plus, we covered Courthouse Becky. And
we're going to permit a lot of a robust cross-examination of Brennan's objections
that I will immediately limit in 2 seconds. Yeah, no. And we covered Courthouse Becky, and and we went back to Judge Toll's examination of Becky and her lovely observations of the truthfulness of the statements being made and how that ended up right in the arrest warrant.
Okay, this I got to bring up. It's
Jailhouse.
so late, but it's Jailhouse Becky now. Oh, I love it.
Technically, depending on the jurisdiction, the jailhouse can be connected to the courthouse, so it could be both.
She did get bail.
Oh, so it's house arrest Becky.
Yeah, I think it was a $30,000 bond, I thought.
Nice. Is it ankle monitor Becky?
I mean,
they wouldn't put her on a tether.
Let's be real. I don't
They're
think
not putting her on a tether. They're not going to put her on a tether.
She's not a flight risk because she doesn't where's she going to go? And also she's not
God.
It's not like she's at risk of reoffending.
Can I do this one more because
we don't think that Jailhouse Becky's going to hunt Murdoch down in prison and go after him or something like that.
No, but
she's not going to have the opportunity to do another, do another interference.
But just closing the door on the courthouse, Becky. These are the reviews given. So Nancy Grace gave a review from beginning to end. Here's the true story of Alex Murdaugh's double murder trial from a courthouse insider who witnessed it all and more. This book is not only historically significant, it is well written and a treat. Pull up a comfortable chair and be prepared to stay there until the last page is read.
This just
Rhonda
confirms what I've always suspected.
It gets better.
That Nancy Grace is probably not literate.
The Walker family. This insider view really gives the reader insight into what went into this trial a century. What a brilliantly written publication, The Walker family. Becky Hill has been villainized. Oh, this part's great. This is my favorite part. My favorite part from Amazon. Becky Hill has been villainized by Alex Murdaugh's attorneys in the press, and they've made very serious allegations of jury tampering against Ms. Hill. Thousands of words in Behind the Doors of Justice are dedicated to the 18 men and women who served on the jury and who were alternates. Read what Becky said that's caused such a stir. Just remember, just because a lawyer says it so doesn't mean it is. Oh my God. Oh. This part also, this is wonderful. I hope this gets brought up. Yes, we did. I did. They're phenomenal. Yeah. They really are great. The emails between Nancy Grace and Becky. A look at the Murdaugh murders through the eyes of Rebecca Becky Hill, the clerk of court, with 40 plus exclusive photos. She puts it here. Exclusive photos. She explains her extensive role that has caused such controversy with amazing visitors and courtroom personnel she met along the way.
And by cause such controversy, they mean controversied her straight into jail.
And by amazing visitors, she means the people that she allowed to take photographs of the sealed exhibits. I mean, I
am amazed by it is amazing because I am amazed.
I mean, go back and watch Justice Toll asking her that question. So you are saying that that you did not allow anyone to take a photograph of sealed exhibits. No, ma'am. 4-second pause. Okay. Oh no, that is so horrible. Oh, what an amazing thing. Yeah, that was that was phenomenal. Don't get on that all the time. Okay, I've got to catch up on super chats and I've got to flow through them pretty quickly. That's the coverage we're gonna have for today. How there was a question that's really relevant and contemporary in time to the last. I'm gonna start from the end and go back to the beginning. Weren't there buccal swabs done? I don't remember, to be quite candid with you.
There were a few people who got swabbed, but not everybody.
Bubbles, how would you adapt as to the defense being given Bev's ruling? You just make your cross solid. You just go after the cross. Like you have to explore a bit.
Drink.
you just pivot. You do. You'll find a way. Heather, I saw this earlier. Thanks for everyone's kind words. We're all okay. As to the insurance, they will pay whether I press charges or not. Police report was filed. With that, the insurance may even waive the excess on my policy. Have to confirm. That was, you had texted this one earlier. Replay crew today had to deal with cops today after a guy came into our property and attacked my car.
Whoa.
Well, but he was high. ambulance. Now I need to decide whether to press charges. Press charges. I mean, don't let that go by the wayside. Actually, if it did occur, because the other thing is,
if the guy is targeting you, then definitely. But I mean, you get tied up in something if it's just somebody who's, it's hard to say. There are pros and cons.
Marmar, good to see you. Good to see you indeed. I feel like a teen girl because I can't even. Yeah, I felt that way.
I mean, I'm definitely odd for that reason.
As I haven't seen an attorney as shady as Brennan since Jay Hatch. Ooh, that's there. I mean, that's been interesting. I wonder how far the feds have been looking into this trial. Do you think that she is a corrupt judge? I don't attribute corruption.
I don't think she's corrupt. I think she's just leaning on one side.
She favors a side. Corruption is being paid and getting a monetary gain in exchange for a disposition. This is not that. This is someone who favors one side versus the other and who makes that bias very well known. I think that's the Brat for you. Okay, motion for drink goal because I can't take this. I mean, I didn't stop you from setting a drink goal of your own, but also not encouraging it. Ashley King, I say this, like you talk about the process of someone becoming a hostile witness. So some witnesses are presumed hostile. For example, when they're called by the opposing party. Yeah, if they're called by the opposing party, they are presumed hostile. Other witnesses are, they just stop answering your questions. And then you ask the judge. You, generally speaking, you approach and you do it at a sidebar and you ask the judge, they're clearly adversarial to me. Can I please treat them as a hostile witness, treat them in an adversarial manner? And then you're allowed to cross-examine them. You see the judge denying this if they call Proctor, Albert, or Higgins? No, I think they will automatically be hostile. Katie Healing, in union negotiations this week, the employer's lawyer is a Harvard grad. Would you like me to hate him for you on principle?
Let's just go with yes.
Yeah, we're going to go with yes. Someone has watched this channel long enough to know that I have a little chip on my shoulder and I love going against the Ivies. Especially in trial when I whoop their ass. Yes, please hate them on principle. Well, just beat them on principle. Rosebud 26, celebrating my late dad's 100th birthday with FNF. Happy 100th happy 100th heavenly birthday.
Yes, I missed a word there, but happy birthday.
Joanna Kate, should KR Defense test unidentified blood spots? There's a whole lot of complication to doing that.
Yeah, it's actually quite difficult for the defense to get stuff tested usually, because the Commonwealth might be able to just say no.
And the labs that are accessible to the Commonwealth that would otherwise cost thousands of dollars are not accessible to the.
And, but I mean, a lot of these things are samples that can only be tested once because there's just not a lot of material to them.
And then you need comparators.
And so if the defense is like, I want this tested, the Commonwealth can be like, well, that would destroy the evidence. And we say no. And the Commonwealth would probably win on that.
Hope for Gibby in the ICU with my 17-year-old who has brain condition. I'm so sorry for that. He loves Runkle, so I am playing this as he sleeps. Thanks for making me feel less alone.
Hope for Gibby, let me know if there's anything I can do. You can reach me via email. It's in my about section. You can reach me on Twitter. I mean, I'm not sure sort of what, but let me know.
Debbie J with a very generous super chat. I honestly do not understand how the judge can allow this change in timeline. And what can any of us do? This seems so unconstitutional. It's not. It is unfair, but it is along the lines of balls and strikes that judges call every day. And if you think this is an abnormality, you are correct. These types of decisions get made in every trial.
The sad thing of like, what can any of us do is often nothing other than maybe make it worse.
Yep. like I said, you guys are doing the thing. You're educating yourselves and making sure you're aware of these situations and you know how to correct it going forward. White Beta Wolf, Robin Ian, about to hit my 1 year at my law firm as the IT manager and paralegal. I have neurospicy brain and always thought I couldn't do anything in law, but watching you two and EDB changed that. Thank you.
That's the sort of thing that I always love seeing, because I didn't think that there was a place for me in law, and I was just like, well, screw it. I don't know that there's a place for me anywhere else in the universe, so let's give it a try. And I've loved it. And you know, law isn't for everybody, but if you love the law, you're going to you know, it's a great place to be. And everybody, like the people who go and say, oh, you know, I saw you guys, and that's part of why I'm, you know, open about it. It's I got the advice by my career counselor they were like, don't tell anybody, you know, just apply for jobs and don't tell anybody that you're and I'm like, no, I'm going to do the opposite. I'm going to tell everybody, because if they don't hire me because I have attention deficit, then I don't want to work there. So
Emily's heading out. See, Emily, glad to see you. I did want to show what I printed.
Oh, that's lovely.
Isn't that cool? Focus.
That is lovely.
Yeah. That was what was printing when the stream started. Speaking of ADHD brain, that's the ADHD. Icosplex, question for a clear unevenness of rule application. Does the defense need to bring it up at sidebar to be appeal preserved? No, you just make the argument. You keep making your objections and have them overruled. Feral Dragon, my hub was 6'1", 210 pounds, clipped by a car. Shipmate hit head on, 29 miles an hour. Shipmate lost orders but remained active duty. Hub's elbow still hurts some. 2, Brennan realized he's been bobbing. That was a joke from way early in the stream that you don't get right now. Yeah. These incidents are
and
not
to everyone
incident.
who did hear the joke, I at least mildly apologize.
You don't. Minnesota knows my daughter's T-ball team made it to their championship. She just turned 7. Also, you can't tell, but 5 years ago, she had open heart surgery for 4 different problems. She's also on the local swim team. That is remarkable. That is remarkable. And hopefully something she carries with her and makes her stronger and stronger. Lazy L, why is there no oversight for judicial malpractice such as this? There is. It's called other judges, and it's called the Judicial Ethics Committee and various things. I keep hearing nothing can be done, but this is so bad. How can they keep getting away with this crap?
The thing is nothing can be done by us. We're the wrong people to do things, right? Trust. Karen Reed's got an amazing team. And when I say an amazing team, I mean that they're like her legal defense team, who are basically all working this for free at this point. They would charge like my car per hour. Actually, probably both of the vehicles that me and Mrs. Runkle have per hour in value. And she's got a good team. They're amazing. They have their strengths, they have their weaknesses.
Yep.
But they're a good team. Trust that they will do things right, and also recognize that some rando interfering
is not
going to help. So, you know, like the do we know them girlies and Caffeinated Kitty and so forth were getting sued. I will bring attention to it. I will note that they've got a fundraiser. I sure as hell am not trying to file anything on their case. I'm not trying to do anything like that. Emily's saying, isn't Alessi upwards of 3,000 billable? I thought he was 1,800.
1,800 per hour is what I heard.
That's
which
still
is
a lot of money. And
insane.
It's both insane and it's not enough.
Give you context, I bill at $4.25 per hour, and I am high market rate where I am. It's like the lawyers in domestic relations that I've gone against, the most expensive ones that I've ever gone against, $5.50 per hour. That's $1,800 per hour is insane. Civil litigators, $1,200 maybe.
I have to do Canadian to US conversion. So for firearm files, I've often charged $4.50 US per hour. But that's for extreme specialization. The other thing is I also do a freak ton of free work, and I'm doing more free work all the time. So, yeah.
Let me give an example. If Alessi bills at $1,800 per hour, Alessi reading an email is $180.
Yeah.
Like him reading an email is $180.
The smallest increment of anything is 0.1. Robert, do you have access to my Twitter?
So,
I posted something to Twitter. I posted a Valentine to Twitter.
Available.
Or I don't know if you're able to pull that up.
Oh, see that. Give you 0.1.
Give you 0.1.
Yeah. Yeah.
Because, and this is the thing, is like every time you check an email, it's a 0.1. Now, I try to do the opposite of what most lawyers try to do. A lot of lawyers, when they bill things, they will try to bill, I'll check an email from each of my clients so that I get a 0.1 on each of them. And I'm like, I will try to read and respond to as many emails from one client as possible in a block so that I can be like, responded to all of the stuff, 0.2. Yeah. Yeah.
Uncle Dodgeball, not soccer. Bella Brat. Okay, I have to do speed round because I've been streaming for 5 hours. It is currently 1:50 a.m. my time, so I've got to get through a whole lot of
speed run.
these.
I will. Yeah.
Talks, and if KR loses, it's still bad odds for appeal, right? Generally speaking,
Always.
any appeal is bad odds. Even with all of this, yes, still. Makes me wonder how anyone ever had successful appeal. Very difficult. Very low odds. Bailey, with these trials being streamed globally, why aren't judges dotting their I's and crossing their T's? Some are, some are not. Depends on the circumstances, but most do. Mary Smith, are you saying there's no Perry Mason moment in real life? Very rare, few and far between. We all have them. We love them. We hold them close.
Yeah. You get you get very few.
Yeah. You will count on one hand. There will usually be you'll have a hand's worth by the time you've been practicing for 5-10 years. So, Chap's wifey. My homeschooled son loves learning about the different laws between U.S. and Canada. Thanks for helping me understand so I can teach him the difference. Thank you, Chap's
That
wifey.
is awesome.
The Trial Channel. I saw your chat earlier. I did see that you have a YouTube channel, the Trial Channel. It looks like it covers trial in just raw format, so trial coverage. Thank you both for making me feel justified in my rage today. Yeah. Not alone. A lot of things were said. Nikki Zibs. I served on a jury this week. Congratulations. I hope that you enjoyed the experience, and I hope you did a great job. I'm sure you did. Shay B, thank you for remarkable generosity and 50 gifted memberships. And Shay B, thank you again. Let's go green. Turning the entire chat green. Brewberries, the problem is people are trained to think, quote, they most likely did it, so I'm voting guilty, end quote. And they think if they get it wrong, it can be overturned or the innocent project can come in. But a lot of people never get that far. Correct. Mm-hmm. This is correct. Most people think, and their predisposition is person in bad chair did bad thing.
If not
Tammy
guilty,
Lynn,
why sitting in the guilty person chair?
Yeah, that's the general thought process. Tammy Lynn, what are the actual charges against Karen Reed, if any of them have DUI or DWI been addressed? There's been toxicology that's gone through, but those are in there, but I don't think they're significant in nature. The main charges are murder 2 and I think manslaughter. can't remember. Yeah, those are the two primary. KVEL. I served on a jury a long time ago before LawTube was a thing. I was more interested in watching the lawyers to see how things worked than listening to the case. Couldn't resist learning the process. KVEL, that's not uncommon. A lot of jurors will focus on the lawyers and they'll actually make opinions of the case based on the lawyer's conduct. Not technically proper. You're not supposed to, but that's why it's important as a lawyer when people say you're being overly critical or you're judging the way he's saying it or something like that. Yeah, because the jury is too. So you have to be cognizant of what you're doing. Debbie J, I am so angry after today. Judge Bev is a judicial disgrace. I'm not going to go that far. I'm going to say that her thumb on the scale has become more and more prevalent. And I would not have said that 2 days ago. It was yesterday and today that made me really start to feel that more and more and more. And it's really starting to bother me a lot. Mama Wolf, thank you for this. My jury experience showed me how hard it can be to stay neutral. I was surprised that when deliberation started, I had a totally different view than what the trial started. Not guilty verdicts in that case. That is remarkable. Way to go, Mama Wolf. You listened to all the evidence and made your conclusion at the conclusion of the evidence. Molly Piazza, what will the defense have to do to maintain this objection to the new time during testimony? Just keep hammering the issue. They're not going to let it go. It's going to be the forefront of the cross. Unchecked lie. I think the change is more neutral. If the impact was 12:32:16, they have to explain how she sprinted home 12:36:39 in an unfamiliar area. I agree with you. That's why I'm also concerned about the testimony about connecting to the Wi-Fi and whether there's going to be some argument that time is wrong too. SF. Are we really surprised that the judge rules the way she does? It hasn't changed since the first trial. Yesterday
I think it has
today
changed.
Felt
I
different.
think it got worse.
Yesterday and today felt different. Last trial, there was a lot of split the baby. Yesterday and today felt very different. Bella Brat, for you, glad I caught you live. How does the Commonwealth get to keep playing move the ball? Like, what the fuck? I'm so worried about with KR with all this BS. This should not be happening. It should not be happening. Philip Coggins, if the Commonwealth has presented an expert that changes their timeline of the case, how is that not reasonable doubt? The way I explained it before, the jury might simply view that it was not changing. It was basically getting closer and closer to the correct and final answer. You are getting the math more and more perfect. Of course you got closer and closer because you were getting more and more accurate with your readings or with your math. That's the logic. That's how people are going to view it.
I'm pulling this one up. Scary part is that Bev 100% thinks she's a good judge and is making nuanced rulings.
Wait, pull that again. Pull it again. Sean, she absolutely thinks that she's making very, very logical rulings. There is no way that she is, and I went on a rant earlier about the I'll allow it versus I'm going to allow this. And how even phrasing it that way is completely improper. But she's so confident in her own ability to appropriately judge a case that she cannot see how improper it is from the outside looking in. If you put her in front of first year law students and were like, hey, this is what a judge looks like right now, they would rip her to shreds. I mean, I've known any number of lawyers who have looked at her and been like, are you fucking kidding me? What is this? But she can't see it. She's blinded to it.
I'm finding this case difficult to discuss with lawyers because I go to lawyers and I explain to them what's happening and they go, no, that's not true. And I'm like, no, that is definitely what is going on in the case. And they're like, no, like that can't be accurate because that would never happen in a court case. And it's like, but it is.
The other thing I made an observation of that was kind of unique. I've been in courtrooms for the better part of 15 years. In no courtroom that I've ever been in, federal or otherwise, does the call, the docket or the call to hear ye. It never says those of you appearing before the Honorable Judge blank, right? It says those of you appearing before the Circuit Court of the County of Fairfax, blah, blah, blah. Or those of you appearing before the Federal Court of the District of Virginia, the Honorable blank presiding. I know the Honorable blank presiding, but I don't like when I don't like how when they do the call, it goes, all individuals appearing before the Honorable Judge Cannoni. It makes her the court. The court is never supposed to be a person. When you put the robe on, you are supposed to mask yourself. You are supposed to hide yourself, cloth or robe yourself in the law. You're supposed to disconnect you as a person, and you're supposed to put on your judge hat, right? That's why they wear their robes. That's why they sit on the bench. I don't like when everything about a courtroom is tied to the judge. It's Judge Cannoni's court. Like all of you appearing before Judge Cannoni, it shouldn't be that way. You're supposed to be appealing to the court, and the court is acting through this particular judge. I've a little bit drunk with power, and so drunk that she can't realize she is drunk. Raise hail to the Redskins. Can the defense make a motion requesting all communication between prosecution and expert that change the timeline? They don't have enough time to make the motion. To be honest, they don't. It's not possible. And the judge isn't going to give it. Heart killer in Texas. My coworker's father-in-law is Aperture. Oh my. He's been telling me his father-in-law is probably going to testify in this case.
Wow.
Oh.
I have all the questions and I can't ask any of them.
And I'm also going to just say, go in peace. Don't want to be in those shoes. Do not want to be in those shoes. Nicola K. Okay, but come on. You believe no one on the jury never watched the first trial? I tend to think people would lie to get on the case.
They might, but they shouldn't.
They might, but they shouldn't. And usually you can... Lawyers and judges have pretty good bullshit detectors. So I don't know. It's possible, but they shouldn't be. January Garnett, can the defense argue closing that the Commonwealth put forward two experts with different timelines because they can't, that's what they're going to argue. Even they can't tell you what happened beyond a reasonable doubt. That's one of the things they're going to argue. I think they're going to lock the Commonwealth into a timeline. They're going to say it's all over the place. And they're going to say, okay, let's believe their timeline 100%. The one they just
They're going
gave
to lock them into a timeline, but they're also going to point out that it's like, all right, this is their third timeline. So, if they don't know what happened, how can they say they have proof beyond a reasonable doubt?
Matthew Lozensky, what if any experts have you two used in cases? A lot. Like there's a little black book, a lot of them, all the time.
Computer experts, psychological experts, various firearm experts, lots of firearm experts.
Psychiatrists, forensic accountants, psychologists, child psychiatrists, any number of medical practitioners, whether it be dentists, doctors, physicians.
I have less call for like dentists because I don't do family law. So
family law,
family law, you're going to get different experts depending on different fields, right?
Everything. Greg, Rob said he can't get the prosecution timeline. Neither can the prosecution. They've had 4 timelines in the retrial. Yeah, it keeps moving. Baby steps. OT, word of advice. Hug those you love. Watch mental health, even if under care. Living the nightmare of losing the beautiful 22-year-old soul of a close family friend.
Oh, I'm sorry.
For the loss. Thanks for the distraction tonight. I'm very sorry for the loss, baby steps. Just because it doesn't change anything, but we have to get the amended report and testimony in for our case. Judge, I need Natasha Leone screaming bullshit.
And Emily, I pinned your comments, so Rob will see it when he gets there.
See.
It'll be right at the bottom.
Is it true that the Aperture expert trained Trooper Paul, or is that internet things? From my understanding, that one of the Aperture experts was the one who trained him.
But like for 8 minutes.
Which is all the training he had.
I mean, he basically had a conversation with somebody in an elevator ride, and that was his training.
I would just the pirouetting and the.
I mean, it was a real slow elevator, so he's good.
I don't know how fast Trooper Paul is on the uptake, because I don't think there's elevators slow enough for that. Trooper Paul was something else. Bella Brat for you. But for what it's worth, you two seasoned attorneys are saying this shouldn't happen, yet it is. How is there still hope? It's freaking crazy. You keep fighting the fight. You don't stop fighting the fight just because there's no hope against it. I mean, there is hope. Come on. Like, the defense still has not put on their case.
And the thing is that ultimately the jury may look at all of this and go, I mean, there are reports. I don't have confirmation of them. I don't know, but apparently, like, I heard that a juror has sent like a snarky note. Oh, and Emily's saying, take care of your back. I have a massage booked tomorrow, and it's I basically was like, I need somebody who can go in and do like some demolition. I'm like, this is not preventative maintenance. This is like demolish and rebuild. And they're like, oh, we got the person for you. So yeah, we'll see.
Baby Steps saying, thank you, chat, for the prayers and support. You're such a lovely group led by a compassionate leader. Baby Steps, thank you. Very kind of you. And all the prayers go out to you right now. Dandy Daisy, 5280. Was there a short time frame to refile the charges, or could the Commonwealth have taken longer to have new reports? No, you have to decide recharging pretty quickly. I think they had, 60 days to bring new charges again?
I mean, they're going to keep charging until they either get a conviction or a full acquittal.
Gotta stop. Bella Brat. Bev, someone is on trial for murder. Pay the F attention. Quit your sighing and your condescending attitude to anyone. If the judge at Sarah Boone can be above board, you should be too. Oh, this judge. See, the thing is, by covering these trials, you get to see comparators. You get to see the different judges and how they control their courtrooms and the courtroom demeanor, and how some people have the courtroom, some people have the judicial temperament and some people do not. The judge in Sarah Boone's case, remarkable judicial temperament. The judge here, I'll let you draw your own conclusions. Barry Adams, as a theater kid with a bar membership, why is the judge on the nod? My production experience screams bad form. It's yeah. ABC's docket question. ARCA, new info response to Commonwealth's new experts. If the Commonwealth rebuts the defense gets SIR rebuttal. At what point does it end? And that's going to be the question. That's why you can only bring, the Commonwealth has the ultimate burden of, they have to prove beyond a reasonable doubt, which means that they get to bring the last bit, they get to counter the last thing said by the defense. But they can't open the door to new things after that. They can respond and say, no, what that guy said was bullshit. But they can't say that guy said was bullshit and then.
Oh, people are saying I got to finish the note from the juror. The reports online, which I can't confirm, are that apparently a juror sent a note to Bev basically going, could you knock it off and let the defense run their case? And so people are reporting that she chewed out the jury for that.
That was
I don't know
the case.
I don't know if there's any accuracy to it. But I was just like, that if that is accurate, and I say if because I apply like an entire Himalayan salt lamp to that.
Yeah, because think about who would be providing the information, who would have access to it.
Yeah,
either the juror is speaking out of turn, in which case that juror is dismissed, or someone in Judge Cannoni's staff or the bailiff reported that outside of the courtroom, which again, that's tough.
I'm not presenting this as truthful, but I'm saying if that was what the jury is thinking, and you never know where the jury is, right? People are like, how is there no hope? And I'm like, jury could be sitting here just being like, can we wrap this up? We want to acquit.
Could be.
So, I just don't know, right? So,
question, Barry Adams, is easy fix. Bev does what she did, and Alessi has easy cross. Were you wrong the first time, or are you wrong now? It's not that easy. They wiggle. Experts wiggle. They wiggle really well.
Wiggle. Yeah.
It's a pain in the ass. Crossing an expert is really difficult. Usually you have to hire an expert to help you prep to cross the expert.
And experts testify for a living.
Yeah.
And
wiggle.
So it's usually not their first cross. They know, I pointed this out with I think it was Scorty Bello. I can't remember which, where I'm like, she sees this coming. She sees the impeachment coming, and you can see the walls starting to go up as
Oh yeah.
All right, here it comes.
Yeah.
And you have to pin them down. Like, it can be really difficult to do it.
Even in the selection of language, you can watch that dance, and you can see it's like watching two people that are ballroom dancers walk up to each other, and they're about to say who's going to lead, who's not going to lead. And they're figuring out how the choreography works. But the experts wiggle. I mean, they've done this before.
Yep.
Hero Dragon. Bev been fair in motions. She is pissed when she does. Maybe contacts your judicial ethics line. Daughter like Alessi does predicate logic, self-care.
Don't call the judicial ethics line. Let them decide. Don't mess with the case.
Don't mess with the case. Breezy, they had the dog hold him down or attack him while they beat the crap out of him, or they beat the crap out of him and after down the dog. Any number of theories exist. I'm going to let the defense. My theory would
be more there was a fight and the dog. Like,
I'm going to let the defense do the defense thing. I don't need.
I don't know if it would. I don't know if it would apply if I was attacked, but like if you came in and took a swing at Mrs. Runkle, I am pretty sure that both Potter and Zorro would be like, "Yeah, it's on." If you took a swing at me, they might be like, "Yeah, we don't like this guy that much." But I can see that maybe there's a fight and the dog comes in and again, that's. Like, we don't know. It's just theorizing.
Possible. ABC's docket question. How can Brennan say Commonwealth experts can keep working? What the fuck is the point of discovery deadlines in their certificate?
Yes, you have identified the main issue here.
No notes.
It is,
no notes.
No notes.
You've got it. Something strange 910. Why is there a sequestration order? Aren't experts allowed to watch? Technically speaking, experts can watch the experts to whom they are intended to rebut. So you can watch testimony by foundational witnesses, so fact-based witnesses, and other experts that you're intending to rebut. But sequestration orders are still there, and you're not supposed to be communicating with the Commonwealth's attorney. Like, they're not supposed to be saying, hey, by the way, please check out this line of testimony at this point in time right here, right there. Yeah, make sure you do that. So it's very much could be a violation. Jury wouldn't know the gravity even if the Commonwealth to admit the violation. Anyways, need a hearing. Cross might bring it up. I don't know how you're going to get into it safely, meaning asking questions that you know the answers to. Collins famously, how will the timeline change come across to the jury now that they are hearing this?
It'll probably come across that the jury will probably think that the defense is misleading them because the defense has been chasing this timeline theory, and they're going to be like, oh, well, that was never true. Defense, you tricked us. When really it's the other way around. So
that's why it's so prejudicial. Let it in.
Yeah.
Auditory storytelling. The defense's violation were the text with ARCA, right? The defense should motion to compel all comms with Burgess, especially after testified. You don't have time to make these motions. I know that you guys want the motions to happen all the time. It is. Each one of these motions takes at least 1 to 2 hours to draft. Then you have it reviewed. Then you file it. Then it's filed, and they have a response, and then it maybe gets heard. It is not something where I can. The most unrealistic thing about suits that ever occurred was, Judge, I filed this 20-page motion this morning at 9 o'clock in the morning, and it's 11 o'clock in the morning. Let's have a hearing on it now. That does not happen. So they don't have time.
I had a 20-page thing that I for my Supreme Court leave application. I can tell you that was not done in an evening.
No, they don't have time. For example, bond motions, we don't put those in writing. We fill out a form that says we like bond, and we show up and we just argue like hell. Very rarely do you have the time to put into writing. And let me tell you, if you put a bond motion in writing, your client did something pretty fucking bad, because you've dedicated the time to write out in specificity why you need bond. And the judge if the judge receives a bond motion that's 5 pages long, the judge is like, oh baby, this is going to be interesting.
I had a bail argument where the court directed written submissions.
Oh no. God.
It was rough. I was like, oh shit.
Yeah, it's bad. Not good. Ice, baby. Is there any recourse the defense can attempt now, or do they have to wait for possible appeal? My ADHD needs for justice is so agitated. The recourse is to prep your cross. Get ready. Like, the judge has given you ample room on cross. You basically try to find a way to box her in and push that ruling as far as you can. Michelle M. If KR is convicted, what are the appeal chances? Always slim.
Yeah,
Always.
appeals always. I mean, the old line is her appeals are for losers.
Because the burden shifts. The burden shifts. The burden is in your favor now. The burden is against you at the appeal.
You've got to prove that there is a reason for it.
Heather, guy was not targeting us, just a random guy. Govern yourself accordingly. Be careful. 9-Inch Nails Gown, 1994. AJ has said trial costs have hit over $5 million, but they are doing it pro bono anyway, and having the firms eat expert costs not covered by the GoFundMe. Dedicated lawyers. XCDA have good.
Yeah, that's impressive.
XCDA, thanks for being a mod, by the way. Have a great weekend. Thanks for the stream tonight. Lee. Oh yeah, by the way, the 4843 of you that are here, 4,843. If you have not hit the like button, please do. I would like to see this get to 5,000 likes if we can. I've not done that on one of these videos. It'd be awesome. Leah M. I feel like the 1800 is low. No, New York City. I know Yannetti is up there in Boston area as a top tier, and AJ is most definitely more in LA. Maybe double that. I don't think you guys are processing how much $1,800 an hour is. Like, reading an email being $180. You send your lawyer a text message, $880. $1,800 an hour would result in monthly invoices at a trial like this of probably $250,000. You know what? For 1 month of trial time for this trial team, I'm thinking, what, $500,000 a month?
Yeah.
For all the hours in court? More than that. Yeah. No. That's insane. That's crazy. Potato. Not going to lie, everyone in Canton seems to be drunk too. A lot of drinking. 9-Inch Nails Gal. They announce it like Judge Judy in divorce court. They do. Docket. Maureen from Monterey. Have Lori Daybell make the motions. She's motion happy. God, I've heard. Ariel Wyatt. Conspiracy thought, what if the feds didn't make a decision to see how far this goes, to see if this includes Bev? No. That's a tree that's not even worth barking up. Debbie J, I'm pulling this back up. Ian, how could you not know that Karen is not guilty? Because we weren't.
I wasn't there.
Because we weren't.
Like, I have not seen any evidence that she is, but I can't say for certain, like, to a mathematical certainty. Like, you never can.
Yep. But I've been going for 5 hours and 32 minutes, and all the super chats have been done. We've got trial next week, shortened week next week. We've got trial on Monday, Tuesday, Wednesday, half day Thursday, and then they're off on Friday. So next week, I expect we're going to see a bunch of experts. Some interesting, some not. Shall see where we go from there. Ian is doing recaps. Ian's recaps are phenomenal. Please check them out. Even if you check them out on replay, check them out. Everyone show love to the mods. Sorry, my brain is in the process of actively shutting down. Everyone say love to the mods. Everyone like the stream. If you like the content, please subscribe. Again, 5.5 hours at the end of a full work day.
Oh man, that's the thing people don't always get about the recaps and the reviews. It's like, we work, and then sometimes I'm able to listen to things as we go. Sometimes I got to listen to things at 2 times speed post work.
I can do 3 times on.
And you get your timestamps, and you're just like, okay, let's go. So yeah.
Oh yeah, Emily, good point. It's the cost. I'm thinking $500,000 a month on this trial. It's got to be for all these.
Or more.
More than that. I mean, it is. I'm not just litigating right now. I'm also mentoring, doing offices. It's a lot of fun.
I mean, at the end of the day, this is a trial where there are some big damn heroes. Because even if they're not successful, the whole thing of stepping up in a case like this is huge.
Okay, guys, we're going to call it a wrap. Thank you for being here. Very much appreciated. Check out Ian on Monday. I saw Emily in the chat. Emily's covering the trial during the days. So is Andrea Burkhart. Please find the person you want to communicate with. Please join the chats. Please engage. Please engage respectfully. Support the mods. Support all the people that are out there giving content and contributions to the discussions, because this is a trial that's pretty important. And different lawyers have different perspectives. Sometimes we agree. Sometimes we don't. What I have been surprised with in this trial is how many of us are focused in on very specific things that are happening and how that's happening across multiple streams. And these are streams that are happening at the same time. So I've gone back and played replay of Emily, Andrea, Peter, and Ian, and they're all focused on these things. Usually it's very difficult to get lawyers to agree. You put two lawyers in the same room and you'll get 5 opinions. But in this case, you're finding a whole lot of consensus, and the consensus happens to be that there's frustration.
Well,
So,
and
guys,
it's also been fun to watch, kind of especially Peter, because Peter very much, lawyer, very much gives, a lot of grace. And he was very reluctant to sort of think that Judge Cannone could be doing anything wrong. And this is not a criticism. I know there's people who are going to be like, "Oh, why?" And it's like, no, this is praise. But like, there reached a point where he's just like, "What the fuck?"
Yeah, I was going to say, did he lose it today? Did he lose it today? Because I imagine.
He lost it like 3 weeks ago. And like, he just got to the point where he was like, "This is indefensible. Like, I've been trying to fight," and watching that sort of transition there, I'm like, "Yep."
It's pretty bad. Yeah, we're trying to play it even across both sides, and we're like, I can't both sides this. It's kind of frustrating.
Yeah.
And yes, as Layered Visions reminds you, please pull a Yuri Buchanan and acknowledge the stream by hitting that thumbs up button. All right, guys. Cheers to both of you, or all of you. Have a lovely weekend. Get outside, go make something, go do something, make yourself feel better, make yourself happy, and I will catch you on the next go around. Night, guys.